My lord, with lordship.
Yes, hand over all the slips.
My lord, only one thing, lordship, kindly allow me to say something, lord. This is on disconnection of electricity on
Hand
20.
over the slip.
Lordship,
Hand over all the slips.
there is one urgent matter.
And just to mention one matter.
They are installing the
Your lordship,
I've granted you leave, you are mentioning still.
No, it is unlisted, your lordship.
No, unlisted, no leave.
Lordship,
File it in due.
Lordship, I am praying for leave to file this writ petition
File it in due course and then mention.
urgent, my lord, very urgent. This disconnection matter.
My lord, under
Lordship,
my lord, under
No leave.
my lord, under
Sorry.
compelling
kindly
circumstances,
consider
my lord,
very urgent matter.
File it in due course.
Obliged, obliged.
Obliged.
Sorry.
You know the minimum of procedure. File it in due course and then mention. Why do you require leave? Why are you continuing after I said no?
my lord, under compelling circumstances.
Yes, I said yes.
My lord,
If it's upgradation, please mention. Write
not
it there.
upgradation, my lord, the affidavit in opposition's time is
Don't
expiring
waste time.
today, my lord. But if
Call
you
on
can
the
be
list,
mentioned,
please.
be mentioned.
Contempt application, Port Blair matter, item 1.
Yes.
My lord,
Please,
in the Port Blair matter, my lord, I appear for the respondents, my lord. The
Respond.
appeal, my lord, is listed on 18th.
কি বলছো বুঝতে পারছি না আগে বলো না কেন কি ভুল করেছে বলো সেটা কি হবে অ্যাকচুয়ালি 11 কি করে বলতে যাই the numbers are wrongly appearing read petition numbers
My lord,
that's why it's appearing probably yes who is for the petitioner
my lord, the order under contempt has been challenged before the division bench, my lord. The appeal is listed on 18th October, my lord. This is the order passed, my lord, in the appeal, my lord. It's pending hearing, my lord.
Learned counsel for the alleged contemnor submits that an appeal against the parent order is now pending and is scheduled to be taken up soon for hearing. Full stop. Accordingly, on the prayer of the alleged contemnor, the matter is adjourned till November 20, 2023, when it will be listed under the same heading. 20th November. Thank you. অনেক একটু ফাস্ট হতে হবে তো পরের ম্যাটারটা রেডি রাখতে হবে আগে থেকে
Daily list, appellate side, to mention item number 1 for filing of written notes of arguments.
পুজোর আগে না একটু ফাস্ট হতে পরের শুধুটা খুলে রেখে দাও তো এটা হয়ে গেলে ওটা দেবে তারপর এই ফাইলটা নেবে ইয়েস প্লিজ হোয়াট ইজ
Your lordships desire that when we file the written notes of argument.
Yes.
Your lordship had indicated to be filed in 3 pages. We have overshot that because we have given indicated in the table opposition and reply points.
minus
Point
10 allotted for each page
Lordship, this is the written note of.
please hand over written notes of arguments filed by learned counsel for the parties be kept on record full stop hearing is concluded judgment is reserved in the
I'm so glad.
Item 2 for release.
My lord, I am for the respondent, my lord.
this is
For the petition of mine.
My lord, this is a group 1 matter.
it is pointed out by
2 and
learned pardon
2 and
Or in
4.
my humble submission, this will be within group 9 matter. my
No,
lord.
my lord,
Because I am
it
for the
cannot
petition.
be. It is adverse
for the
possession of land. My land friend is
Within group 13.
claiming.
It has
you are for the petitioner
I'm for the
Yes.
petition item number 2, my lord. This is
I-
group 9, my lord.
Otherwise, I would have asked for vacating of the order also.
What is the
on
release
ground
short?
that wrongfully it has been treated as group 9.
Mr. Agarwal, let
Our
me-
respondent authority has given me a notice to vacate the land. In default, it will be vacated with the due with the government machineries, and the district magistrate has been directed to take steps. Challenging that, we have come before your lordship.
why is
My
the
lord,
land
it is not a group 9 matter. It is
Why?
a group. Why, my lord? My land friend, government had granted him the lease. Lease has expired by flux of time. Even then, my lord, and after expiry of the period
that's
of
your
lease,
defense
no, that is their case. They say that even after the expiry of lease, they are entitled to continue in possession. My lord, then very well, I shall
That is
take
not
out
what
the
we have challenged. That is not what we have challenged.
My lord, that is what has been challenged. The notice of the government calling upon them to vacate the land has been challenged.
Government has
just
got no
because
right
land
at
is
all
there
right
it's
now.
a land matter
No, my lord, it is a complete land matter. Very well, lordship will not release item number 2. I'm not saying I shall.
learned
I'll
counsel
apply
you
for
are
vacating.
appearing for the
I am appearing for the private respondent.
learned counsel for the private respondent submits that the matter pertains to land dispute full stop such contention is controverted by learned counsel for the petitioners full stop upon a preliminary perusal of the relief sought comma
Not
it,
recorded, I shall satisfy.
it appears that the
It is not a
matter
group 9 matter, my lord. Sorry.
The matter pertains to group 9 of the writ rules, full stop. Accordingly, let the matter be listed under the regular heading.
It was in the list, my lord, may it retain its position, my lord. It was in the list.
It will go back to the list wherever it is.
So it may retain its own position.
I can't say, Mr. Babu. It's very difficult for me to say whether it's written,
Very
it will retain its position.
Very
Can, do I mean, have a control over every matter which is the item number? Do you reasonably expect it? It should go back where it was. I mean, if it does not, then mention it. Call kor tinta.
Item 3.
Appearing on behalf of the petitioner.
Yes.
That this is that my client's instruction is not to proceed with the matter. I would love to argue this matter.
No, no,
It's
no.
very interesting, but anyway.
No, no. In the next
yes.
case. Let counsel for the petitioner submits that the petitioners do not want to proceed with the matter further and files a written instruction in that regard, which is kept on record. Full stop. Accordingly, WPA 21518 of 2023 is dismissed for non-prosecution without any orders to cost. Interim order, if any, stands.
No,
valid.
no. Motion stay.
Next. Thank
Obligement. Last part is not required, motion stay. Interim order.
you. Let me decide whether it is required.
Item 4 for release.
Lord, I am for the petitioner.
Same.
It's my group 1 matter. That is a different. It is, I am claiming back possession of my land, my lord.
Release
It is,
compensation of
yes.
its own
Then this is a land matter.
Land matter. It is the same matter, my lord, where I am claiming possession of land myself.
Same order as item 2.
My lord, no. it
এখানে
is-
শুধু respondent আর petitioner উল্টে.
no,
You
my
are for the
lord, it is
petitioner
not the
here.
Same matter.
for petition.
I am asking for the my land from for government.
Same order. Next.
My lord, it is not the same matter. My lord, I am asking for possession of my land from the government.
Yes.
Because which is not a vested land.
Extension of interim order.
Then, my lord,
Item 5.
may I just make one submission, my lord. Mine is a new motion, as it not.
5 who is appearing?
Sir,
You're appearing?
No, my lord, I was in this matter.
I am led by Mr. Mukherjee.
My lord, item 4, my lord, it is a land matter.
5 who is appearing?
My lord, I appeal for State Bank of India.
Who is for
Lordship,
the-
I appear on behalf
What
of
is
the
your matter?
petition. Lordship, I'm praying for extension of interim order. Lordship was pleased by an order dated 5th of July 23 to stay the operation of 2 lookout circulars.
Difficult to hear before vacation.
My lord, kindly extend the time for
I'll do it for a limited period. The interim order granted earlier is extended till November 30, 2023 or until further order, whichever is earlier. The matter shall be listed on November 17, 2023 for hearing.
Lordship,
time to file opposition be extended. Kindly.
Lordship,
So you have not yet filed your opposition.
Lordship, twice they've sought extensions to file opposition.
My lord, within 1 week after vacation, we shall be filing.
তাহলে এই অর্ডারটা কেটে দাও। Learned counsel appearing for the respondent bank.
State Bank of India.
Respondent bank seeks extension of time to file affidavit in opposition. Full stop. Accordingly, such time is extended till
1 week after vacation. my lord.
till November 24, 2023. Full stop. Time for filing reply is extended till December 1, 2023. 2023. Full stop. The interim order granted earlier is extended till January 31, 2023 or until further order, whichever is earlier. Full stop. The matter shall be listed for hearing on December 4, 2023. Please remind me if they pray for time again, then I'll refuse that. Yes. Yes. Call on.
Top item, item 6.
Yes, Mr. Sharko, what is the matter?
My lord, I appear for the petitioner. My lord, this is an adoption matter.
Hmm.
My lord, where
I am
lordship,
appealing for the Union of India.
You know, right. Yes.
my lord, where lordship had granted an interim order. This is in respect of a hard to place child, my lord, which stands on a different footing. The petitioners had applied under the Carings portal, which is the portal through which adoption process is carried out. They have to be within the age of 110 years in order to apply. They were within the age of 110 years. Subsequently, lordship, they waited. There was no progress. Then, under this hard to place category, they can opt to adopt one such hard to place child. They opted for 2 sisters, 2 siblings, both of whom came to live with them. Subsequently, lordship, there were the elder sister did not want to live with the younger sister. So therefore, a dispute case was raised, my lord, where a counseling process is to be carried out, etc. Now, for this entire process to go on, there has to be an HSR, a home study report. In the meantime, lordship, this
All this is under the Juvenile Justice Act.
lordship,
All
under
these
there are these
categories are-
regulations, lordship.
Yes.
Now, in the meantime, lordship, when this counseling process was on, in the meantime, the HSR expired. Now, after the HSR expired, what happened, lordship? It so happened that after counseling, it was decided that the petitioners would take the younger sibling. They wanted the younger sibling wanted to be adopted by the petitioners, and therefore it was told that the adoption would go through. The documents have all been annexed.
What is the age of the children?
Malad, that is about 10, 11, 8 and 12 years, Lordship.
Right.
Now it's 10.
Yes.
Now thereafter what happened, Lordship? Because the HSR had expired, it had to be revalidated within a period of 3 years by the respondent number 4. The respondent number 4 made a recommendation that it should not be revalidated because of XYZ reasons, which is the parents were not caring, they did not go for counseling. Now, Lordship, that appeared to be a miscommunication because there are two adoption agencies involved here. One is the agency of West Bengal, and these kids are from Odisha, the agency of Odisha. Because there was no coordination between them.
How was respondent number 4 involved? You applied through them?
Lordship.
Yes. You applied through them?
Lordship.
Right.
Now, subsequently, what has happened is the respondent number 4 has said, they filed their affidavits. The only issue now is age. Because in the meantime, the cumulative age, according to the respondent number 4, has crossed 110.
110 is the outer limit.
That is the cumulative age, Lordship.
Cumulative, yes. Right.
Now, Lordship.
When did it expire? I mean, how long back?
This in the month of February.
Right.
Now, our case, Lordship, is that when they applied for the revalidation of the HSR, they were within the cumulative age limit. In any case, Lordship will find from the regulations which I will place that the relevance of the cumulative age limit is insofar as the entering into the registration process is concerned. Once they enter into the registration process and thereafter they seek revalidation at
from the rules.
Lordship. There's a copy for the court. I open the regulations.
The shell of the nut has to be very short.
Lordship. Please take her.
Thank you so much. Thank you so much.
The relevant portions are also marked.
Thank you very much. You are now with them, or
Point number 4, my
you are now supporting their stand, or still?
different, Lordship.
Very well. I'll come to it. Yes.
My Lord will kindly come to Regulation 5, eligibility criteria for prospective adoptive parents. Lordship will find sub-regulation 4, clause 4 of these regulations.
Yes.
The age of prospective adoptive parents as on the date of registration shall be counted for deciding the eligibility of prospective adoptive parents for children of different age groups as under. Now, Lordship, here, since we were with 2 children, 8 and 12, above 8 and up to 18 years, 110 is the cumulative limit.
Right.
Provided that the minimum age difference between the child and either of the prospective shall not be less than 25 years, no doubt about that, Lordship. Now, Lordship kindly comes to 7. Couples with 2 or more children shall only be considered for special needs children as specified in clause 25 of regulation 2 and hard to place children as stated in clause 13 of regulation 2 unless they
qualify for these.
Like qualify. Now, Lordship, what has happened is the short question is on the date they applied for the revalidation of the HSR, the cumulative age was 110 years, 4 months.
When I
applied for the revalidation of the HSR, this rejection took place several months later.
On the date of registration, you were within time.
Within the age limit.
Apparently, 4 says date of registration.
Date of registration. My simple submission, Lordship, is first of all, a technicality should not come in the way of a substantive or a beneficial legislation such as these regulations, because that is there in the regulations that it is. These regulations have to constitute.
Is it coming in the way at all? I mean, force.
It is according to my Lord, in my humble submission, it is not.
What can be the counter argument?
The counter argument is the moment 110 is crossed, it goes into 110 2 months.
The date of registration as per 4.
Yes, but then that is also being sought to be applied for revalidation of HSR. Okay. Now, our argument is that if Lordship goes by the only relevant legislation we could find to use as a yardstick is the Majorities Act. The Majority Act, which says that when will you be considered a major, or when will you, for instance, I'll give an example.
Children are not yet major.
No, Lordship, that is only for purpose of calculating age. The calculation of age will take place, the day of birth will be counted, and on that anniversary, you will reach the age of 18. If I follow the same computation here, unless they reach 111, they are within this limit of 110. That is the short argument, Lordship. Now, as far as I can understand, and from the submissions or the affidavit filed by the respondent number 4, my lord, if Lordship holds that this will not stand in the way for revalidation of HSR, my lord, the matter may be solved. Because the child is there, the child wants to be with the petitioners also want the child, but it's only this technical confusion which is coming in the way. It only requires, my lord, some purposive interpretation from my lord that this will not come in the way.
Well,
that's all.
What is the stand? Your stand is the most important, probably.
Yes.
Your respondent of 4. Yes. What is that? Do you have another copy of this?
Yes, my lord, I have a copy.
Yes.
But my learned friend has a copy of the.
Even if he does not have a copy, it's his problem. Yes.
Lordship,
How do you deviate from 5-4? Start
Yes,
with
my
that.
lord.
Yes.
My lord, may I be permitted to explain the process very briefly, my lord?
Yes.
I have also had the occasion to read this entire regulation and appreciate what actually goes through, my lord.
Appreciate
Now,
that.
the
yes.
respondent number 4 is a specialized adoption agency.
Right.
My lord, these agencies are established in every state across India,
Yes.
and they are supervised by the SARA and the CARA, my lord, respondent numbers 2 and 3, my lord, the state and the central adoption regulation bodies, my
Right,
lord.
right.
All of these bodies, my lord, are regulated by the adoption regulation of 2022, which is the latest, my lord. It has undergone an amendment after 17. So, my lord, I have the latest copy with you.
Yes.
My lord, in regulation 5, as my learned friend had just indicated, the eligibility criteria of the prospective adoptive parents, my lord. They call it PAPs, prospective adoptive parents. My lord, very briefly, the process is first a couple or a single parent will first have to go through the eligibility criteria. And my lord, at sub-regulation 4, the age bracket is given as to the composite age and the maximum age of a single prospective adoptive parents. If lordship comes at regulation 5,
So
sub-regulation
single
4.
and
Yes. So at any point, if I'm a composite age of one of the first one, 85 years, if the couple together is 85 years, I will be eligible to adopt a child up to 2 years.
Right.
The moment I cross 85 years, my lord, the composite age, my eligibility will become 2 to 4 years. In the same way, the moment I cross 110 years, I will no longer be eligible to adopt a child at all. This is the scheme of the regulation. Yes, my lord.
Because
The
110 is
composite.
cumulative.
My lord, I'm not getting into the single parent because that is not relevant for
No.
this case, just for the composite age. Now, my lord, the process is after this eligibility criteria is set up, they send a social worker to the house of the prospective adoptive parents.
This house report.
Yes, my lord. That is called a home study report. In the home study report, my lord, the home study report is under regulation 10. I shall briefly tell what is the process. In the home study report, my lord, the social worker, which is usually designated through this SAA, that is the Specialized Adoption Agency. So the parents, they register through the portal Carings,
Yes.
and then the specialized agency, they send a home study, the social worker for the home study report.
Right.
They conduct this home study report to see whether the house is fit for adopting a child. And this home study report is then submitted and then uploaded in the portal, which becomes the basis for adoption. So it is only when I have a valid home study report will I be entitled to approach any other agency for adopting a child. Now, my lord, the process is, the regulation says that the home study report will be valid for a period of 3 years. In this 3 years, my lord, if regulation 11 is followed, it states the entire process is set down in regulation 11. Which says that once an HSR is valid, it is validated, it is uploaded on the portal, my registration is done as a prospective adoptive parents, everything is considered, then the agency is going to start referring adoption or rather children to these parents. Now, my lord, there are several parents in these categories. So the seniority is also decided as on the date of registration. If there are 10 couples who have registered on the portal, so they will start referring children. Now, once the referrals begin, this all happens within the span of 3 years. If the referrals begin, then there is a counseling session whether the children can adopt with the parents, whether the parents and vice versa, and whether there is any There's a pre-adoption foster care facility also under the guidelines whether to see whether the parties are all in peace. And if it does not work out, my lord, there is an option that the children may be returned. Then there is a disruption procedure which is also followed. Everything is in the guideline, lordship. After that, my lord, in some cases it is seen that within this period of 3 years, referrals are not being made because there is a paucity of children, or my lord, because the parents and the child cannot adjust. So sometimes within 3 years, when the parents do not get it, this HSR has to be revalidated. So after 3 years, my lord, or prior to the expiry of this period, it is the duty of the specialized adoption agency, the SA, in the event there is no referral, to revalidate this HSR to see that the parents continue to be eligible and suitable for adoption. This is the scheme of the regulation, because this period of 3 years will continue.
For revalidation, after 3 years, they have to apply, or PAP has to apply, or the. So
My lord, it is a two-way thing, my lord, because if there is no referral from my agency, then I have to ensure.
Liability only on the PAP, or you.
No, my lord, it is a both way, my lord, because the regulation says if lordship sees regulation 5 at sub-regulation 8, prospective adoptive parents have to revalidate. It is their job, my lord. At the same time, if lordship comes to regulation 30 at internal page 18, lordship of
Just tell me what is there. Yes.
It says that I also, as an agency, it is my
Of course,
job
have to
also.
revalidate.
Yes, my lord, the condition precedent is that there is no referral. If there is a referral, if there is a child, my lord, therefore it is common sense that we do not have to revalidate because the child has already been received.
Right.
Of course, there are other circumstances when there is, my lord, the child does not adjust, which is what has happened in this case.
In
Lord.
their case, the children were in their foster care.
My lord, I shall now tell what happened factually, what are the instructions that I have received. My lord, I have annexed it in my application as well. When they had designated through the portal carings and they had approached my agency, my lord, we had validated their HSR. The home study report was conducted, although the social worker was not appointed by me. It had come, it was outsourced through
It is there
CARA.
within the province.
Yes, my lord, it is there. The CARA can also directly validate, send a social worker, my lord. Anyway, we had conducted the HSR, and after the HSR was conducted, my lord, they received an adoption from respondent number 6, my lord, I believe, which is the SAA of Odisha. So, my lord, Odisha, the specialized agency, sent us an email saying that you please send over the original home study reports because we have a child in adoption which is matched with this family, my lord. My lord, whether the child was hard to place child or not is not within my knowledge because there is nothing, at least in my records, to show that. So, my lord, we sent over the HSR. Now, this home study report was first conducted, my lord. Very few dates are important. 21st of October 2019. After that, my lord, we received an intimation that you please send over the home study report because there is a matching of the two siblings from Odisha, and this family has been matched with them. My lord, we sent over the home study report, and thereafter, my lord, we have received no information because, my lord, regulation 11, which, my lord, I was just indicating, that is the referral of a child of a specialized adoption agency, my lord. The entire process, how the child will be referred and the pre-foster agency, the adoption care and everything and the counseling, that was carried out by respondent number 6 because the child was from Odisha. Therefore, my lord, the specialized agency of the place of origin of the child took up this entire responsibility and we were not informed, and my lord, we did not have to look into it because we were told that the referral has been made. They had received children.
You are probably relying mostly on 11-16.
Yes, my lord, absolutely. Absolutely.
Absolutely.
Yes, my lord, 11-16. So, my lord, what happened? We were not aware of it. Now, my lord, come straight to July 2022. When we suddenly come to know that the petitioners are on their way back to Odisha to return the children on a train. This was informed to us through the social worker, my lord, who had visited for the HSR at the time of October 2019. So, my lord, she has annexed a report, which is a part of my affidavit, saying that disclosing this entire fact that the parents are now on their way back to Odisha to return the children.
Is her communication, does they have the locus standi to communicate and you to accept that?
My lord,
to act on that? I don't think
my lord, I have not acted on it,
Our
my lord.
limited charter is to hold the...
Yes, my lord, I have not acted on it, my lord. It is my duty to inform your lordship what has transpired. I have not acted on that. It is a part of the affidavit. What has happened is, my lord, they went back to Odisha to return the child. What has the difficulty that has arisen over here is we had to initiate, my lord, at rule 5 of regulation 12, regulation 14, my lord. Rule 5 of regulation 14, procedure of disruption. This is what we had to initiate if we were informed within time that the parents and the children were not adjusting with each other. This is what we could not initiate, Lordship, because we had not received any follow-up. There were, whether any counseling session was done by respondent number 6, whether there was at all any difficulty that the children could not adjust with the parents, as has been alleged. The older child could not adjust, my lord.
How
That
did
is-
you have information regarding
My lord,
this?
we did not. We only,
Social worker informed and you acted?
my lord, we did not act, my lord. We could not, my lord. That is the difficulty. We could not proceed with the procedure of disruption because we had no information.
Okay.
Thereafter, Lordship, therefore, my lord, we were completely in the dark. Now, my lord, during the course of all this, my lord, we had been informing Kara that we had nothing to do except being a silent spectator, my lord, because we were not in the loop at all. Thereafter, my lord, on 21st October 2022, the period of 3 years expired for the prospective adoptive parents.
23rd October.
21st October, my lord, because 21st October 2019, 21st October 2022, it expired. Now, as on the date of registration, which was in 2019, my lord, they were within the composite age, which is a fact. Now, it expired on 21st October 2022. In the meanwhile, we have come to learn that all of this has happened, that they went to return the children. They applied for revalidation on 29th of November 2022. Now, my lord, what I will try to impress upon your lordship is, in this case, it is not a question of revalidating the HSR. Here, my lord, the HSR has expired entirely. Here, this is the process where I have to ascertain afresh whether the prospective adoptive parents are eligible for the HSR. Under if it had they informed us of the procedure of disruption, or that there was no suitability between the adoptive parents and the children, my lord, I would have taken steps to revalidate it prior to the date of expiry. There was no such information given to me. It is only on 29 November 2011 they come to me, and my lord, I would not like to say this in a way that I'm prejudging the petitioners here, but my lord, they had even applied for adoption of a different child through another agency in the meanwhile, without having
They
an
must be
HSR.
frantic when they want children.
Yes,
who
my
wants to
lord.
adopt, they become frantic.
My lord, I appreciate that, my lord.
Justified. That
My
does
lord,
not go against-
absolutely, lordship. And because of these reasons, my lord, we did not hesitate to try and revalidate their HSR once again. And therefore, we send them emails also that you please provide your documents. We will try and revalidate it because, my lord, your lordship is absolutely correct.
Right.
We do not want to come into the way of an adoption of a child.
They generally don't.
Yes, my lord. Now, my lord, the difficulty is when this revalidation is now happening on and from 29th of November, this is a fresh HSR that has to be conducted for these prospective adoptive parents. And I am now stuck, my lord, at regulation 5, sub-regulation 9. My lord, the seniority of the prospective adoptive parents who have not received a single referral within 3 years shall be counted from their date of registration, except those who have crossed composite years of 110 years. My lord, this is the first clause, my lord. The seniority cannot be computed. The seniority will remain as long as the composite age is there. So, my lord, if I am the first couple to have applied, registered, my lord, and my learned friend is the second couple to have registered, my seniority will retain till I reach an age of 110. If I cross that age, my lord, my learned friend will become the next couple to receive a child. Now, lordship kindly comes to sub-regulation 16 of regulation
Here
11.
they had received a single referral.
Yes, my lord. They had received 2 children already. The referral system was already carried out. Now, my lord, kindly comes to sub-regulation 16 of regulation 11. The registration of prospective adoptive parents shall continue till the time they have not exceeded the maximum composite age, that is 55 years for single and 110 years for couple, as provided in sub-regulation 4, subject to revalidation of the HSR in every 3 years, lordship. So, my lord, the concept of revalidation of HSR every 3 years prior to the expiry is to ensure that the couple is still eligible. Now, my lord, kindly also comes to regulation 30, my lord, at page 20, lordship. Sub-regulation 3, sub-regulation M. Complete, my lord, is my lord with me?
M.
My lord, page 20, yes, my lord. Your lordship will see it's 3 and then M.
Right.
Complete revalidation of the home study of the prospective adoptive parents. This is, my lord, this is the function towards the PAPs, my lord, my function. I am to complete revalidation of home study of PAPs prior to expiration of their validity period, and in the event they are not found eligible or suitable to adopt, all such HSR shall be referred to District Child Protection Unit. I have done so, Lordship. I have intimated this to Kara that my only difficulty is the age bar. Now, my lord, under the regulation also my lord, this is also, it is my duty to inform this to your lordship. There is a regulation 62 at page 35, where, my lord, the petitioners, they have an option to appeal before the state adoption as well as the central adoption agency. My lord, I'm not sure, my lord, I'm not aware if they have availed of this remedy, but in any event, lordship, now we are before your lordships, and this is the crux of the case, lordship, where I, as respondent number 4, my lord, my hands are tied under the regulation. And my lord, this opinion was only sent over to the Kara, that it is due to the age bar, and I do not have the discretion, my lord. I have no discretion under the regulation. I have to strictly follow. If this age bar can be relaxed, my lord, there is nothing in, my lord, in fact, there is a rule 63, my lord, there is a power to relax an interpretation. My lord, there is an authority, relaxation committee of authority, my lord, who may have the power to relax. So, my lord, the regulations are pretty exhaustive. So, in that event, lordship,
Very well.
yes, my lord.
Yes, union has to say something. Reply, Mr. Sarkar.
My lord, first
Deal
is
with 1116 first. You did not apply in time for revalidation. That is one of your problems.
now, my lord, what has happened here is essentially complete lack of coordination between the state, the SAA of Odisha and the SAA of West Bengal.
Satisfy me on the law.
Lordship.
Whether we can do it or not.
Lordship. Referral of a child from specialized adoption agency through the designated portal to prospective adoptive parents.
1116.
Lordship. The registration of prospective adoptive parents shall continue till the time they have not exceeded the maximum composite age as provided in sub-regulation 4 of regulation 5 and subject to revalidation of the home study report in every 3 years.
The validity expired on 21st of October 22. You applied on 29th of November 22.
My 17th November is the correct date, my lord, but
very well.
it's pleaded in the writ petition.
I mean,
My lord,
so once it expired, once it lapsed,
lordship.
Revived.
Lordship. Now, my lord, this assumes following of certain timelines by the concerned authorities, the statutory authorities, which have not been adhered. For instance,
it be done. I mean, can it be said that
lordship,
if you apply later for revalidation, if it is pending before then the revalidation, which is in your present case probably,
lordship,
then we can consider that leniently probably. I mean, we
Lordship.
can, we
lordship,
should.
lordship.
But whether we can do it, suppose if it is revalidated later, I mean, as of today, it has not been revalidated, you have applied late. So you have lost time in between.
Lordship.
So if it's
Now,
subject to that, your seniority also goes.
lordship. Now, lordship, what has happened, lordship kindly sees in this respect, my lord, page 43 of the writ petition. All this, lordship, is in respect of a referral. The first thing here is, lordship will find in the regulations no provision in respect of hard to place children. In this case, lordship, there was no referral because the referral provision does not apply at all. Here, we have to make a choice in case of hard to place children, lordship. We have to select, which we have done. So therefore, all these provisions which apply in case of a referral in usual course through the portal does not apply because we have applied under what is known as the immediate placement module. That is
come to 211,
lordship,
213
lordship.
of the regulation. This applies.
Hard to place child refers to a child who has not been placed in adoption after going through the procedure as mentioned below. So there,
in your case, this applies.
This applies, lordship.
Show me that these are exempt, hard to place children are exempt from this provision.
Now, my lord, there is absolutely no provision in the regulations for this immediate placement procedure. that happens only through the carings portal. My lord, we've prepared a list of dates and we pleaded it in the writ petition.
Suppose
because-
regulation 5, it applies to eligibility criteria for prospective adoptive parents,
Lordship,
which applies to every
Lordship, it
person,
will apply to me as well,
and to hard-placed children as well.
to hard to place children as well. But my only difficulty, Lordship, is that those timelines are in case of referrals, but not under immediate placement. My lord, in referrals, what happens is the PAPs get a child referred to them. Here it's just the opposite. Here I make a choice because no one else is going or choosing to adopt those children because they're hard to place. Now, my lord, once I've exercised that choice, as far as the HSR is concerned, Lordship, that would also have happened in usual course had a disruption case not been started. Now, my lord, what has happened in case of a disruption case, everything, the usual timelines go haywire because under the regulations, we are mandated to return the children, which we had to, because that is what my learned friend placed those regulations, Lordship will see, we have to return the children. So we return the children because the elder sibling did not want to stay with the younger sibling. We got in touch with the Orissa authorities, the respondent number 6. They did not communicate anything with the respondent number 4. Counseling took place without the knowledge of respondent number 4, which we don't know that no information is being given. We are under the impression, Lordship, that the procedure is being carried forward in accordance with law. Now, Lordship will see as late as March 18, 2023. I'll just place page 43 of the writ petition, my lord. That I'll explain why this has happened. Now, my lord sees this is from CARA. This is the apex authority. They are saying that it is informed that the child Annapurna Satpati, this is the younger sibling who wants to be adopted, has been matched with the adoptive parents, Mr. Palash Sarkar. Now, my lord, after this, it so happens that they discover that in the meantime, they had gone ahead with this entire procedure without the HSR being revalidated in time. When I was asked to apply for the revalidation by respondent number 6 before the respondent number 4, we did apply on the 17th November. But the respondent number 4 was not informed. Perhaps had the respondent number 4 been informed of the timelines, that is the expiry on 20th October, maybe they would have taken steps. I am not attributing any mala fide on their part. But my lord, because of this miscommunication and because of the delay which has occurred, my lord, how can the petitioners be made to suffer? Not just the petitioners, the child as well. Because there is no doubt in this case that the child wants to be with the petitioners. Petitioners want the child. My lord, in this
Mr.
case,
Shah, I'll close arguments on this.
Lord,
I'll not direct any affidavits.
My
I'll
lord-
take the weekend and 1 or 2 more days. Yes.
Well, only one request, Lordship. My learned friend is saying that there is no doubt that the child wants to go back to the parents. My lord, I believe what my learned friend is saying. But just for abundant caution, Lordship, there is nothing on record that there is any counseling report or anything at the latest stage where it can be shown that the child has indeed expressed its opinion to stay with the parents.
You
My
have
lord.
given a disruption report as of today.
My lord, I have not given any disruption report. The procedure is in process, and the HSR, my lord, this is where we got stuck, the revalidation of HSR. We could not proceed with the HSR at all because of the age bar. So, my lord, in the event, Lordship feels that
So
all of this.
ultimately, it boils down to the age bar,
Yes, my
which you
lord.
are not being able to revalidate.
Yes, my lord. So, in the event, Lordship relaxes that age bar, my lord,
If
later.
the age bar is relaxed, then you can go on. Go ahead
Yes,
with
my
the-
lord. And let a counseling letter direction be passed upon respondent number 6 that the counseling be held. That the children and the parents, they want to stay, that the younger child, my lord. Because there is nothing on record even before me. They are submitting that the
that
child
has
wants
be
to stay.
subject to the compliance with these regulations.
Very well, Lordship.
Otherwise, how can they?
my lord,
Yes, my lord.
my lord, the only last provision I'll place, Lordship, before Lordship closes is regulation 35. My lord, that is 35 State Adoption Resource Agency, 35 clause 2, subclause P, Lordship.
Yes.
The structure of the State Adoption Resource Agency shall be as under: State Adoption Resource Agencies shall function as executive arm, etc. And it includes make additional efforts with the waiting parents within the state to arrange adoption of children in the category of special needs, older children, and hard to place children. This is the only exception, Lordship, which we can find. And as far as the age bar is concerned, Lordship, the only submission is we were still within the limit of 110 because we had not crossed over 211. As on the date, we applied for the revalidation. This revalidation was rejected in June 2023. Several months later, in the interregnum, I crossed over. So that cannot.
That has to be interpreted in the manner you are suggesting, that
Lordship.
it goes on till 111 is reached,
Lordship.
then the entire timeline will also change, the other edges.
My
Lordship.
lord, in my humble
Same
submission,
interpretation has to apply to all.
Lordship, in case of that also, it will continue till I reach that 110, which means it will continue till I reach 111. That is my interpretation, Lordship, because otherwise it would be an absurd interpretation. The day they reach 110 and thereafter they get barred, it's nowhere there in the regulations. This registration will continue till
Language is maximum composite age. When a maximum age is stated and
Lordship.
you cross that age, 110 cumulatively you cross, you cannot have one day more. How can you?
Lordship, my humble submission is
It is
maximum.
not the other way around. It's not when you reach 109 or 111 or something like that.
My lord, for instance, with reference to that Majority Act which I was referring to earlier,
Yes,
my
you're
lord,
right.
if it says that, for instance, to the maximum age to get admission into a BLLB course is 23 years, my lord, that continues till I turn 24. Till the day I turn 24, the anniversary, my 24th anniversary, I am still 23. Therefore, this bar of regulation 1116, Lordship, which Lordship referred to.
So 110 implies 110 plus.
It means, Lordship, till
In our usual sense, 110
because
plus.
under the Majority Act, which is the only law I can find on the subject, they continue to remain 110 till they reach the 111th anniversary, which came much later. That came in February 2023, not before that.
Lord, this would be stretching the interpretation. But
My lord,
anyway,
that is
would
because
be
that
your
would be
lordship.
my lord, that would be the only reasonable interpretation. And my lord, considering the situation here, where all the parties want the matter to be resolved, my lord, maybe give a short note within a couple of days, my lord.
Do that.
Day after tomorrow.
I cannot work on this before the weekend. So do that before the weekend.
Grateful.
I'll keep it as to be mentioned day after tomorrow.
I just two judgments, Lordship. My learned colleagues are, but it's on the Majority Act, my lord. May I give a copy to my learned
I
friend?
have
and
not
just put
referred to those while arguing, Mr. Shah.
Lordship, then I will not
reply to.
I will not. I will not.
So file your written notes day after tomorrow, just half page, 1 page written notes.
Lordship.
You can file or you may not file also. I'm putting it as to be mentioned there.
Well, it's only just so that considering the situation here, I'm just asking for that.
Very well. Learned counsel for hard learned counsel for the parties. Full stop. Hearing is concluded. Full stop. In view of the legal nature of the submissions made by the parties, comma, affidavits are not directed in the matter. Full stop. It is deemed that none of the allegations made in the writ petition are admitted by any of the respondents. Full stop. For the purpose of filing of written notes of arguments as sought by the parties, comma, the matter shall be listed on October 12, 2023 at the top of the list for the limited purpose of filing of written notes of arguments.
Well, in this case, my lord, affidavits have been exchanged.
Oh, sorry. Affidavit in view of the legal questions being sentence. Sorry.
Grateful, my lord.
Grateful. I'll keep your copy of the regulations for the
Yes,
time.
my lord, that is for your
Don't have a
lordship.
copy of this.
Yes.
Eta hoye gele mone korো na কিছু.
Grateful.
Thank you.
7.
Here I will.
Yes,
I,
Mr.
I will. At place mostly I will just remind my lord.
Yes.
Here the show cause notice is of 30th September 2022, page 45.
Yes.
For page 45, for on the basis of non-completion of work, Lordship will find Roman 4 at the bottom of page 45.
Yes.
Non-completion of work by 21st February 2023.
Right.
Last 3 lines, revised target date of completion, 21st February 2023. Before this was also in semi-violation. Of course, we didn't file contempt petition of an order passed on page 42. Not really an order, it was the submission recorded when we moved the writ petition, threatened termination, that last sentence, counsel assures that no steps shall be taken by the respondents in the meantime. They wanted adjournment. So in spite of that, they gave this notice. Now, what happens thereafter is subsequently my submission is this notice has been superseded by 2 events. One is 22nd December 22, page 43, is the order of the writ court. I don't think he will contradict me if I say more or less by consent, because he also said, let them complete the work. So this was the order at page 44, last paragraph. Second paragraph and last paragraph, that we shall complete the work as
I
expeditiously
will
as
place this order fully.
Very well, then let me place
I will-
44.
I will rely on this order.
Yes,
I will place it.
because we both got this order more or less by consent, as I said. Lordship kindly sees page 43 then. However, after hearing learned counsel and considering the assurance given in a letter of 13 July 2022 by the CPWD that the defect liability period will run from taking over all the respective buildings and of the exemption provided under Section 3 of the Government Buildings Act to certain government buildings from municipal laws, this court is of the view that the petitioners should be directed to complete the remaining part of the project. The admitted position is that the petitioners have completed about 70% of the project. Only 30% remains to be completed. The apparent financial distress of the petitioners may be addressed by direction on CPWD to process the bill of rupees 5 crores, which has recently been submitted by the petitioners. It is made clear that the petitioners have also to urgently look into the charge of non-payment to the vendors and other parties' assistance in the work project. WPA is disposed of. The petitioner shall make every effort to complete the remaining part of the work within a reasonable time without any further delay. The letter of CPWD of 25th August regarding the delay on the part of the petitioners to complete the work and asking the petitioners to submit the pending bills is kept on record. Any impediment in the completion of the work shall be looked into and resolved by CPWD. The petitioners shall cooperate with CPWD on the matter of completing the balance part of the work. So this, my first submission, this supersedes the notice because the timeline of January 23 is gone. But there's something even better, because after this, my lord, they thereafter give a new work program. That's not annexed here, but that's referred to at page 67. That is in the last page 66. It starts. That is the last extension given on 21st of August. Last annexure, 66.
Yes.
Last para at page 66.
Date of completion is extended till 29th of July. Page 67.
67, Lordship, the first sentence of page 67 at the top. Therefore, why this letter dated 11 January 23, this office has made a reasonable completion program of the work, and completion date provided 29 July. I'm on this. The earlier show cause was for non-completion till January 2023. So this is the second subsequent event, which really renders my the earlier show cause infructuous. And the other is that there's a fresh show cause notice given, page 60, under clause 14, page 60, on 17th April 23. For again overlooking the new timeline, but whatever may it be, for taking out some parts of the work. This is under clause 14 of the contract. Clause 14, we are carrying a copy of the agreement. We had craved leave. Lordship, may I hand up a copy of the agreement? Clause 14 is for taking out from the scope of the work a part of the work. In fact, they have done it thereafter. 11th May, they took out a part of the work, and we have filed a separate petition which has not been heard because there is also no urgency as such. So this is the action taken thereafter. And now, my lord, suddenly we face.
You are challenging page 63.
Page 63. This is basis the show cause of 2009 that your lordship will be that your lordship will find from page. Where is it refer? Where is it refer to the show cause of 2009? 22. I'll just give you.
Show cause টা আছে যেটা
Para 8. Page 64, para 8. Yes. I remember I marked it, I forgot. Whereas a show cause notice was issued to you, Kamaladitya, dated 30th September 22 to show cause within 15 days of the issue of notice as to why disciplinary action. So this was this is the order. And it's a very serious consequence. This is given on 28th of August. And when I have got time to complete the work till, as per the last extension, till November 2023. Lordship, page 67, second paragraph, 29 November. This was entirely on the basis of an earlier fact scenario, which is completely regulation. And this is under regulation 13.6, sorry, rule 13.6, which contemplates a little more. Yes, well, this is for my lord. Disciplinary action under clause 13.
Same.
I'll give then
Previous
then
page.
let me use
Previous
it. Let me use it for my. Yes, the 13 point. Well, not that. That is there's another rule. This is a
Foreclosure of contract duty about.
That is standard thing. I mean, standard
This is a
terms
standard.
and conditions.
Yes, standard.
General conditions
is-
of contract. No, okay, করেছে the rules are under.
This is the rule 13.2.
No, this is a different rule, Mel.
Yes, that's what this is what is attracted here in this case. I want to show about 13.1. The contractor shall abide by all the rules of enlistment. Now, third line, where the contractor has made himself liable for disciplinary action, enlisting authority shall have the right to debar the defaulting contractor from participating in tender process for a period not exceeding 2 years, based on the recommendations of the empowered committee. Now, clause 13.2, it contemplates a proper inquiry. The enlisting authority shall initiate disciplinary case against an enlisted contractor, either suo motu or on receipt of a written request from an officer not below the rank of executive engineer, and forward it to the empowered committee for consideration. The empowered committee shall consider the disciplinary case on the basis of documents, facts, and circumstances, shall issue a show cause notice to the contractor, allow him personal hearing if necessary, and forward its recommendation to the enlisting authority. The enlisting authority shall take a decision on the basis of recommendations of the empowered committee.
Apparently, this follows the blacklisting as per this. 13.1, when you make yourself liable for blacklisting in their perception, they can blacklist you and then initiate the procedure.
And the grounds are there, 13.6.
So here they are blacklisted before the disciplinary case having been initiated.
No, disciplinary case is what they are calling the show cause is the disciplinary case initiation. And the grounds are 13A, 13.6A and, sorry, yes, A and B, that they've called 1 and 2.
In the contract.
Yes, 13.6, next page, A and B.
Not in the contract.
In the rule, that is for 13. Grounds for debarment, the contractor may be debarred, fails to execute a contract or executes unsatisfactory or violates any conditions of the contract. That is my humble submission. This is not for anything dehors the contract. So contractual timelines are still there very much at large. This is really my submission, and personal hearing also though not given, though there's contemplation of personal hearing mentioned in 13.2. Because I have a.
Hello. Firstly, Melot, termination of a contract and debarment are two separate.
Are we hearing for the purpose of interim orders or final?
I was praying for interim order. If
interim order,
not sure.
No,
No, we are hearing for the purpose of
finally, that is what your lordship, because I had prayed for, I had made a prayer for filing affidavits. Your lordship was contemplating issuing an interim order in that event. That is why I have said,
Yes.
my lord, because any interim order at this point will be post facto, my lord. It is already
Yes,
there.
yes, that was the finding,
Yes. So
observation.
that is why I said I will make arguments on this.
Right, yes.
Because that is what happened on the last time. I suffered a lot due to my judge being.
Don't suffer.
I
You have to suffer by a court order.
exactly, my lord. Exactly, my lord. My lord, kindly come to page 65. This is the last page of the order, my lord. This element has to be made very clear. Termination of an existing contract. My lord, kindly see at the end, my lord. To construction period, last paragraph, years from date of the issue, the debarment would entail the following: ban on participation in tender process, award of contract of etc. The third, my lord. However, running contract shall remain unaffected. So this does not affect the running contract, my lord. Secondly, my lord, kindly see the show cause notice, my lord. It is at page 45, my lord. It starts, my lord. Para 3.
Yes.
My lord, kindly, whereas the subject work is badly delayed and the work has not been executed satisfactorily. This is what has been repeatedly been stressed. The whole case is based on this. And kindly see the next part. And you have also violated the conditions of contract as detailed below. Specific violations of contract had been set out. Well, what are these? As per scope of work given, the buildings are to be planned, designed, and registered to meet 3-star TERI, Teri Graha or LEED Gold Star or IBC Gold Star. Number of letters were written, engineer, etc., etc. Well, this is, I will show from their reply also, and the fact remains this is still not complete as on date, not completed. As per clause 6.1, where architectural consultancy in agreement model of the campus has not been submitted, still not submitted, Mala. As on date, they have admitted in their reply. Technical staff has not been deployed. This is a very big problem and one of the reasons why the whole project was there. Technical staff has not been deployed as per clause 6.1 and details given in schedule F of the agreement. Even after issuance of notices by, well, they don't have a project manager as on date. No deployment of sufficient resources and manpower at sites. Even after repeated reminder, but that this is admitted position has been reflected in this order also, previous order. Part work related to aluminum siding, this work was withdrawn. This work was withdrawn. They have not, and several works have been withdrawn. 50% of their work has been withdrawn. Now, kindly consider original work was for the period 23rd March 2019. 23rd March 2019, to 22nd February 2021. It was to be completed in 2021. This is 23 months. Now, 5 months was for planning. 18 months was for execution. Well, kindly, I will come back to the order, my lord. When they filed the previous writ petition on 27th July 2022, so almost more than 1 year, a few months after the due date. There they say the main reason, and in fact it was the only reason, only substantial reason, that land documents were not supplied to them. On one hand, they said land documents were not supplied to them. That is why they could not complete the project. On the other hand, they claim 70% work has been completed. The court acknowledged this and said, and under the Government Buildings Act, no sanction from the municipal authority is required. That has been noted in the order. That was made the crux of even today, my lord. That is the crux of all problems. Nobody is asking them. My lord, Mr. Mitra on the last day made an oral submission. I could not find. I was trying to search that submission in the writ petition. I could not find it, my lord. They said that they were stopped by the municipality. Never has happened. It has never happened. After they filed writ petition, one letter was written to us, CPWD. We have given them the reply and they have not taken any action. So they were never stopped from doing the work because of land document. And land document is the crux of everything, man. You have not given, kindly see the, now the show cause, reply to their show cause. I have very specific points have been given. Their reply, my lord, will kindly see. Reply to reply to kindly come to page 50, my lord. Very long reply, all based on land documents. All, my lord, I need not take your lordship through each of the sentences. Everything is based on land documents. They have
Mr. Dasgupta, you have to satisfy me on 3 scores. One
My
is
lord.
that the show cause of 30th of September 22. Why can't we say that that was overridden by the order?
that is what I satisfied
This
lordship.
is one aspect of the matter. The second aspect is there was no show cause for blacklisting. There was a show cause for disciplinary action. I'm just
That was the
you will
first
give
one.
your answers.
Yes, yes.
And thirdly, extension till 29th of November. How can you blacklist them before that?
My lord, all the 3 replies that was my opening statement.
Make that again.
Termination of an existing contract. That is why I showed you this. Lordship.
Termination is different from blacklisting.
Blacklisting, my lord.
Yes.
When they are not questioning it, my lord. Admitted.
Not questioning what?
That termination and
They are challenging the blacklisting. Termination is over.
my lord. No. Termination.
They have worked already.
No. Work is going on.
They're challenging the blacklisting.
They are challenging the blacklist, but they are basing their case on
whatever
non-performance.
You answer this question.
Well, the question, answer lies here, my lord.
Right.
So this show cause after all the show cause notices, extension of time, these are issued by the executive engineer who is working there on the project.
Maybe.
Termination is a different process carried out by a higher authorities. Executive authority does. So executive engineer is only related to the execution of the work, nothing else. He will give show cause notice under the terms of the agreement that you have not completed this work. His jurisdiction is limited to withdrawal of work.
So this show cause is not for blacklisting.
No. Show cause for blacklisting is 28.
Can I record your submission on that?
Yes, well.
30th September
Is the only 30th September is the only notice for blacklisting.
No.
Other show causes which are being shown, my lord, those are not show cause notices. 30th September.
My question of you, I'm renewing my questions, Mr. Dasgupta. One question, show cause dated 30th of September.
That is the show cause notice.
If that is the notice, why can't we say that that order, that show cause notice was overridden? That was done away with after the final order passed in the previous day.
Yes. Well, I hope other questions are.
Other questions are 2. One is that was not a show cause for blacklisting. It was a show cause for disciplinary action. I saw it from the notice itself. Third is after the extension being granted till 29th of November, you concede to that extension. If you grant that extension, after that, can you say for non-completion, I am blacklisting you?
My lord, I am not saying. I have made all this argument. Kindly see notice once more. Kindly see page para 3, page 45. Yes.
Para 3, yes.
It rules.
আমার কাছে খালি এই ক্লজটা আছে কিন্তু
There's a different copy of the same notice.
No, I have got only the particular clause.
I wanted to show the debarment can be
এটা নাও তুমি এটা নাও
for not completing the work properly, not executing the work properly, and violating conditions of contract.
Nobody doubts.
Well, no violation of conditions of contract. They are not
answering the 3 questions.
My
None of the 3 questions. I'm repeating my question last time.
My lord.
First question is show cause notice date 30th of September 2022.
My lord,
after the order passed thereon. Answer this.
I will kindly see the order.
How can that remain valid after the order of the writ?
Well, kindly see.
Let us
kindly see the prayer in the first writ petition.
Let us come to page 43, the order itself. Whatever may be their prayer, that has merged into the order.
Yes. Very good.
No.
My lord, an order was
order.
My lord, my lord, kindly see. An order, a writ petition is filed on certain facts of circumstances. An order is passed on those facts and circumstances. It was never argued before that in the interim and show cause notice has been issued. It was never placed before the Honorable Court, my lord. Honorable Court did not have opportunity to look into the show cause notice. Kindly now see the order.
Let us forget that order, if you say that. You granted extension after that.
My lord, may I first let us, my lord, complete the first part, my lord, first answer. Whether this order dated 22nd
Yes,
December
let us read that.
2022.
Start that because we are on motions.
My lord, this was an order in my favor. This was not an order in their favor.
Let us interpret, please.
My
read the
lord,
order.
petitioners have moved this application against threat of termination, not against cause notice. Threat of termination, not against
No.
blacklisting. Have moved this against the threat of termination of the petitioner's contract with the CPWD for construction of an academic campus for IIT Kalyani. The petitioners were continued to be protected by an undertaking given by the learned advocate, learned counsel appearing for the CPW on 29th July 2022, that no steps would be taken by the respondent against the petitioner. When this undertaking is given, my lord, this is in respect of termination of the work which was challenged. However, after hearing the learned counsel and considering assurance given in letter dated 13th July 2022 by CPWD that the defect liability period will run from taking over all respective buildings and the exemption provided under Section 3 of the Government Building Act to certain government buildings from municipal laws. So this was their main point of argument before in every case. Even in their reply, they have made this. This court is of the view that the petitioner should be directed to complete the remaining work, because we said we do not want to terminate him, because if we terminate him now, then we'll have to retender the whole work. Whole process will start again. It will again be delayed. So it is in our benefit if he does the work. So complete the remaining part of the work. It's 70%. When the writ petition was filed in July, it was 70%. This order is in December, still 70%. Kindly, the admitted position is that petitioners have completed about 70% of the project, and only 30% remains to be completed. The apparent financial distress of the petitioners may be addressed by direction. So this was one of the other ground. By direction of CPD to process a bill of 5 crores, which has recently been submitted by petitioner. No objection. It is made clear that the petitioners have also to urgently look into charge of non-payment of vendors and other parties assisted in the work project. This is still not done. We are now directly paying the vendors. WPA is disposed of in terms of the above. Petitioner shall make every effort to complete the remaining part of the work within a reasonable time without any further delay. So this order was the existing project, Miller, only in respect of the existing, because by this time the show cause notice has come. They have given a reply. They have not pointed out before the Honorable Court that they are already, in spite of a submission made, they are contemplating blacklisting me. So this was never brought before they did not think it was necessary because they knew it was a different thing. The letter of CPW 25th August regarding delay on part of the petitioners to complete work and asking petitioners to submit pending bills. We were giving them letters, my lord. You submit bill, they were not submitting. Is kept on record. Any impediment in the completion of work shall be looked into and be resolved by the CPWD. The petitioner shall cooperate with the CPWD in the matter of completing the balance part of work, which we are still doing. So, my lord, this order does not set aside the show cause notice, and this order does not negate the terms and conditions of the tender, because that ground has been taken in other writ petition. For some reason, they are not moving that writ petition. Same ground, that because everything has been now been nullified, now we can continue doing it within a reasonable period of time. Reasonable period, even if you take their argument, reasonable period of time was from December till August, because our lordship said the whole period 70% work completed. Whole period was 18 months. Till date, they are not doing this. Till date. Your lordship kindly, well, I hope I have, but this is my answer to your lordship's question, that this order.
That entire exercise was regarding the termination. And this is regarding blacklisting, which you specifically mentioned. Clause 6 you have mentioned, maybe debarred.
Debarment.
Debarment is
same thing, my lord. The word is
debarment. Rule 13.6, you have given the ground. So that is categorically a notice for blacklisting.
My lord. The second part is that their argument is mostly based on the terms and condition. I can concede on that point, my lord. I can concede on that point that we had told you that you have not been able to, but we are ourselves telling you to complete the work. We can concede, my lord. But on the second part, my lord, where you have deliberated until date, my lord. Now, my lord, another point was raised regarding delay, because almost 1 year. My lord, delay to one ground, I know one ground I am assuming is that in order to, because it is to be done by a constituted committee. So the constituted committee may have taken time, I do not know. But another ground which I know for a fact is in this particular case, I cannot bring it on record, my lord, is that this person was given some time to show some progress. Our job, my lord, this is a college campus for triple IIT. No, we have to complete it, my lord. Our job was to give them all chance. But my lord, on the same time, we do not want to do business with him anymore. At least for a period, because Supreme Court has said it cannot be for an unlimited period of time.
Yes, President.
We have to give him 2 years. He is, my lord, ranked one of the topmost contractors. Topmost. He is super, he is level super, my lord. Nobody is, very rarely people get this. And kindly see his conduct. And also, my lord, I don't know if your lordship will allow me to place a document, my lord. This is the letter written by the executive engineer to me.
Let us not be on their antecedents. Let us focus on this particular case.
I am, that is one of my defense, my lord. I will be invoking the defense of equity in this matter. Kindly see the conduct of this writ petitioner. Everything, let everything be admitted. And your lordship will then see their conduct. And your lordship will judge whether this person, this contractor who has been given so much, who is executing an important public work, he should be given in equitable justice, whether he is entitled to that, whether your lordship will exercise that discretion or not, even if everything is.
So, Mr. Dasgupta, I can take your assurance on this, that whatever order is passed on this, that does not allow you not to pay them on the work done by them, and the work which they have already done, you have to pay them on that.
My lord, my lord will kindly. Again,
so this has no nexus with
this has nothing to do with the existing work, my lord. This is my unequivocal. My lord, kindly.
You are trying to diverge the two. You are saying that the termination proceeding is different from this.
Kindly see page 65. Again, my lord.
The rest falls in
running contract shall remain unaffected means unaffected.
Rest falls in place.
Unaffected means unaffected. Payment, time period, although a very strange argument has been taken in the other writ petition. I wish both were taken. They have said by this writ petition, by the order which has been passed, every terms of contract has been nullified. Everything has been nullified.
That has not been made here.
A slight indication has been made in this writ petition. I do not want to take a look. My lord, this is. I hope, my lord, I have touched on all the questions, yes. My lord.
Yes.
Great.
Lord, I just 2 minutes, my lord.
Yes, absolutely. You have a right to reply.
Lord, first, my lord, if I may show your lordship the show cause notice, 3 paragraphs only.
Yes.
My lord, what has been invoked? If your lordship says paragraph 6, rule 13.6 has been quoted.
Yes, it has. Yes.
So as per rule 13.6 of the CPWD 2022 rules, contractor may be debarred if it is established by inquiry that. So it presupposes an inquiry prior to debarment to establish these 2 following conditions. This is the quoting of the rule. Paragraph 7.
My lord, this is again a new point. Your lordship will kindly allow me to answer this.
No, it's not a new point, my lord. Paragraph 7, kindly see, whereas by failing to execute the contract satisfactorily and violating the condition. Yes,
stress has to be the and violating.
I'm also saying that. But this and violating the condition of contract is under 6(2). It has to be established by inquiry 1 and 2.
Yes.
Paragraph 7 is a recording of the conclusion. Kindly see, my lord, by failing to execute and violating the conditions. Even after repeated notices, you have made yourselves liable. My lord, kindly see, paragraph 7 is supposedly the result of an alleged inquiry under Rule 6. under paragraph 6, 13.6. 13.6 is a quoting the rule that if it is established on inquiry, these two conditions, then you will be debarred. If your lordship takes the rule once, now, my lord, if your lordship sees, so paragraph 7 is supposedly their conclusion and their satisfaction upon inquiry, must be upon inquiry under rule 6. So, my lord, thereafter your lordship will see, therefore. Therefore means, since I have made myself liable for debarment under 13.6, therefore, this notice is given to me to show cause why disciplinary action is should not be taken under rule 13. So therefore, this show cause notice presupposes a prior inquiry and a finding of debarment.
Very.
With the greatest of respect, my lord, that is not on record. The finding which has come after my reply to this notice, kindly see page 63.
Yes.
This is they are treating this again as, my lord, a ban on participation. The ultimate conclusion is debarment would entail the following. So, my lord, the show cause notice for disciplinary action is converted into a proceeding for debarment. That is number one. Now, my lord, if I go into the merits of the submission which my learned friend makes, he tries to make a distinction between the right to terminate and the right to initiate debarment action. That is all fine. But the moment you say that violation of a contractual condition may lead to debarment, violation of a contractual condition is an essence of a repudiation of a contract by breach. Unless the violation goes to the root of the contract, the other non-defaulting party cannot, under the contract law, exercise a right of termination. Right of termination means it's a prime main breach without which the contract cannot be performed.
Yeah.
Now, you cannot say that once you say that I have exercised my right not to terminate, but the law will definitely presume, therefore, that there is no violation of an essential condition of a contract. Because contractual conditions are essential conditions, non-essential.
Mr. Sen, I'll just hear Mr. Dasgupta shortly on that.
And only on one more aspect, my lord.
Yes.
Just kindly see, my lord, I come back to your lordship's third question. Now, your lordship's third question was page 66 notice.
Yes.
Once page 66 notice comes, can they say that there was a violation of the condition of the contract necessitating my debarment, but not necessitating my termination? Now, kindly see just two sentences at page 67 at the top.
Yes.
Wide this office letter dated such and such this office made a reasonable completion program of the work and completion date provided is 29th of July 2023. Therefore, the work could have been completed by 29th of July 2023. So, my lord, once 11th January 2023 letter comes from them, then, my lord, the breaches have all vanished, or I say condoned, and no cause of action either for termination and no cause of action. Therefore, no cause of action can survive for debarment. So, my lord, termination, the higher step is debarment. Termination is, I can say like this, it is only a minor penalty in respect of one particular contract.
You see, it's a degree.
It is a degree of punishment. You are yourself saying that all the breaches which I noted in
Get
my.
your point, Mr. Shani, you have made it.
So therefore, my lord,
Yes.
when 11 January 2023, you have given a greater work
Then they
progress,
cannot give a greater.
then you cannot rely on that breach.
Mr. Rajgupta, on this short point 13.1 and 13.2, inquiry, you did not make any inquiry, disciplinary action. Disciplinary case
Inquiry
before-
was done. This is what
It is not reflected in your office order, impugned office order.
Hmm?
Show me from your office order.
মুশকিল করে না এইটাতে আছে
But if that inquiry has
If
been.
disciplinary case action was taken, Mr. Rajgupta, they would have to be heard then.
Yes.
No,
Where is the show cause notice?
I have a judgment which says they need not be heard.
13.2.
Two judgments I will reveal. They need not be heard. That is if may.
Very good.
I have judgment. I did not want to drag this.
So have you, is it reflected anywhere from your impugned order, page 63?
Well, it has been referred to the committee. Whereas rule 30 were filed to 12. আরে কোথায়? কোনটা
Mr.
দেখেন?
Dasgupta,
আমাদের-
have you got a copy of this 13.1, 13.2 this thing?
No, I don't. কোনটা 13.1 contractor
Does it contain up to 13.7?
Yes,
That
yes.
copy,
13.2
your copy?
13.7 Department of
I'll show you something. Please come to 13.1. 13.1 is, I'm reading the third sentence, 13.1. Have you got that? Unless you have that.
Well, 13.1 I have.
13.1 third sentence, where the
sentence.
contractor has made himself liable for disciplinary action, enlisting authority, you may debar. So the language is where he has made himself liable. This per se does not contemplate any disciplinary action.
No, disciplinary action is
But
the department.
13.2 is
Well,
there.
there is
Let
punishment
us come
is
to
the
13.2.
department.
The enlisting authority shall initiate disciplinary case against an enlisted contractor.
Well,
The procedure is given.
Yes,
Now
my lord.
please come to 13.4 now. The disciplinary action against an enlisted contractor may lead to penalties mentioned in 13.6 and 13.7. And 13.7 speaks about debarment. Now, if disciplinary action, the result of that can lead to a penalty of debarment, can you do debarment before inquiry?
Well, this particular paragraph is disciplinary action. So the only result is
Result of that disciplinary action, that is the penalty you can take on that is debarment as per 13.7.
Yes,
Read with 13.4.
yes, my lord.
If the result of disciplinary action is debarment, can you do debarment prior to disciplinary action?
No, they have not been done, my lord. Disciplinary action has been taken, my lord. It is to be referred to a committee. My lord, kindly see where the contractor made liable is tender process period, etc. The shall be right to debar defaulting contractor from participating in tender for a period based on the recommendations of the empowered committee. This is the disciplinary proceeding which is done, my lord.
So it is
my lord,
pending before the empowered committee.
done. Empowered committee has recommended, the empowered committee makes the inquiries. They go through mainly the show cause is given. In this present case, my lord, I did not show your lordship. He has admitted every allegation, those sub clauses. He has not said that this is absolutely wrong. Your lordship kindly see.
When was the disciplinary action completed?
কোন কথা 65 এ কি আছে দেখি the chief of oh this is the reply, my lord. Last paragraph, it is to page 12, my lord. Paragraph 12, my lord, 65.
This is what I had challenged.
After carefully considering your reply of show cause notice, taking into consideration all the facts placed on record, circumstances of the case, and recommendations of the empowered committee, the enlisting authority found that action against Mr. Kamala is justified in above mentioned rules, exercise power under Rule 13. Well, it is directly, inquiry is not done by the authority, enlisting authority, is sent to the empowered committee. And empowered committee is, my lord, it says who are the empowered committee, my lord, clause 1.
We do not want. Yeah.
Well, yes, 13.2 also says.
I'll close arguments. I'll not pass an order on the debarment order because this does not affect the present action. I'll make that clear. I'm not passing any order on of stay of the debarment order. But I'll clarify that this does not affect the present work and the dues, your dues on that.
18th January, my lord, I have to participate in another tender, my lord.
That is never not mentioned in the writ petition, not a single line.
No, not that. No,
Subsequent
no.
notice is issued.
18th January.
Sorry, 18th October, my lord, subsequent notice.
That you cannot participate. I can't do it before the vacation.
No,
Not possible, Mr.
No, that is okay, my lord.
Learned
No, I was only submitting this, my lord, even the disciplinary action under 13.2 requires hearing. That is 13.2 itself.
Hmm.
And my lord, kindly, that is the only aspect.
May I
my lord.
clarify this? Short judgment, 2 pages, 3 pages judgment, only one.
Heard learned counsel for the parties. Full stop. Next para. Since it is clarified by learned counsel for the respondent authorities that the debarment order impugned in the present writ petition does not prevent the petitioner from staking a claim on the bills for the work done under the present contract, comma, no order of stay of the operation of the impugned debarment is passed. Full stop. Next para. The matter is reserved for judgment.
I can only participate without prejudice to the subject to the result of this
No,
writ
Mr.
petition.
Shah. You have to miss out this.
But I have not placed it, but Lord shall kindly go through the reply given to the show cause, my lord.
No,
Reply.
no, definitely I'll.
They have admitted everything, my lord.
I am only relying upon that 11th January.
No, I'll have to look into everything.
Okay.
That's what should go. Yes, call.
Item 8.
Yes. Yes, so what Judge?
Regarding the change of currency note, 2000.
Yes, Mr. Banerjee, what is your
No, my lord. My instruction was there. He was to take instruction. Yes, my lord.
Yes.
This is my application, my lord, before the learned chief judicial magistrate. Now, my lord, the learned chief judicial magistrate, my lord, is not disposing my application due to the non-availability of the lower court record. I made an application before the learned additional session judge first court, my lord, for transfer of the record. This is the observation of the, my lord, the learned first court that the as per, my lord, this order, the learned first additional session court is of the opinion that the learned CGM should write a letter to him for transfer of records.
These matters, but I'll not get into. Your lordship will not get into this. This is obviously some ego somewhere speaking.
That is the right.
Your lordship will issue certain directions.
That is correct.
Because that money be changed. I am not standing in the way of that. As far as the money I have with me, that has already been changed.
Yes, so far as the 4 lakhs, which was seized my lord, from the accused person, that was changed.
For
And
the
my,
superintendent of police. You are the superintendent of
I
police.
appear for the police authorities.
Police authority. The scope of the present writ petition is very limited. Full stop. There was a robbery, an armed robbery or something like that.
no, my lord,
There was theft. There was a theft from the safe. What happened was some of the money was stolen. Obviously,
Some was
some was left. behind.
channelized elsewhere.
So the money that was left behind, we had seized everything.
Well.
With that we handed over to them as Jimma. So that is what is about 55 lakhs odd minute that was it. Now out of the other money that was stolen, we have recovered about 4 lakhs something.
Yes.
So that we have already changed, which is in our custody.
Good.
But the money that was with them,
Hmm.
that needs to be changed.
The কোনখানটা শেষ করলাম প্রথম সেন্টেন্সে হয়ে গেল তারপর কি আচ্ছা very good. An amount of money was stolen from the petitioners. Subsequently the money was recovered. The portion of the recovered sum, comma, which was lying with the police authorities has in the meantime been the portion of the money which was lying with the police authorities, comma, to the extent to which the same comprised of rupees 2000 notes, comma, which are about which have been recently banned, comma, were duly exchanged by the police authorities in the meantime. Full stop. Next para. However, comma, insofar as the amount of the recovered sum which is lying with the Jimmadar, comma, it is the contention of the petitioners that The same also comprised of 2750 pieces of rupees 2000 notes. Full stop. Unless there is a conversion, there is an exchange of the said notes, comma, it is submitted that the said money will become stale, stale. Full stop, next para. Accordingly, the petitioner applied duly by way of a put-up petition before the jurisdictional magistrates court, that is the court of the chief judicial magistrate at Bardwan. Full stop. However, comma, no order was passed with regard to that. Full stop, next para. On the other hand, comma, the petitioner also moved the additional sessions judge, comma, since the money was lying with the said authority, comma, who also disposed of the petitioner's application with the observation that it would not be proper to send back the original case record unless a request to that effect was made by the CJM, comma, Bardwan. Full stop, next para. Unfortunately, the petitioners are the worst sufferers. Full stop. The petitioners, being public authorities, have been opinions of the additional sessions judge, comma, first court at Bardwan and the chief judicial magistrate at Bardwan. Full stop, next para. The matter can be resolved if the chief judicial magistrate makes a formal request to the additional sessions judge to take necessary steps for converting the 2000 rupee denomination notes to valid currency. Full stop. Accordingly, WPA 23862 of 2023 is disposed of by directing the chief judicial magistrate at Bardwan. He is not a party. Very well. By granting leave to the petitioners to approach the chief judicial magistrate at Bardwan and press their application pending before the said magistrate for the purpose of passing necessary directions. Full stop, next para. As and when the said approach is made by the petitioners, comma, the chief judicial magistrate at Bardwan shall act on the same and make a necessary request in writing to the first court of additional sessions judge at Bardwan to take necessary steps for conversion of the rupees 2000 notes into valid currency at the earliest. Full stop, next para. The parties as well as the aforesaid two authorities shall act on the written communication of the learned advocate for the petitioner and take necessary action thereupon as expeditiously as possible, comma, positively within 3 weeks from the date of such communication being made to the said authorities.
And they shall hold the money in the same terms of Jimma as.
So, needless to say, comma, after such conversion, comma, the said valid currency would be held in the same terms as they were being held in Jimma. Take up the next matter.
Upgraded matter, item 9.
Would I appear for the petitioner?
Yes.
I am here, my lord, because my lord, it was my lord, adjourned at my instance
The
yesterday.
court
my
is
lord.
extremely grateful to you.
No, no,
But
not
I'll
that, no,
record
no,
that in my order that
No, no,
you are
my lord,
here.
there
It's
is- no, no, my lord, there is a continuing.
How did you manage the other court?
My lord, I have taken the risk, my lord. It's a continuing parted, my lord. So of substantial importance also, my lord. It's ongoing since yesterday, my lord. So I am here, my lord, but I will be really grateful to Mr. Dotto if he does not stand in the way and agrees to my proposal. I have made a request to have it on Thursday.
No, but I could not, but accede to his request, because this matter seems to be of some urgency and very interesting for me.
Oh. Why me? Mr. Bhattacharya, you must have some objection to this court.
My lord, I will run very
Because central agencies are in some way or the other.
I was about to indicate, my lord.
That objection I'll really consider.
My lord, this stems out of, my lord, the investigation which is ongoing and the investigation as is being conducted by
What
the
is this matter about? Actually?
enforcement.
But I'll tell you,
My
Lordship,
lord, basically, my lord, I'm taking the point regarding, my
Mr.
lord,
Bhattacharya, let him
my
open
lord,
in
the
a
point
nutshell.
of determination, my lord. It's my duty to indicate. Just a second, Shobhushaji. So, my lord, it's my duty to indicate, my lord, this stems out of, my lord, an investigation which is ongoing as conducted by a central agency being the Enforcement Directorate. So there are orders, my lord, if my lord, prayers, my lord, if my lord kindly takes, my lord, the prayers E, prayers F, my lord, those are, my lord, essentially, my lord, against, my lord, the ED, my lord, impliedly touching upon, my lord, the question of the investigation.
Let us see what is the main challenge, Mr.
And
Bhattacharya. If
prayer
these are
G,
related-
my lord, is out and out, my lord, a prayer, my lord, and a police in action, my lord. Because the OC of Kalighat, my lord, he has.
If those are ancillary reliefs, Mr. Bhattacharya, then we'll have to
My
consider.
lord, otherwise
But
the
the question
reliefs
of
are,
determination we have to take.
otherwise the reliefs are, my lord, claimed against private respondents, my lord.
Let us hear Mr. Dotto first. Yes.
Will my lord hear him today, my lord, or my lord will hear him on
Right now,
Thursday?
May I start, my lord? May I start, my lord? They are
If
familiar.
you are in difficulty, we'll continue after the recess. After recess, we'll be.
After recess will be very convenient, my lord.
We'll continue after recess. Let Mr. Dotto start.
Very good.
Then if he finishes before that, and if I hear the others who are here, then we'll continue for you after the recess.
I'll be grateful.
Good.
May only submit, Lordship, I have a maintainability point.
Yes. What is the point? Mr. Dotto, please hear that and address that also.
Has already.
Take the microphone. Mr.
Microphone.
In the year 2012, Lordship, the Honorable Supreme Court has clearly set out a guidelines that under which circumstances a gag order can be obtained.
No, I'm not praying for a
That is
gag
the
order.
merits. That is on the merits.
Postponement order, Lordship.
No.
That does not prevent any writ petition being filed for gag orders. If let him pray for that, if he prays for that, that will be on the merits of the prayer. Yes, Mr. Dotto, please move on.
Lord, the
Yes.
primary, my lord, ground of challenge, my lord,
Yes.
or my lord, the set of facts for my lord moving this writ petition is, my lord, the petitioner finds day in and day out, my lord, various media reports coming, my lord, which has virtually, my lord, held, my lord, the petitioner, her family members, her husband, etc., my lord, as guilty of certain offenses. Now, what is the stage today? Well, the stage is, my lord, various investigations are going on, my lord, by or being carried out by the CBI and or the ED in respect of so-called scams. My lord, ED.
But I am only for, my lord, the Union of India, my lord. Respondent number 1 and 2, I do not know whether the ED has been served or not.
No, nothing to do with them. I am primarily, my lord, on the media.
ED is a respondent here, my lord. So I'm neither for the Press Council of India,
Mr. Chatterjee, you are for?
nor for, my lord.
To 17 and 18.
And Mr. Ganguly, you are appearing for?
They are the private.
Good, let us hear. Yes. Yes, Mr. Dotto, then what is your?
Yes.
Google India has been made a party. Google India is not to be made a party. Google, the company LLC, that is
Very well, yes.
I hope all objections are over.
No, ED is served.
No, ED hasn't served. Yes, for your satisfaction, ED
I'm
hasn't served.
ED is also making publications.
Yes.
ED is making publications.
Yes. Press releases are being made, my lord, by the ED.
Anyway, let us hear you. Yes. So
yes. Now, my lord,
can there be a blanket order in that fashion, Mr.
Well, may I say this, my lord?
As you said, gag order. That is.
Yes. No, I'm not here for a gag order. But I am here, my lord, for, my lord, an order within the permissible legal parameters As to, my lord, to what extent, my lord, number one, ED or any investigating agency, for the time being, I don't use the expression ED. To what extent, my lord, an investigating agency can percolate information to the press, media, etc., in respect of an ongoing investigation, number one. Number two, to what extent these informations can be percolated, my lord, again to the media houses in respect of sub judice matters. Number three, my lord, what is the effect or affectation of right of a person or a group of person, my lord, who are being discussed, dealt, and, my lord, held guilty, my lord, by the in course of media trial. Number four is, but again, my lord, something to do with, my lord, the basic presumption. That is, my lord, my presumption of innocence, my lord, goes, which, my lord, I enjoy, even, my lord, when, my lord, I am a convicted person. If an appeal is filed from a conviction, the moment, my lord, the appeal is admitted and conviction is stayed, my lord, the presumption of innocence, my lord, again comes back, my lord, till such time it is finally decided by the final court. It may be the Supreme Court, it can be the High Court, whatever it is. Now, my lord, this presumption of innocence, again, my lord, gets affected, my lord, during an ongoing investigation. And finally, my lord, my fundamental right to privacy. Now, this fundamental right to privacy, my lord, includes my right to protect myself, includes my family's rights, and, my lord, the other persons, my lord, for whom I can vouch. But these are, my lord, the primary, my lord, outlines of my argument. And finally, my lord, what are the powers of the court in respect of this? Now, if I may start from the final one, and then, well, I'll go back to, my lord, the other ones. Well, first, my lord, in Sahara India's case, where the Supreme Court has applied, my lord, your lordship's powers under Article 215 of the Constitution. Where, my lord, your lordships have the power to either direct postponing or withholding of media trial. But I'll come back to the facts later on, my lord, and the documents were based on which, my lord, I have grounded my petition. Yes, Sahara ka diya gaya. But first, my lord, please take me to 2012, 1210 SCC. 603.
Yes.
My lord, your lordships, my lord, may kindly take me to paragraph 33. Printed page কত দেখতো?
720. Yes.
Please give me a moment. 118.
Yes. Para 33.
Yes, please give me a moment. But a long judgment, my lord. I should upgrade myself.
Has to be a bigger iPad. What
Yes,
is
yes, true. দাঁড়ান।
হাতে নিয়ে দাঁড়িয়ে আছি আমি। You think his junior is incompetent?
Yes. Page 30, para 33.
Yes.
At this stage, it may be noted that the judgment of the Privy Council in Independent Publishing Company versus
Please wait a minute. Para 33 of this judgment is at
Wait.
page 702.
my lord, 720.
720 আছে।
Yes. Printed page 118.
Yes.
At this stage, it may be noted that the judgment of Privy Council in Independent Publishing Company Limited versus Attorney General of so-and-so has been doubted by the Court of Appeal in New Zealand in so-and-so. In any event, in the interest of powers of the courts of record, we are bound by the judgment of this court in Mirajkar. Thus, courts of record under Article 121, Article 215 have inherent powers to prohibit publication of court proceedings or evidence of the witnesses. The judgments in Reliance so-and-so and Mirajkar were delivered in civil cases. However, in Mirajkar, this court held that all courts which have inherent powers, that is the Supreme Court and the High Court, and the civil courts can issue prior restraint orders on proceedings, prohibitory orders in exceptional circumstances temporarily prohibiting publications of court proceedings to be made in the media, and such powers do not violate Article 19(1)(a). Further, it is important to note that one of the heads on which Article 19(1)(a) rights can be restricted is in relation to contempt of court under Article 19(2). Article 19(2) preserves the common law of contempt as an existing law. In fact, the Contempt of Courts Act 1971 embodies the common law of contempt. At this stage, suffice it to state that the Constitution framers were fully aware of the institution of contempt under the common law, which they have preserved as existing law under Article 19(2) read with Article 121 and 215 of the Constitution. The reason being that contempt is an offense sui generis. The Constitution framers were aware that the law of contempt is only one of the ways in which administration of justice is protected, preserved, and furthered. That it is an important adjunct to the criminal process and provides a sanction. Other civil courts have the power under Section 151 of the Code of Civil Procedure to pass orders prohibiting publication of court proceedings in proceedings. In Mirajkar, this court referred to the principles governing courts of record. Under Article 215, it has held that the High Court is a superior court of record, and that under Article 215, it has all the powers of such a court, including the power to punish contempt for itself. At this stage, the word including in Article 129, Article 215 is to be noted. It may be noted that each of the articles is in two parts. The first part declares that the Supreme Court or the High Court shall be a court of record and shall have all the powers of such a court. The second part includes the power to punish for contempt. These articles save the pre-existing powers of the courts as courts of record, and that the power includes the power to punish for contempt, see so and so. As such, declaration has been made in the Constitution that the powers cannot be taken away by any law by the Parliament except to the limited extent mentioned in Article 142(2) in the matter of investigation or punishment of any contempt of itself. If one reads Article 19(2), which refers to law in relation to contempt of court, with the first part of Article 129 and 215, it becomes clear that the power is conferred on the High Court and the Supreme Court to see that administration of justice is not perverted, prejudiced, obstructed, or interfered with. To see that the administration of justice is not prejudiced or perverted clearly includes power of the Supreme Court, High Court to prohibit temporarily statements being made in the media which would prejudice or obstruct or interfere with the administration of justice in a given case pending in the Supreme Court or the High Court or even in subordinate courts. In view of the judgment in A.K. Gopalan, such statements which could be prohibited temporarily would include statements in the media which would prejudice the right to a fair trial of a suspect or an accused under Article 21 of the Constitution, Article 21 from the time when the criminal proceedings in subordinate form being perverted. That the words due course of justice in Section 2(3) or Section 13 of the 1971 Act are wide enough and are not limited to particular judicial proceedings. That the meaning of the words contempt of court in Article 129 and 215 is wider than definition of criminal contempt in Section 2(c) of the 1971 Act. Here we would like to add a caveat. The contempt of court is a special jurisdiction to be exercised sparingly and with caution whenever an act adversely affects the administration of justice. See so and so. Trial by newspaper comes in the category of acts which interferes with the course of justice and administration. Where I lay emphasis on the last sentence that I have placed. See so and so. According to Nigel Lowe or Brenda Suffren, and also in the context of the second part of Article 129 and Article 215 of the Constitution, the object of contempt law is not only to punish, it includes the power of the court to prevent such acts which interfere, impede, or pervert administration of justice. Presumption of innocence is held to be a human right. If in a given case, the appropriate court finds infringement of such presumption by excessive prejudicial publicity by newspapers in general, then under inherent powers, the courts of record, suo motu, or on being approached, or on report being filed before it by the subordinate court can, under its inherent power, under Article 129 or Article 215, pass orders of postponement of publication for a limited period if the applicant is able to demonstrate substantial risk of prejudice to the pending trial, provided that he is able to displace the presumption of open justice, and to that extent the burden will be on the applicant who seeks such postponement of offending publication. Then para 34. The above discussion shows that in most jurisdictions, there is power in the court to postpone reporting of judicial proceedings in the interest of administration of justice. Under Article 19(2) of the Constitution, law in relation to contempt of court is a reasonable restriction. It satisfies the tests laid down in the judgment of this court in R. Rajagopal. As stated, in most common law jurisdiction, discretion is given to court to evolve neutralizing devices under contempt jurisdiction, such as postponement of trial, retrial, change of venue, and in appropriate cases, even to grant acquittal in case of excessive media prejudicial publicity. The very object behind empowering the courts to devise such methods is to see that administration of justice is not perverted, prejudiced, obstructed, or interfered with. At the same time, there is a presumption of open justice under the common law. Therefore, courts have evolved mechanisms such as postponement of publicity to balance presumption of innocence, which is now a recognized human rights in so-and-so, vis-a-vis presumption of open justice. Such an order of postponement has to be passed only when the alternative measures, such as change of venue or postponement of trial, are not available. In passing orders of postponement, the courts have to keep in mind the principle of proportionality and the test of necessity. The applicant who seeks order of postponement of publicity must displace the presumption of open justice, and only in such cases the higher courts shall pass the orders of postponement under Article 129 and 215 of the Constitution. Such orders of postponement of publicity shall be passed for a limited period and subject to the courts evaluating in each case the necessity to pass such orders, not only in the context of administration of justice, but also in the context of rights of individuals to be protected from prejudicial publicity or misinformation. In other words, where the court is satisfied that Article 21 of the rights of a person are offended. There is no general law for the courts to postpone publicity either prior to adjudication or during adjudication, etc. Therefore, my lord, the powers of the court is not fettered. Your lordship, being, my lord, exercising power under Article 226 quae, my lord, having powers, my lord, under Article 215 of the Constitution, my lord, have the authority of law, my lord, to direct postponement of whatever is happening. I'll demonstrate that later on. Number one. Number two, my lord, what is my obligation? My obligation is to demonstrate before this court that this media publications, discussions, talk shows, etc., my lord, they infringe valuable right of me and my family. So therefore, my lord, first, my lord, my first limb of submission, though which was the last one, to put it as the first one now, is, my lord, the power of the court or the expense of the power of the court, my lord, in this situation to, my lord, pass orders. This is the first one. The second one is, my lord, which I preempt is, my lord, arguments are made, my lord, in the sequel of, my lord, all proceedings, my lord, which are going on, that the persons who have come before the court or the persons who are being discussed in media, most of them are not accused. They are at the most a witness. Well, why I say this, my lord, when, my lord, ECIRs are sought to be challenged, the only ground of defense is how does it lie at the instance of a witness. But on that, my lord, please take, my lord, a Kerala High Court judgment, which is reported in 2022. SCC Online Kerala 2710. Aji সকালে যেটা দিয়েছি। No, this is not the one. This is not the one. This is the previous one. Aji সকালে যেটা দিয়েছি। 2022 SCC Online Kerala 2710. But here, my lord, initially, my lord, an interim order was passed in this proceeding, where, my lord, there was a blanket order. My lord, then, my lord, the matter went up for appeal. My lord, when, my lord, the appeal court had modified the order. Now, please take, my lord, paragraph 2 of the judgment. This is of division bench. Though the impugned interim, through the impugned interim order, the learned judge has issued a direction against the appellant not to publish, broadcast, telecast any item concerning or relating to the petitioner herein while reporting about crime number, etc., except the order of the court for a period of 3 weeks from today. That was the interim order, which was the subject matter of challenge. Now, please take me to paragraph 70. May I place para 16 before that?
Yes.
Coming back to the impugned order, though we do not propose to speak in detail on the merits of the rival factual contentions, we are left without doubt that a direction not to publish, broadcast, telecast any item concerning or relating to the appellant certainly travels beyond the reasonableness of the restrictions sanctioned by the Honorable Supreme Court in Sahara and other judgments covering the field. The term any item is not merely very vague, but would also cause an unfair fetter on the press to make a fair reporting within the parameters of law. And therefore, we feel it necessary to modify the same, though to a very limited extent. Then para 17. In the circumstances, we deem it apposite to dispose of the writ appeal vacating the impugned interim order to the extent to which it has restrained the appellant from reporting any item relating to the first respondent, but clarifying that they shall not engage in sensationalism or pursue any line of reportage intended to forge an impression against the first respondent or any other accused or witness with respect to their involvement or otherwise in the crime, and without in any manner commenting about the proceeding, etc.
How do you decide what is sensationalism? How do you enforce these orders, Mr. Dutta? What is sensationalism? Suppose my perception, your perception may be very different.
Very different.
I mean, our boiling points may be different.
Yes.
So how do you decide? How do you enforce these orders? Suppose I pass an order like this.
Yes.
How do you enforce it? Any line of reportage intended to forge an impression upon the person.
Yes.
Now, that will be definitely a gag order in every sense, which is not expected in a democracy. I mean, they have a right to speak. The media definitely has a right to speak. And to bring to the people, it has to be open justice also. Access to justice also includes information about justice.
Well, may I say this,
how can you do this?
Yes.
What is sensationalism? We all have our perceptions, but that depends on our background, our stratum of society and all these things.
But there has to be a balancing act.
There has to be something balancing, yes. These orders are sensational.
Yes. These are
when we pass these orders.
Yes.
But Mr. Datta, it's very difficult unless it can be enforced. How can we pass these sort of orders? I am in doubt on this.
Yes. First is, as I was saying, Millard, balancing the rights.
Yes.
First is a right to information, which has included in its, Millard, the right or freedom of speech and expression. Now, Millard, please consider, Millard, this is my understanding, subject to correction. Now, when the media houses report or the newspaper that we read every day, where it is told that the media houses or the newspapers, Millard, they report news.
Yes.
They bring to us certain information. Let us put it in this way.
Ideally information.
Ideally information. Now, please consider, what are the media houses doing? Because it is my right to information or the citizen's right of information or the newsreader's right of information, my lord, which is being mechanized by these news agencies, media houses, etc. Or my lord, my right to get the information, or my lord, one of my rights or mechanism to get the information is news media, etc.
Yes.
But I can give an alternative example where I submitted before your lordship on the last in another matter also. This Right to Information Act. The Right to Information Act has not conferred me with any extra right. My right to information was already there under 19(1). It is only a mechanism through the Right to Information Act that I have to apply to so and so with such and such fees. If he doesn't give, then I go up in appeal, etc., etc. So this is only a mechanism to enforce my right, which is a fundamental right. Therefore, what
it's personal, but my take on Right to Information Act is right. That act provides where you cannot get information rather than confer on you the right to, when you cannot get the information. That is stipulated there basically.
Therefore, the right is somewhere else.
Yes. Yes.
A procedure is formulated. Right to access to justice. It is right. But we come with Article 226 petitions. This is the process through which we get. Now we are the balancing, as I was saying. It is a citizen's right of information, a fundamental right, no doubt about it. Now what is to be seen is, through the enforcement of the fundamental right of a section, whether the fundamental right of a class or a person or a family can be affected thereby. But here, my lord, I would like to, my lord, impress upon the court that, my lord, my right to privacy, my lord, cannot be taken away or affected, my lord, by news reports. For example, so and so has earned such and such money. So and so has parked money in overseas bank account. Now, these, my lord, has the effect of, my lord, putting in or inculcating in public mind, my lord, a guilt of that person without the courts or, my lord, the ordinary process, my lord, coming to that conclusion.
Mr. Dotto, at the risk of disturbing you, at the best thing you can get is, we can import the tests of contempt. I mean, the tests of contempt are, it has to be accurate, it has to be objective, it has to be the truth. That much can be reported. We may say, probably, subject to hearing the other side, that yes, your loose comments on that, or your take on that, or the media's view on that, that may not be expressed for a particular period or during the pendency of the trial. The views of the media, that we may see. But even there, what is objective, what is accurate, what is the truth? Then it has to be then ordinary journalism, mainstream journalism, Mr. Dotto, has to be restricted to law reports. I mean, can we do that to the public?
But
it will be then like an AI here. Now, when you read whichever newspaper, I don't want to name any, whenever you read the newspaper, you will get an accurate, exact detail, which will be just a version of the AIR or law journals. I mean, can we do that to the public? Or some observations may come in, Mr. Dotto, which are the views of certain persons. There has to be a healthy discussion in society. How can you interdict that?
Lord, the bottom line is that through discussions, through reporting, through talk shows, Lord, nobody should be held to be guilty. Lord, the Supreme Court has held that the fickle-minded public, Lord, it is very difficult for them to accept tomorrow's court's conclusion against today's, Lord, media conclusion.
That's true. Yes.
But 2 days back, when the division bench of our High Court, my lord, had delivered a judgment. But I have read the judgment, my lord. It is so informative, my lord, on DNA test, our genes, etc. But, my lord, even the judiciary, my lord, has been criticized.
The same bench granted a bail at 2 days thereafter. That was also reported, although that was not so important.
That was
in
not
that context. Anyway, this happens, Mr. Dotto. We all of us are aware of it. But how far can we interdict to that, in that?
This mechanism, my lord, has to be, my lord, with the assistance of the bar, my lord,
Definitely.
to the extent
Always,
possible by me, my lord.
Yes.
I'll, my lord, definitely try to assist the court to find out.
The publication regarding the outcome of an investigation.
Yes. True. The outcome of an investigation at the investigation stage, my lord, is not permissible. But I'll cite another decision and go back to, my lord, my main points.
Right.
Well, the other one is Bombay High Court,
Yes.
2021, SCC Online Bombay, 56. Now, this is a case where your lordship would find, my lord, from the names of the learned councils, that were most of the media houses were parties over here and they had represented. From page where your lordship finds, my lord, the name of the learned councils who had appeared in the second page. But as your lordship was pleased to, my lord, observe that the matter should be kept on matter issues bordering criminal contempt. Yes. My lord, may kindly take me paragraph 253 at printed page 124.
Yes.
Resting on the authorities referred to above, and as a sequel to our aforesaid discussion, we hold that any act done or publication made which is presumed by the appropriate court having powers to punish for contempt to cause prejudice to mankind and affect a fair investigation of crime as well as a fair trial of the accused, being essential steps for administration of justice, could attract subclause III of section 2C of the Contempt of Courts Act, depending upon the circumstances to be dealt with in accordance with law. Then, my lord, your lordship may kindly take me paragraph 258.
Yes.
In our view, the court merely noticed that what has been laid down in A.K. Gopalan, but did not endorse that it continues to be the law in the present times. We say so with the utmost respect that at our command, that the aforesaid extract cannot be read as laying down of a law by the Supreme Court in relation to prohibition that could be ordered for statements in the media made at the time when proceedings in a subordinate court are imminent or where the suspect is arrested. When A.K. Gopalan was decided, what would constitute contempt was not defined. There being a clear definition of contempt in COC Act, reading criminal contempt in section 3 to commence with the registration of an FIR as suggested by Mr. Gokhale based on her reading of A.K. Gopalan would amount to rewriting the statute which is permissible. Therefore, my lord, in course of investigation also, my lord, it is the court's concern also that it should ultimately lead to a fair trial.
But that view was not accepted here.
Yes, yes. But 253, my lord, I deliberately read that.
Yes.
Because 253 is the part, my lord, on which, my lord, I would be laying emphasis. But criminal contempt, my lord, definition, my lord, I think your lordship has had it, my lord, a lot of time, my lord. It's
No, but this is-
interference with the court of course of
Section
justice.
2C or what is
2C is so wide that it could, my lord, include anything. But there were very interesting cases, my lord, on interference of justice, locking the, my lord, the court's main gate. It tends to interfere with the course of justice. We are preventing your lordship from coming to court, my lord, at the appropriate time. It also, my lord, amounts
to be
to
so beneficial to the court.
Now, my lord, this is, my lord, so my lord, I start with, my lord, what could be, my lord, the powers of the court, my lord, in this kind of situation.
Yes.
Now, my lord, only to give you a lordship, my lord, just, my lord, a glimpse of, my lord, what are my allegations. Please take a few, my lord, reportings, my lord, from the petition. For example, my lord, page 78. But hurriedly, my lord, without wasting court's time, my lord, we come across all these, my lord, every day.
No, even then, yes.
Yes.
Do you have a list of the page numbers? First, I'll take that down and then I'll go to the page.
But for me, my lord, I have noted
One or
down
two pages would do. Yes.
page 78,
Yes.
page 80.
Hmm.
78 is strongly to 17. Then 84,
Yes.
88, 93, 97, 100, 109, 111, 113, 116, 120. And my lord, I'll be seeking leave to, my lord, file a supplementary affidavit. My lord, 2 pages of that, page 10 and 16.
Supplementary to the
Oh, yeah.
time হবে তো মামলাটা।
Yes.
Now, my lord, please have a look to, my lord, page 78. But after the picture, but just please take the third line. TMC leader Abhishek Banerjee was flying on a Thai Airways flight and landed in Kolkata from Bangkok. She went through the normal screening where her 2 kg gold was seized. Meanwhile, BJP leaders from the state started making insinuations. They made at the bottom of that page, after the expression highlights.
But may I take your lordship's kind leave, my lord? That matter is about to be called in
Yes,
court
it's
one.
call of duty.
No, I was addressing.
Not
my-
as in the game, I mean. Yes.
I was addressing. Mr. Dotto should also satisfy, my lord, one point, whether rights which are exclusively available to the citizens of India under Article 19 can be sought to be curtailed by a foreigner, because paragraph 1 of the writ petition specifically says that she is a Thai national, the petitioner, and she is holding just an OCI card. So this is the first hurdle that has to be overcome. And insofar as the Nolakha matter, my lord, that was upon exchange of affidavits. My lord, my junior is here, my lord. Good.
But before he leaves, my lord, you should come prepared, my lord, for Article 14 and Article 21 is not limited to citizens. Very good. Now, after 78, my lord, please have a look to, my lord, page 80. Yes. My lord, it's not that legible, my lord. If your lordship may kindly permit us to, my lord, hand up, my lord, legible copies. But please take the second page, my lord, of the one which I've handed up separately.
Have you given the particular websites or the?
My lord,
Because otherwise, this, I mean, theoretically, this can be manufactured by your client also.
yes.
Unless the specifics are given.
So this is Swaraj. My lord will find it from এই Swarajটা কোথায় যেন দেখলাম?
Yes, page 83 probably.
Yes, my lord, at the top of me the one which I have handed up, my lord.
Yes.
Yeah, at the top of it, my lord, very faintly. Swarajjo.
Oh, yes.
Swarajjo.
ব্লগের মতো
Please, my lord, turn the page, my lord, of the, my lord, fresh copy, my lord, that I've handed up. Please take the first 3 lines at the top.
Yes.
The CBI investigations have allegedly revealed some links between so and so, a kingpin of mafia controlling activities relating to illegal mining. But investigate, Millard, the progress of investigation, Millard, is being reported. But after 2 paragraphs, then Bharatiya Janata Party has accused so-and-so and his wife of being beneficiary of this scam. Then please come to the bottom of that page. Former Trinamool minister, etc., who joined so-and-so, has said he will soon expose Madam Narula and her bank accounts in Thailand. Then, Millard, if your lordship may kindly take me to page 84.
Yes.
Now, this is of Republic World. Kindly take me at page 85. In a massive development, Republic TV on Saturday has accessed tapes of alleged conversations between an unknown individual and coal scam accused, Anup Maji's right-hand man, Ganesh Bagadia, exposing the syndicate culture in government. While the tapes have not been verified, Bagadia is heard allegedly describing the syndicate which runs the coal smuggling business since 2012. Currently, Bengal polls are underway, etc.
Why does this affect you?
Well, these are
Unless you are a part of the syndicate. Unless you admittedly are a part of the syndicate, Mr. Dattu, how does this affect you at all?
Millard, these are Millard, all Millard investigations or the progress of investigation or the stages or revelations in the investigation, if I may use this expression.
It's not a public interest litigation. You don't have any cause of action on this.
No.
It is a very
it involves my family also. I'll place those judgments also. It is not confined to me. It can be, if it is,
So, Doctor, your greater family is paying the price of popularity. There has to be a limit to the court's interference in that. Every media house has an affiliation to some trade house. Every media house, and that's an open secret here, has an affiliation to some trade house which is financing it, and those have their affiliations politically. Now there will be some political mudslinging and all will be there. We cannot pass gag orders so that everything is stopped. I mean, like this. Yes, you may say objective, accurate reporting has to be there. Generally, we may say that, but we cannot apprehend situations, Mr. Dotto, when what will be reported tomorrow, we don't know. We may say, we may frame certain guidelines. Very broad guidelines.
Yes. Millard, all the guidelines, Millard, which Millard I would be requesting the court to frame is based on Millard the judgments, Millard, which has been passed by the courts of our country.
It's an evolving thing.
Yes, it's an evolving thing.
Right.
Millard, page 82, Millard, again, Millard, very faint. আচ্ছা ওনার কাছে ফ্রেশ কপি আছে
Yes, 82 I'm looking at.
Millard, in the middle, controversies surrounding Rujira.
Right.
But just better copy to দিয়েছিস তো কোথায়? Please take me the better copy that I've handed up. Unfortunately, it doesn't have a page numbers. But please take the 1, 2, 3.
No, I can decipher page 82. Mr. Dattu. It's more or less legible in my.
Yes.
Small print but legible.
But above that,
yes.
But above that, there is another heading. Why is Rujira being probed?
Right.
But please take me to the second paragraph of why is Rujira being probed. CBI sources say that some bank transactions between so-and-so are being probed. The CBI has reportedly sought details of Rujira's investment and involvement with some companies. The sources say that the agency is probing some bank accounts in Thailand which are allegedly linked to Rujira. The CBI wants to know how the turnover of the companies.
This directly pertains to the investigation. Yes.
CBI sources.
Then, Millard, after that, please take, Millard, page number 88. This is 88 is by Hindustan Times, I believe.
Yes, an
Abhishek-
audio clip has been referred to, the veracity of which has not been independently.
This is one thing which I find
Yes.
that if you have not verified something, why should it be circulated? Verify it, take responsibility. If it is permitted in law, circulate it. Then after the gap, Bharatiya Janata Party leader Shubhendu Adhikari, who contested against Chief Minister so-and-so, in such and such, released at a press conference on Sunday and claimed that Abhishek Banerjee, Chief Minister's nephew and President, received 900 crores from rackets that smuggled cow coal and sand.
They have quoted a particular political person.
Yes. Then we'll,
So this is not the media has,
this may not be.
that's objective. I mean,
Then Miller, please take me to page 91.
91.
Yes. Page 91 is কাদের এটা? Oh, it is the continuation of that.
Yes.
Middle of that page. CBI has already questioned Abhishek Banerjee's wife, her sister, the latter's husband, and his father in the coal smuggling case. Earlier, several cow traders and border security forces officers were grilled by CBI in so and so. Then CBI raided properties and offices. Of course, I'm not with that.
No, the linking is very clear. I mean, these have no nexus with each other, apparently.
Yes.
The cow, this cow stealing case or whatever. Cow traders. Very well.
Then, my lord, may kindly take, my lord, page number 93. Yes, again, we are an illegible one. Will kindly permit us to hand up legible copies. Please take me the second page, third paragraph.
Yes.
The ED, it is learnt, has gathered irrefutable evidence of huge sums of money suspected to be proceeds of the scam being deposited in some overseas bank accounts held by Rujira. Yeah. Previous one was CBI, this one is ED. Then please take, my lord, page number.
And the ED joint director has been quoted.
Yes.
Not quoted, his actions have been.
Then, my lord, your lordship may kindly take page 97. But this is, my lord, regarding, my lord, eye checkup. So please take the second paragraph. Further, it was alleged that it has been a wonderful political ploy by Abhishek to proclaim for a gherav of all the BJP workers before going there. Abhishek's entire incident of going for an eye checkup in the face of ED summons was reported as a wonderful political plot that was expected when he failed to send Rujira away. Abhishek Banerjee is often seen quoting the statement, "Time is very important." It was alleged that just 2 months before the Panchayat elections, in the name of Nobojoar Jatra, he did a Nobo Tolabad Jatra by bringing criminals down the street. Later, when he himself participated in that proceeding, he silently sent his wife to Dubai.
So what is this a part of, Mr. Bidattu? Nothing is there.
Where
Only
97 is a it's a Shanmoy Banerjee.
In which
bulletin, lordship, in Banglar Barta, this was
Banglar Barta.
Banglar Barta. I have a YouTube channel.
Press one number 8.
This is a transcript of that.
Yes, they made a transcript of this.
Yes.
Then further, it was alleged that Abhishek had deliberately had been deliberately avoiding ED summons first through Navajwar Jatra, then in the name of campaigning, and finally for his eye checkup. It was said that ED was calling them repeatedly, be it Shayoni Ghosh or Monga Ghatak, or for that matter, Abhishek Banerjee avoided them with the excuse of Panchayat election, campaigning from so-and-so. They said they would cooperate with
Here the petitioner is only the lady.
Yes, yes.
So we cannot be concerned with the others because she cannot
No,
blanket in a
the
blanket. fashion.
petitioner and the family.
She is espousing the cause of her family.
Yes.
But suppose something is said against her husband in independent capacity, as her, not as her husband, but in his independent capacity. She does not have locus standi to, espouse his cause.
Well,
He is not a petitioner here.
Well, I'll demonstrate that. Well, the Supreme Court has held my right to privacy includes, my lord, not only me, my family.
True. As your family, if he was projected as your family, he had to have a nexus. The news item had to have a nexus with him and you.
Yes.
Otherwise, if he's not shown as your family, I cannot espouse the cause of my husband, my father, my mother, whoever.
My lord, provided
they have their independent
Yes,
causes of action.
yes. Now, your lordship will kindly find, my
If
lord,
it is said that my family, they're doing something, then definitely I have a cause of action.
my lord,
I'll look into that Supreme Court judgment very well.
কোন পাতাটা? But the connection in the last paragraph that I've placed, last line after the comma, he silently sent his wife to Dubai to avoid the summons, ED investigation.
What is that?
Third, 1, 2, 3, third paragraph, last line after the comma.
These are gossip items, Mr. Dottu. Why do you look into all these?
No, but,
They're absolutely gossip items.
but my gossip, my lord, at the expense of, my lord, my right, fundamental right.
True.
Now, my lord, please recall, my lord, apropos, my lord's query, my lord, far back, my lord, in Olga Telly's case,
Yes.
the Supreme Court has said that I cannot barter away my fundamental right. No one can barter away. This is fundamental.
Cannot.
These are all fundamental rights. My lord. Then, my lord, please take, my lord, the next paragraph which I was placing, my lord, Navajwar and avoid.
This is outright defamation, Mr. Dottu. Why do you take steps for defamation?
That, my lord, that is.
This is outright defamation, apparently.
But, my lord, I am on a higher platter or the highest platter.
Very
Now, my lord, please take, my lord, the second last paragraph at page 97.
97.
They were speculating that Abhishek Banerjee would make an attempt to travel abroad since he has been unsuccessful in sending Rujira away. We wish he gets well soon. But it is the media which is connecting. Now, my lord, thereafter, my lord.
Yeah, have you seen the last sentence?
Oh,
Did not
that-
read it out, that paragraph. This person has a sense of humor.
We wish he gets well soon. It is very.
No, after that.
Shastro Shadika does not work there.
Achha.
Yes, President. Anyway.
Now, my lord, kindly see, my lord, now, my lord,
Yes.
so as my husband is concerned,
Yes.
page 100. No, don't know. Please take me at page 190, 102,
102, right?
second paragraph.
Second paragraph, yes. You have not been named here.
Yes. Well, the first page 90, কত এটা? This is Miller page 90, 100. My husband.
Insinuations have been 100 is yes.
But yes, with 100,
Yes.
this is the story at page 102.
Yes. Probably the tag is more crucial
Yes.
than the news item.
Yes.
That page 100.
But page 100 onwards, my lord, that Russian episode
That
comes,
episode continues, yes.
100 to 108.
This
Now,
is also your client, Mr. Chatterjee. Somebody else.
no, this is
I-
Republic Bangla.
I think Republic.
No, Republic is carrying the news. Oh, it's very, yes.
Then again, my lord, that episode at page 109. 109 is Arambak TV.
After this matter, Mr. Datta, I probably can write a biography on this person. I do not know so much. I don't know one hundredth of this. Anyway, that's because of my difficulty. I don't read newspapers deliberately. I don't read newspapers at all. So
You don't watch
important news is no, and the important news are delivered to me by people in discussions. So those are only important.
from my domestic angle, my lord, my wife gives you
Yes.
these informations.
Yes, right. That is one of the sources.
Yes. This is possibly the only source apart from friends and other
Yes,
discussions.
right. Friend discussions are also very limited now.
Yes.
So I have very limited scope of knowing about the world.
Then, my lord, please take me to page 111,
Yes.
where the leader of the opposition is saying whatever he can say.
These are political propaganda, Mr. Datta. Courts of law cannot, grant injunctions on political propaganda. This is absolutely political.
Where
It is
I-
very clearly political.
Well, I'll address your lordship. My lord, today I'm not prepared. There's something called, as I've said, editor's choice.
Editor's choice, yes.
Now, the editor, my lord, has to exercise a right of
True,
choice.
that's there.
Therefore, whatever news he comes across, if it has the effect of, my lord, harming somebody's reputation, but I think, my lord, the editor has a choice over there.
You are searching for a standard which is now an utopia in India, Mr. Datta. That's utopia in India.
But,
That standard we cannot. Anyway, let us try
Yes,
as much
yes,
as
yes.
possible.
But the time has changed, my lord. Our tastes have changed.
Beyond
Everything-
recognition, changed beyond recognition. So I don't have any qualms with that. Time should change.
Should change.
Should
But-
change. But anyway, standards become different, Mr. Datta. That's what we are also evolving. So how far we can injunct people, go on injuncting people, we have to think of that also.
That is why, my lord, parameters are to be laid down.
Parameters are maybe.
Parameters are to be laid down.
Yes.
And but what is very important is, but of all these, whether it affects my right or not, whether it affects my family's right or not, what is to be seen is, my lord, that the interference of the courts of justice, that is very important.
Yes, definitely.
Those judgments, my lord, I'll place that I don't think that I need to waste your lordship's time with all these anymore. অনেক আছে, it is- But your lordship has noted down the page numbers, my lord?
Yes, Mr. Datta. Need not read place all. I've got a clue of the nature of the allegations.
Where my learned junior wants me to place only one sentence from page 113. The fourth line from the top or the second paragraph? I'm sorry, second line from the top. Which claims that Rujira Narula left for Dubai with her 2 kids.
That is the most innocuous in that page.
Yes. And the middle of that page.
That is the
Yes,
most innocuous
yes.
in that page. There are other things also in that.
Yes, yes.
I am not certain of what.
Anyway, Millard, to put it, Millard,
Yes.
in one sentence,
Hmm.
I am in the headlines
For the wrong reasons.
for the wrong reasons.
Right.
Now, Millard, kindly see, Millard, apropos, Millard, what I have shown, Millard, what is the scope? First, Millard, I need to, Millard, address your lordship, Millard, that what is a media trial? দেখাচ্ছি না But first judgment, my lord, your lordship may kindly have a look, my lord, is R.K. Anand judgment reported in 2009-8 Supreme Court cases, page 106.
One zero
106. But this is that, my lord, famous, my lord, BMW hit and run case.
Yes.
Where, my lord, the car crashed, my lord, with the police.
Right.
And my lord, NDTV, my lord, had covered it. And started by, my lord, a sting program. And, my lord, the Delhi High Court, my lord, had initiated, my lord, a suo motu, my lord, criminal contempt proceeding on that. Now, please take, my lord, paragraph 293. Printed page 93.
Yes.
What is media trial? The expression trial by media is defined to mean the impact of television and newspaper coverage on a person's reputation by creating a widespread perception of guilt regardless of any verdict in a court of law. During high publicity court cases, the media are often accused of provoking an atmosphere of public hysteria akin to a lynch mob, which not only makes a fair trial nearly impossible, but means that regardless of the result of the trial, in public perception, the accused is held guilty and would not be able to live the rest of their life without intense public scrutiny. Therefore, my lord, formation of opinion by the public at the instance of media reporting precedes, my lord, a finding of guilt, my lord, by the competent court of law. Because ultimately, my lord, it is the court who can, my lord, find a person guilty or acquit a person. So, well, this is, my lord, the best, my lord, I could find, my lord, the definition of media trial.
Could you continue after the recess? Sir Doctor, I'll request you to be precise, I mean, on the judgments. I mean, yes, make your points.
Yes.
Please make your points, but because there are other important matters, people not getting electricity and all this, rather
But
than
could I
your
say,
media trial.
in that case, my lord, could I say this?
Yes.
I'll make bullet points of the
I
judgment.
think that will be the best thing.
Well, I have got only 1 page. I have a 2 page. I
did that. After recess, I'll be taking this.
So what I'll do is, my lord, in that case, my lord,
Yes.
not to, my lord, waste your lordships, and in fact, my lord, before the vacation also,
Yes.
my lord, I'll type out these 3 pages
Please do that. Please.
and come
Give
back.
a copy to them also.
Yes, I'll come back tomorrow in that case, my lord, as the in the first hour.
So if a copy is given to all of you, I mean, then you also come prepared on that.
Yes.
You make your own bullet points, each of you.
Yes.
And give a copy to Mr. Bhattacharya's,
Yes,
Mr.
yes,
Vilodal Bhattacharya's client also. Junior also.
But whoever, my lord, sends an email or a request to my learned advocate on record, my lord,
Do that, please, because there are so many people involved. Just communicate between yourselves and get a copy. And you are Google India. You say there's no proper service on you because you have been.
They have tried to make YouTube a part. YouTube and my client is completely different. They have served YouTube to my client. That's not the way, Google, the global company, is the company, that should be served. Not India. India is not, actually the YouTube, in any manner.
Mr. Doctor, please take care of that also. 21 probably.
But I'll talk to my learned friend and do the needful.
Do the needful and whatever it is.
But may it retain its position tomorrow, my lord. I won't take, my lord, more. Just placing the judgments will not take me
এগুলো
much.
তাহলে ইয়েতে আপগ্রেডের উপরে দিয়ে দিন hard in part for further hearing tomorrow.
And my lord,
What submission?
That my lord, my
Very good. তার সঙ্গে একটা লাইন অ্যাড করে দাও Various objections relating to maintainability of the writ petition have also been taken by the respondents. For sub next para, learned counsel for the respondent number 21 submits that there has been improper implement, insofar as YouTube and Google India are two different entities and cannot be served together.
Lordship, so far the
Maintainability point I've generally referred to those.
should be contents which have been relied by Mr. Dotto extensively.
Yes, yes.
Lordship, if your Lordship wants to take cognizance of those contents, then possibly the affidavits may be required, Lordship, from
What
our
may be affidavits? May be.
affidavits, because we should get a chance to substantiate our stand on that. That what has prompted us to make those things.
Definitely, affidavits, if you want, I shall always direct affidavits,
If
but
that is required. But
if
your
required,
Lordship says that
I'll grant that opportunity, but I am now,
now your Lordship
if it's possible, I'll dispose of the main writ petition. If it's not possible, direct affidavits, then I'll consider grant of interim order. I'll have to
in that
either
case.
grant or refusal, what?
এটা তো দেখাই আছে, ছবি তোলা আছে।
এক্ষুনি অন হয়ে যাবে। বুঝিয়ে বিল দেবে না তো কয় বছর বলা যায় না। God.
Item 10.
For the respondent, passport authority led by London AEC. Kindly partner.
Yes, yes, absolutely.
For the
Well,
university.
it would have been my pleasure to appear physically, but I'm since indisposed. Kindly allow me to appear virtually.
Absolutely all right. No issues. Yes, yes, Mr.
The
Bhattacharya.
last order passed by your lordship on the application filed by the present writ petitioner regarding the passport with pendency of a criminal case where where a particular boy has committed suicide on the allegation that I refused her to marry. We refused him to marry. Lordship will kindly, that discussion was made by your lordship in the judgment of your lordship at page 26. Passport authority refused to issue any passport. May I place it for your lordship?
Yes, Mr. Bhattacharya.
The learned counsel for the petitioner contend that the petitioner is a 21-year-old lady and has her entire future prospect before her. It is submitted that the petitioner was indicted in a criminal case on the allegation that she had abetted suicide of a young boy of about her age due to her refusal to continue with the amorous affair with the said boy. The criminal trial has already begun and the petitioner has obtained the bail from the competent court. It is submitted that, however, when the petitioner went to the sessions court where the criminal trial is going on, for a no objection in compliance with the relevant circular issued by the government in that regard to facilitate her obtaining a passport, the same was not given by the sessions court. It is submitted by placing reliance on the relevant provisions of the section 6(2)(f) of the Passport Act and the relevant circular October 10, 2019, that nothing in the said provision contemplates any ground for refusal of such no objection to the petitioner. It is submitted that this court, being a court of equity, ought to pass the appropriate order so that the passport is issued in favor of the petitioner. Learned Additional Solicitor General objected to the prayer on several grounds, scores. It is contended that section 6(2)(f) of the 1967 Act is subject to section 5 of the Act. Section 5 provides for application for passport, travel document, etc. And subsection 1 thereof stipulate that an application for issuance of a passport under the Act for visiting the foreign country or the countries as may be specified in the said application may be made to the passport authority and shall be accompanied by such fee as may be prescribed. It is submitted that the section 6 clearly stipulate that the subject of the other provisions of the Act, the passport authority shall refuse to make an endorsement for visiting any foreign country included in clause B or clause C or subsection 2 of the section 5 on any one or more of the foreign countries thereafter. It is submitted that in the present case, the provisions of section 6(2)(f) have not been complied with as well, since a proceeding is pending before a criminal court against the petitioner, where the petitioner is an accused person and is on bail. Learned Additional Solicitor General further states a point that a petitioner has made vague prayer in support of her application for passport. Nowhere within the four corners of the writ petition and a submission of the petitioner before the Sessions Court did the petitioner place anything on record to indicate that she has any urgent need to travel abroad. Such, in view of the absence of exigency, the passport authority was not at fault in not issuing the passport to the petitioner. A perusal of section 6(2)(f) shows that the petitioner on a proceeding in respect of an offence alleged to have been committed by the applicant for a passport is one of the ground for refusal to issue passport to an applicant. Although section 5 contemplates that the application for issuance of passport is for
So what
visiting.
I've gone through it. So 6(2)(f) is there, the circular of the government is there, which says that you have to obtain order from the jurisdictional court.
Before I go to the order part,
yes,
I got the order after your lordship's that order,
was
no
passed.
objection was given. But
what is the present cause?
The striking? They have given me a passport for 1 year.
1 year.
1 year. Normal passport, ordinary passport for 10 years. I
have pendency of the proceeding.
No, what is difficulties is kindly come to page 41 for once.
41.
Admittedly, my lord, this is admittedly, my lord, this is covered by 10th October 2019 notification.
Yes.
Page 41. And they are, my lord, bound by the same and they have acted on the basis of the same. I do not, my lord, find any wrong in giving me 1 year's passport in view of the section October 10, 2019 circular. Kindly come to circular, my lord. My lord, it is quoted GSR 570, paragraph 2. GSR 570E. Kindly, my lord, skip over. Kindly come to clause A 1(2) Roman.
Yes, 2.
If no period either for the issuance of the passport or for the travel abroad is specified in such order, the passport shall be issued for a period of 1 year. So therefore, the learned magistrate, while granting me the permission, did not mention the period. And difficulty has cropped up. Kindly come to the learned magistrate's order at page 36. I need the passport in connection with my service in Indigo. Lordship has aviation where I was a training flight staff, and there I need a passport of normal nature of 10 years, which is a compulsory requirement for getting the service confirmed by them. And they don't allow this 1 year's passport. Therefore, but there was no objection while given. The court did not mention anything. Court did not mention anything.
You have to satisfy me that you will not get the job or the training unless you show that you have a passport for 10 years. Show me that also from something.
I am coming to that.
Yes.
Malada, page 36.
36, yes.
Malada, kindly see, the court did not mention, no objection only has been given. Did not mention the period for which I will be enjoying it.
Therefore, that the A2 will apply.
Therefore, if the court mentioned, magistrate mentioned the same, I would have been in a very comfortable position. But since that has not been mentioned, because the A comes for a period specified in the order referred to above. If this period is mentioned by the learned
Obviously,
judge,
they're right. Yes.
now I approach the learned judge. I approach the learned judge. Page 47, the last order. It starts at page 46. Sorry, my lord. Recapitulation, my lord. This part third, fourth item. On reiterating the order of the Honorable High Court, I have been directed to pass the order of no objection, and the same has been complied. There is no mention of name of passport, nature of passport like specified period or permanent passport. It is found that the petitioner accused, they have already obtained the passport, but for the period of validity is only 1 year instead of 10 years for the Indian citizen. Hopefully, the passport authority issued the same as per provisions of GS subsequent Government of India notification as introduced to give relief to such applicant against whom the criminal proceedings are pending. This court already passed the order without giving any specific period of nature of passport. It is full domain of the passport authority to issue passport as per the provisions of law. This court only see the ensured attendance before the court on the date of hearing. However, it is found that there is no such passport permanent in nature. More so, this court has no inherent power to pass any order in mandamus nature. Accordingly, the prayer for no objection to obtain the passport in permanent nature is said to be misconceived. Prayer for a petitioner as per the petition refused in being. However, the petitioner is given liberty to apply for the passport authority with no objection. This is how it has been dealt with, my lord. But so far as my service inconvenience is concerned, my lord, the
Mr. Bhattacharya, 62F stipulates a rider that you normal courses under normal circumstances you cannot leave the country. Does it?
Is it, my lord, 62F?
Yes.
Kindly come. F speak of that the proceeding in respect of an offence alleged to have been committed by the appellant are pending before a criminal court of India.
একবার দাও।
আর একটা বই দে না, একটা বই, এটা পাসপোর্ট একটা দেবে। Government of India.
Yes, so 62 says that you cannot be issued a passport at all if such a circumstance happens. Proceedings in respect of any offence is pending against you. So under the act, there is nothing to entitle you to a passport for an indefinite period.
Not the indefinite period. I am praying these are normal, ordinary
There is a
passport.
specific restriction under section 62F under normal circumstances.
But
an exception has been carved out by this circular.
Yes.
We have to go by this circular. The maximum period apparently is 1 year, which can be.
No, if no mention. If no mention by the judge. 1 year passport ballot for in respect of a service matter. In respect of whether I will get employment matter, 1 year passport is not the intention of the legislators. The only it has been held to be that the magistrate or the court can.
As Mr. Bhattacharya, show me that your service rules. You are undergoing training now.
I am in training. Training, my lord, I have not been allowed to. The passport is at page 37. Lord, you can look at the passport for once.
So show me from your service regulations that you won't be permitted.
Paragraph 10 of my petition. Your petitioner said that she is working as a cabin crew in an aviation
Why
company.
do you say it's a training? You are working as a cabin crew.
And is a precondition of her service.
You are arguing that you are undergoing training and
which is training hoyeche. Cabin crew not being sent for training for permanency of the service. That is the problem. May I place it, my lord, for your lordship? She is working as a cabin crew in an aviation company, and as a precondition of her service, she requires passport. Since the petitioner could not produce her passport before the employer, she has not been permitted to undergo training, and for which she is losing her seniority in service.
No, Mr. Bhattacharya, show me the specific portion where you have stated that you require a passport for a particular period.
Yes, it required to be mentioned that even during the pendency of the writ, so and so, kindly skip over few lines, and thereafter your petitioner could not participate in the said training since she was not allowed to get the passport, and now though she has the passport, but since the same is a conditional one, that is validity of 1 year, as such same is not acceptable by the employer of the petitioner. Only 1 year passport, my lord, not accepted. It is a student's passport, my lord. Someone is going to, my lord, Dubai for a particular course, or London, my lord, for a particular course, 6 months course. This 1 year, my lord, for student's purpose. For permanent employment purpose, my lord,
So that's the discretion of the criminal code. It's entirely the discretion, the jurisdictional code. You have to apply for renewal after 1 year.
Yes.
Cannot direct the court to grant you a particular.
Normal law speak of, my lord, ordinary passport is for my lord, 10 years. Normal law speak of. If no qualification is made, you have stipulated something in the circular of 570 that if nothing is mentioned by the magistrate, then you will be giving for 1 year. That is why you wanted the magistrate to pass an order that so that I can get it as a normal and ordinary citizen, I can get this passport. And what is
You are not an ordinary citizen. Your matter is sub judice against you. In normal circumstances, 6(2)(f) applies.
What an allegation, Lord. She
No,
will see the
Mr.
future of a
Bhattacharya.
lady, a girl, young girl.
Maybe. Young girl is an accused in a case. That case is pending. Now, already this circular, I mean, this is carving out a rider within 6(2)(f).
Yes, there was a bar. There was a bar.
There is an absolute bar under the statute.
But magistrate's power has been they accepted. If the magistrate say so,
yes, that
then definitely they can give it. But magistrate has said, no, but it is not my jurisdiction. I cannot issue any mandamus. Why this magistrate has said so? He has used some language, my lord, which in fact, my lord, has caused serious prejudice.
Yes, Mr. Chakravarti, what do you say?
My lord, there are 3 things.
Yes.
My learned friend has not challenged the order of the criminal court before your lordship or under 482. Number 1. Number 2, this is not also a challenge of the government circular which gives discretion to the passport authority to grant passport for 1 year when there is no period mentioned. Number 2. That has not been challenged also. Thirdly, my lord, after getting a passport of 1 year, he made another application before the London magistrate, and London magistrate exercised his discretion that he has no such power to issue mandamus. Now, here a question comes that a criminal trial, my lord, has commenced. Nowhere the petitioner is expressing her bona fide that she will be present before the court as and when the court directs. She simply wants a passport of 10 years. Nowhere she expresses her bona fide that criminal trial has commenced. It was committed to the court of session and trial has begun. She, my lord, for conveniently wants to get a passport of 10 years and, my lord, without giving an undertaking to the court that as and when, my lord, it is required, she should be present before the court to assist the court and face the trial. This is simply, my lord, an attempt to evade the criminal trial. And secondly, my lord, kindly see the circular which has been annexed, that is not under challenge. The criminal court's last order has not been challenged. Simplicity, he is making a cause of action against the passport authority. Passport authority cannot. No, these are the issues your lordship will kindly consider.
Well,
as per
only one thing more, my lord. Your lordship is also aware when there is a criminal case pending under section 432 of the Criminal Procedure Code, permission has to be obtained from the court from leaving the country. That is also a mandatory provision in the Criminal Procedure Code.
Yes. Anybody representing the state? State is a party here. You have not challenged the order of the magistrate. State is not a party. You cannot get any relief against the passport authorities. Definitely not.
No, passport authority, my lord, that way I cannot say that they have committed gross error wrong. That they are.
Writ petition is
that-
not
that-
maintainable then.
that
I'll
is-
reject the
that-
writ petition.
The order of the magistrate, my lord, did not exercise his power by saying that I have no power. That is why I am before the court. He has said.
You have not challenged that order in any manner. Not a single line devoted to that.
I mean,
State is
he-
not a party.
he
Magistrate
can-
is not a party.
Magistrate can say so, my lord. It is not that the magistrate has no power to say. I cannot impose something on the
You
magistrate.
have not
that-
challenged that order of the magistrate, Mr. Bhattacharya. Neither in the relief, nor is the state a party. How can I pass any order here? The present writ petition has been filed by a lady of around 21 years of age. Full-stop. The
My lord,
petition,
should I be permitted to withdraw it?
very well.
Because for the future of this girl,
Do that. Do that.
with liberty to file a fresh one.
The present challenge has been preferred. It's a decision by the passport authority to grant a passport to the petitioner only for a period of 1 year. Full stop. Next para. However, it is rightly pointed out by learned additional solicitor general that the order of the jurisdictional criminal court, within the contemplation of the office memorandum dated October 10, 2019, which carves out an exception to section 6 within bracket 2 within bracket small f of the Passports Act 1967 has not been challenged before this court. Full stop. Next para. At this juncture, learned counsel for the petitioner prays for leave to withdraw the writ petition and to file a fresh challenge against the order of the magistrate. Full stop. Next para. Accordingly, WPA 22978 of 2023 is dismissed as withdrawn with liberty to the petitioner to challenge the order of the jurisdictional magistrate, refusing the petitioner's prayer for modification of the no objection granted to the petition. Thank you. No rest to cost. Yes.
11.
11.
My lord, I am for the petitioner.
Yes.
For the state matter. And very short matter, my lord. I was given a work order on urgent basis in relation to election. I have completed the work and the work done
Honey.
certificates are there. They have released part of the claim and they have neither disputed the rest of the claim nor disbursed the money.
Where is the you have given a representation?
Yes, I have given a
Yes, what do you say? Disburse the amount, Mr. Shamantu.
My lord, whole difficulty is, my lord,
What
came-
whole difficulty?
my lord,
Pay the
came-
money.
I came to learn the matter in fixed your lordship only today morning, my lord. That's the problem, my lord.
By tomorrow morning, disburse the amount.
But kindly
So
fix,
you have learned that it is appearing.
kindly fix tomorrow, my lord.
No. I'll direct you to pay the entire money.
But my lord, kindly also.
As a very well, you may have a dispute. You have not raised a dispute. The limited question raised in the present writ petition is that the petitioner is allegedly entitled to dues for work done by the petitioner for the respondent authorities. Whose it is submitted that the dues have not been disputed by the respondents at any point of time, nor are they being disbursed to the petitioner. First of next parallel, counsel for the state seeks a day's adjournment to take appropriate instructions. First of accordingly, let the matter be listed under the heading to be mentioned tomorrow.
Great.
Thank you.
And the service may be kept on record.
Affidavit of service filed today be kept on record. To be mentioned tomorrow, যেখানে বললাম মাধব বাবু, to be mentioned tomorrow for the purpose of passing orders.
The appearance.
Mr. Shamanto, take instruction whether there is any dispute or not.
I will.
Don't raise a dispute just for the sake of it. If previously have not raised any dispute, then I cannot review.
Well,
thank you. Next.
12.
Yes, Mr. Shah.
I find myself against a very formidable adversary. Well, I did not realize this. So, my lord, I'll request my learned junior
It's a
to my lord-
golden day in his life. And in your life, probably.
Of course. my lord.
I don't know whether this has happened in any other.
Once. It's happened once earlier.
Yes.
Entirely by chance.
I coined the expression my learned senior friend in a similar situation, not against my father, obviously, but against my uncle and senior.
I was
Yes,
little
sir.
taken by surprise.
Your repetition should be dismissed.
Yes.
Ex facie. Literally.
Yes.
Tell your lordship, my lord, here my allegation is that, my lord, survey report has not been furnished, my lord, within the timelines that are stipulated within the IRDA guidelines. That is all that is stated, my lord. They say that repeatedly, my lord, the surveyor has called for information which has already been provided by them. And my lord, the frivolous inquiries for documents, etc., particulars are being raised. The survey report has not been furnished. My lord, if your lordship will see, the last query that the letter that is disclosed, where the surveyor is asking for documents and particulars, is pertains to, my lord, December 2021.
You are for the respondent.
I am for the respondent, my lord.
Yes.
New India Assurance.
December 2021.
December 2021, my lord. I am instructed that there are further letters, my lord, whereby even this year, my lord, the surveyor and the respondent have called for further particulars. It is because, my lord, full and particulars are not disclosed that, my lord, the survey report is not being drawn up.
You
And,
have
my
a
lord, the
copy of
final
those
settlement.
communications, Mr. Shah. This can be resolved without direct.
I'll tell you, Lordship, my lord, what the matter is.
Let us see.
My lord, on 26th of September 2021, without going into the papers, 26th of September 2021, my lord, the surveyor writes to me, my lord, there are two properties. One is the Marriott Hotel building and one is the Vivara, my lord, residential complex behind that. These were insured. My lord, during Amphan, they suffered extensive damage. My lord, insurance claims are immediately made. The surveyor, my lord, comes and makes an assessment of the loss prima facie, and it says that, my lord, about 4 crores of rupees is due and payable at that point of time. My lord, there's a letter, it's at page 161. Now, my lord, after that, he says, my lord, final survey report will come. My lord, the final survey report never comes. And my lord, the insurance company has written to me at page 174, where the insurance company on 1st October 2021 has said that we are going to try and release the payment to you before the pujas this year. That was in 2021. We are now in 2023. My lord, I say that, my lord, so far as the, my lord, amounts that have been admitted by the surveyor is concerned, that should be paid to me. And, my lord, the final survey report has to be given to me.
4 crore is admitted.
Yes, my lord. 3 crores 37 lakhs 41,922, my lord, in respect of the hotel. And, my lord, 73,19,573 in respect of, my lord, the residential, my lord, tower.
I'll find it at
My lord, at page 161, my lord, in the first writ petition, and page 201 of the second writ petition. They, my lord, identical otherwise.
In this matter, my lord, there's one issue to be raised here, my lord. There's if your lordship will see the second writ petition, my lord, this is WPA number 10325 of 2023, my lord. There's an assessment.
12 and 13.
I'll just tell your lordship, my lord, on September.
12 and board election.
Yes, similar matters, my lord. My lord, September 2021, there's an assessment that is forwarded by the surveyor directly to the petitioner before your lordship. They consent, my lord, on the 29th of September to this assessment, and they ask for disbursement.
Right.
They say, my lord, we make this concession, or we agree to this assessment, my lord, on the belief that they will immediately disburse. Thereafter, since there is a delay in disbursing, they write a letter specifically, categorically stating that they withdraw their consent to the assessment. So there is no admitted figure of which they can ask for disbursement today.
Your surveyor calculated that amount.
Yes, there's an assessment, but the final survey
From
report
your end, there cannot be any.
There is no offer of settlement from the respondent. That is what happens, man.
Not a question of settlement. They claim a larger amount.
Yes.
4 crore is tentatively 4 crore is your surveyor's report.
Yes.
So why don't you disburse that amount?
My lord, again, survey's assessment is not binding on the respondent. I have to also adopt the assessment.
True.
So as final settlement has to be offered, your lordship is aware that there's a discharge voucher. They say in full and final settlement.
When was the report
I accept.
given? Survey report given?
Survey report has not been furnished, my lord. That is what I say.
Well, that only there
is an assessment, preliminary assessment that the surveyor had directly forwarded to the petitioner, my lord, in September 2021. My lord, I have documents in my possession, my lord. I can disclose it by way of affidavit.
It's
even
your
in
surveyor.
Yes, it is my surveyor, my lord. The difficulty is full particulars are not disclosed, so the final survey report cannot be drawn up because the
you
division
disputed that survey report.
Survey report again, my lord, has
come.
not come. It is a preliminary assessment that was forwarded directly to them. I don't adopt.
Loss suffered in 2021 September. Well, survey report has not come.
I mean, Junior Mr. Shah, you cannot sit on this position for.
Yeah, I do appreciate that, my lord, but this is the genuine difficulty.
I'll give a report within 3 days, Mr. Shah, as to what are your admitted amounts till now, or the assessment, whether you have any dispute regarding that assessment.
I'll have to take the instruction, but 3 days will not be sufficient. Should kindly give me 2 weeks. Let me file my affidavit because, my lord, their prayer is for disbursal, which perhaps without a final survey
and for the final
survey report, that is a prayer, my lord, I can appreciate. But again, I'll have to take proper instruction, my lord. I am told that there are further particulars that are required to drop the final survey report.
Let us also get some benefit during the puja, my lord.
Puja, you cannot benefit because if I mean, it cannot be done like this because if they don't admit that. If it's a preliminary assessment, Mr. Shah, we cannot bind them also on that. He's right on.
No, that is right. But my lord, they have, my lord, come on record to say that, my lord, we are trying to release this matter to you before the pujas of 2021.
Where is that?
Page 174 of, my lord, the writ petition number. And this is 103. It is hotel. Yeah. 174 টা তো এখানে নেই, অন্য রিপিটিশনটা দাও।
29 December.
Well, it is
28 December.
well, this is, well, this is
Yes, yes.
1st October 2021.
In February 2021 to that.
Page 174 of 10325. I'm finding that there's something like that.
Well, this is, well, at page, well, of the writ petition number 10325, page 174, annexure P20.
Yes.
Well, this is, well, the insurance company writing. Well, the subject is claim of Fabworth promoters regarding settlement of claim as per discussion had with you in the presence of your CEO Jhunjhunwala sir and our DGM sir. We had agreed for settlement of the claim before puja vacations. If we receive the survey report in original within this weekend, and you also assured your earnest cooperation in this regard, but unfortunately we have not received original survey report even today, which delays our process. Though we shall be trying hard to keep our commitment, it is possible that we may require further time due to delay in report submission by the surveyor and holiday in between next week.
Surveyor is an independent entity, Mr. Shah.
Yes.
The surveyor has to, my lord, give the report. My lord, that is my.
Can we direct the surveyor? I was wondering about that in a writ petition.
Well, ultimately, my lord, the insurance company has to pay the claim. It is, my lord, a process of insurance, my lord, assessment that, my lord, they appoint a surveyor. So, my lord, if, my lord, their surveyor does not give the report and they hold on the claim for that, my lord, then they have to come up with an explanation for that.
Mr. Shah,
And let me furnish that explanation by way of affidavit, my lord.
Why explanation? The surveyor has to file a report.
Yes, he does. He does have to file a report, my lord. May I just request your lordship to consider two documents once? If your lordship will kindly take page 161 of the second writ petition. That is, my lord, 10325.
Yes.
Page 161. This is, my lord, 29 December 2021. This is the surveyor writing directly to the petitioner based on our survey. Documents received from your end. Please find attached assessment of loss. So this is the preliminary assessment of loss, my lord. Learned senior friend talks about. And my lord, lordship will kindly see thereafter.
So if your surveyor assisted preliminary in a
kindly bear with me, my lord. Two other pages I'd like to show your lordship. If your lordship takes page 170.
Oh, 170. Yes.
This is the petitioner, my lord, writing to the surveyor directly that I do hereby accord our acceptance to the assessment amount for both claims assessed. And then the very next page, my lord, lordship will see 18 February 2020. So, my lord, page 170 was dated 29 September 2021. And then 18 February 2023, my lord, they write, upon reconsideration of the records, we hereby withdraw our consent. So, my lord, the assessment that was forwarded is also preliminary and not forwarded by the respondent. And this acceptance has been
I'll keep
categorically
it 2 weeks
withdrawn.
after the vacation,
Yes,
but by that time you have to file the final survey report.
My lord,
Your surveyor has to do it, you'll have to ensure.
She will allow me to file an affidavit and disclose, my lord, what is the difficulty in the survey report. This is the problem.
Difficulty, then you have to file it within 1 week. No, Mr. Shah, no.
1 week I can punish.
You cannot sit over the matter forever. No. 2021, the exercise started.
Yes, ma'am.
Amphan was long back.
She will kindly allow me 1 week to file the affidavit and disclose, my lord, that what are the particulars that are deficient. That is why the survey report could not be filed. That is my instruction, my lord.
They have to furnish those particulars.
No. Yes, particulars called from them. They have not given full particulars.
I'll do that. I'll keep it at the top of the list with after a week. Lord, you furnish those particulars. Once they furnish the particulars, I'll pass necessary order.
Let them ask me, Lord, what further particulars they. We have furnished every particular.
No, they have to.
If they want it, once again, let us know what particulars they want. We'll give it to them. Let them.
That is what they'll be doing on this. I'll keep
May I
it on
do that
record.
by
I'll
way of
make it a formal order of the court. Learned senior counsel appearing for the petitioner contends that although a preliminary assessment regarding the loss suffered by the petitioner was carried out by the surveyor of the respondent insurer in the year 2021, and a copy thereof was given to the petitioner, no final steps have been taken by the respondent as yet to disburse the necessary amounts to the petitioner as insurance claim. Next para, learned counsel for the respondent authorities submits that there was no agreement on the part of the respondent with regard to the preliminary assessment. Even the petitioner, it is submitted, although initially agreed to the preliminary assessment, subsequently withdrew such agreement. Full stop, next para. It is further contended by the respondent that certain further particulars are yet to be furnished by the petitioner, comma, which might also be delaying the final survey report. Full stop, next para. Learned counsel for the respondent, learned counsel. No. The respondent shall file a detailed list of the particulars which are required to be furnished by the petitioner in the perception of the respondent on the next returnable date with an advance copy of the said list to the learned advocate on record for the petitioner. Full stop. The matter shall be listed on October 17, 2023 at the top of the list for passing further orders in that regard.
Grateful.
Most grateful. Do that. Let us see. I'll pass necessary orders.
শুদ্ধকে থাকতে বলুন, ম্যাটারটা আমি করতে পারবো।
হ্যাঁ, আচ্ছা, প্রথম লাইন একটা অ্যাড করে দিন, both the matters are taken up together due to identity of cause of action.
Grateful.
Two claims.
Two claims.
Two claims, yes.
Two insurance policies, two claims.
Grateful. Thank you.
14.
But I beg to appear for the petition.
Yes, please. What is the matter? What about service? You are
This is
appealing?
my
For this.
affidavit of service, my lord. The postal authorities are the respondents, my lord. So with regard to a financial scheme, the Kishi Vikash Patra and National Savings Certificates were issued.
You are for all the respondents, Mr. Raj.
Postal authority is the primary. My lord, savings certificates and Kishi Vikash Patra was issued in favor of the petitioner. My lord, those were destroyed. Subsequently, I applied for issuance of duplicate certificates. There are 8. 4 of them has been disbursed to me. Upon inspection, my lord, I found there was 4 else were lying. Now, my lord, I have categorically stated in
You want duplicates of the copies of the certificate?
My lord.
Duplicates of the certificate.
They have passed an order. Office orders have been passed. Their Postmaster General has passed several orders directing a Bhangor subdivisional office to issue those certificates. My lord, I'll take my lord to the.
So respondent number 6 is the culprit, according
My
to
lord, there might be a reason. Bhangor sub post office might be inoperational right now. But my lord,
Right.
kindly comes to page 16 for once. This is their initial office order, which directs the certificates to be issued to me. My lord, kindly sees, may I read, my lord? In connection with the above noted subject, accepted IBNC and along with the following relevant documents are returned herewith for early issuance of duplicate certificate in favor of the holder. The indemnity bond should be kept in personal safe custody of the postmaster. The duplicate certificates should be encashed, discharged from the office of the issue only. Necessary guard against the fraudulent use of the duplicate and original certificate should be ensured before the discharge encashment of the certificate. Now, that is the initial office order with regard to 4 of my certificates. Now, my lord, kindly comes to page number 27. This is their third reminder, their own office orders. 27.
This is to Belghoria head office.
Belghoria is the head office which holds the Bhangor as the sub office.
Who has to take steps now? Belghoria.
Belghoria has to take steps. My lord,
Why is
during,
Bhangor in operational? It is not there.
my lord, I have received oral instructions, my lord. It is not, it's the office.
I'll ask Mr. Das. So you want those
My lord,
4 certificates?
My lord, may I, this is the document which was served upon me personally after filing of the writ petition, which goes to show that they have passed the orders, but the subdivisional officers are not complying with the orders. My lord.
Yes, what can be done, Mr. Dasgupta?
My lord, there is no unwillingness to give. My lord,
No, not at all. But but yet she is not getting those.
record to the, can you see paragraph 4?
Unwillingly unwilling.
2004 matter
What
certificates
can
are
be
lost.
done, Mr. Dasgupta, so that she gets the certificates in hand?
Well, they are
Court order will help. I mean, whom
don't
should I
know,
direct?
because maybe because court order may help because my lord,
Then whom should
unless there is a matching record which is not being a guard file, they call it a guard file.
No, what is the problem? Bhangor is not union.
But there is some there is some problem. Possibly the division has changed. Whole division has changed. Baruipur is now possibly in. They are asking this head office to issue the necessary, and the head office is unable to do so because they don't have the record.
Mr. Dasgupta, take instruction. Tell me day after tomorrow which respondent is to be directed. I'll pass the direction. I'll put a time.
So that this issue.
Put a time frame.
My lord.
The petitioner contends that the petitioner misplaced 8 of the certificates regarding different savings deposits with the respondent authorities. Full stop. Regarding 4 of them, comma, duplicates have been issued to the petitioner on the petitioner's request. Full stop. However, comma, insofar as the remaining 4 are concerned, comma, the petitioner has not yet got back those. Full stop. During pendency of the writ petition, comma, a communication was made to the petitioner indicating that the respondent authorities are taking steps to issue those certificates. Full stop. Next para. It transpires that although the respondent number 6, that is the postmaster of the Bhangor post office, was initially liable to issue such certificates, comma. In the meantime, the said post office might have become inoperational. Full stop. Next para. Learned counsel for the respondent submits that there is no unwillingness on the part of the respondents to issue the duplicates to the petitioner. Full stop. Next para. In order to resolve the issue once and for all, comma, the respondents are directed to file a brief report to indicate as to which is the respondent which is now in charge of the functions of the Bhangor post office and is liable to issue duplicate certificates to the petitioner. Full stop. Let the matter be listed fairly at the top of the list on October 16, 2023, when a short instruction stroke report in writing in that regard shall be filed by learned counsel for the respondents.
My lord may not kindly put that instruction. I will bring instruction, my lord, but if on affidavit, my lord, the problem is, my lord, then again,
My lord,
I've not directed.
on affidavit.
That's a written instruction stroke report.
my lord.
But the affidavit of service and the subsequent communication kept on record, my lord.
ওটা লিখে দিন। Affidavit of service and subsequent and the communication handed over in court today be kept on.
I'm grateful, my lord.
Yes, next.
15.
15.
I'm appearing for the petitioner. my
Oh,
lord.
you are there.
License. Yes.
Thank you. Yes.
This affidavit that matter was adjourned therefore.
Thank you. What is the matter, please? Take the microphone closer to you.
The petitioner applied for new electricity connection in February 2022, my lord.
Right.
But till date, the connection has not been given to him. In the meantime, my lord, I should mention this. In September 2022, petitioner was charged for unauthorized use of electricity, my lord. But he paid the fine. He paid the fine penalty for the compounding of offense, my lord. And everything is clear, my lord. But till date, no connection has been given to him, my lord.
The criminal case has been dropped.
Yes, my lord. The offense has been compounded, my lord.
Offense has been compounded.
Yes, my lord. My instruction is, my lord, there is an existing meter. And he is enjoying for that meter. But your lordship, that connection is in the name of his brother, my lord. But now he is not want to share.
But you have to give that reason in writing to her. You have not stated anything regarding that to him, to her, or him, I mean, yeah, her client.
Yes, my lord. I wrote a letter to him, 31st March 2023.
That's
my
not
lord,
annexed here.
no letter received as per my instruction, my lord. Whether there is due to the absence of separate existing line connection. But lordship, that connection is
Have you got a
belongs to his
copy of
brother,
this,
my lord.
that written communication you give to her? Can you get that copy? I'll keep it day after tomorrow. Learned counsel for the petitioner submits that the petitioner was charged with theft of electricity. However, comma, subsequently the offenses were compounded and the petitioner accordingly exonerated. Full stop. Next para. However, comma, electricity connection has not yet been restored to the petitioner. Full stop. Next para. Learned counsel.
New connection, my lord.
Acha, sorry. Electricity connection has not been restored. Na? Electricity connection has not been given to the petitioner in spite of the petitioner's application for new connection. Full stop. Next para. Learned counsel for the distribution licensee submits that the petitioner is already enjoying an electricity connection at the premises. Full stop. A communication in that regard was allegedly issued to the petitioner by the WBACD cell. Full stop. Next para. To enable learned counsel for the WBACD cell to produce a copy of such written communication, comma, the matter is adjourned till October 12, 2023, when the matter shall be listed under the heading upgraded matters for the purpose of passing further orders. Thank you.
Grateful.
16.
16, my lord, this
Yes,
can
Mr.
be
Lahiri, what is
disposed
the
of. Same, my lord, matter. It can be disposed of in terms of your lordship's judgment, my lord. Granting the petitioner liberty to approach the tribunal. Paragraph 39, page 12.
Yes, what do you say?
My lord, similar
As a
matter.
short order, I will not make it so long.
Yes, my lord.
My lord, I am for the minister.
Mr. Lahiri, what have you challenged in the writ petition? In the
Same, my lord, challenge, my lord. entire
Forgotten what you
copy
challenged
paste.
in the previous one.
My lord, page 100.
Saying
Page,
same.
page 100, page 100.
100.
Yes. This is the immediate cause.
Oh, that.
Original.
This is also another development agreement.
And my lord, yes. This memo has subsequently been withdrawn
Keep it with you. I mean, not
in
if not
compliance with your lordship's judgment.
what? Fair.
It of development agreement can use.
Learned counsel for the petitioner contends that the petitioner's development agreement was refused to be registered by the registering authorities, purportedly on the strength of an order passed by the National Green Tribunal with regard to the area in question. Next para. Apart from the fact that the area in question does not fall within the purview of the National Green Tribunal, it is contended by the petitioner that the registering authority acted dehors its powers in refusing to register documents, despite the existence of the order of the NGT. Next para. Heard learned counsel for the parties. It transpires, as rightly contended by the parties, that in a similar matter, with a order dated August 31, 2023, passed in WPA 18398 of 2023, it was directed that there is no bar to the petitioner's development agreement being registered, and a liberty was given to the petitioner to approach the NGT to point out the preliminary objection as to maintainability of the matter before the NGT. In the light of the said observations, WPA 19663 of 2023 is also disposed of, setting aside in the light of a last paragraph, it is further contended that previously a memo dated April 20, 2023 was issued by the additional district magistrate, Malda, to the district registrar, Malda, restraining the latter from registering such documents. However, it is contended by learned counsel for the petitioner that in the meantime, the said memo has been withdrawn in terms of the order dated August 31, 2023, passed in WPA 18398 of 2023. Next para. Accordingly, WPA 19663 of 2023 is allowed, thereby directing the registering authorities to register the development agreement.
This has been registered.
It has also been registered.
Yes.
You only want that liberty.
Yes.
Is disposed of. Accordingly, WPA 19663 of 2023 is disposed of, granting liberty to the petitioner to approach the NGT seeking to add himself as a party, to point out the issue of jurisdiction of the NGT to take up OA number 30/2023/EZ. If such an approach is made, the NGT shall act on a server copy of this order along with the communication of the learned advocate for the petitioner and provide an opportunity to the petitioner to produce relevant documents and give a hearing to the petitioner on such issue Full stop, upon giving such opportunity of hearing and to the applicant before the NGT, comma, the NGT shall decide the question of maintainability of the said OA in the light of the observations made in the order dated August 31, 2023, passed in WPA 18398 of 2023. At the earliest, comma, prior to proceeding further with OA number 30/2023/EZ. No rest to cause, urgent certified copies.
Next matter, there is no development agreement.
Every other thing is the same.
Yes.
What is the agreement?
He wants to develop his.
17.
That is,
yes.
everything is the same then.
Everything is the same, but there is no development agreement as such with any. He is himself doing it for himself in the property.
Then what are you challenging here?
Same order.
Registration of what was refused?
That memo, which pursuant to which, my lord, no registrations were being done. I am developing my
Then
own
this has
property.
become infructuous.
I am developing my own property, and after developing the
Petitioner
property,
is the same or a different?
no,
petitioner?
different petitioner, different land. I am developing my.
This matter has become, you have challenged the memo in this
Yes,
matter.
yes.
So this has become infructuous. You have the same liberty. You cite those orders and get a hearing.
Let the liberty be.
I'll put something in my order.
Yes, page 133 is that memo.
The present writ petition has been preferred, challenging a memo issued by the concerned district magistrate on the district registrar, which is the area, district registrar? Malda, comma, restraining registration with regard to deeds in respect of a particular area, comma, which is allegedly sub judice before the NGT, National Green Tribunal. First of next para. In the meantime, comma, such memo has been withdrawn, and as such, comma, the writ petition has become infructuous. Full stop. Accordingly, WPA 19669 of 2023 is disposed of as infructuous. Full stop. The petitioner will be at liberty to take out the challenge as to the maintainability of the relevant petition before the NGT, before the said tribunal. Full stop. If such an approach is made, comma, the NGT will hear the petitioner for the limited purpose of ascertaining maintainability. Thank you. No rest to cause, sir.
Well, other matters are there in the monthly list with a slight additional.
Those are
therefore I'll not
dismissed on the ground of delay.
No. File similarly.
When those are taken up before the next
Yes,
quarter.
yes, I'll not trouble your lordship.
Don't trouble.
18.
18.
I have got a petition, my lord.
Yes, what is the matter?
Submersible pump, my lord, new connection. My lord.
Have you got an affidavit of services there?
Already have.
Already filed. Very well. You are appearing. Same.
Company. This is our report, lordship.
Yes.
Actually, 4 polls are required to.
4 polls?
Yes. And.
Install the polls.
3 months are required, lordship.
3 months?
Because it's a paddy field. Now crops are there. That's the problem.
I'll give them 3 months. Learned counsel for the petitioner contends that the petitioner's application for electricity to operate his submersible pump has not been acceded to by the WBSCDCL. Full a report is filed by learned counsel for the WBSCDCL which indicates that 3 poles are required.
4 poles, lordship.
4 electricity poles are required to be installed for the purpose of giving connection to the petitioner. Full stop. Next para. The WBSCDCL seeks 3 months time to complete such work due to the ongoing paddy season. Full stop. Next para. In view of such submission and keeping the report on record, comma, WPA 21531 of 2023 is disposed of by directing the WBSCDCL to give electricity connection to the petitioner, comma, subject to the petitioner complying with all formalities and making due payments as per the estimate raised by the WBSCDCL, comma, within 3 months from the date of compliance of such formalities by the petitioner. Full stop. Such estimate shall be raised by the WBSCDCL within a fortnight from date, and a copy thereof be served on the respondent. Full stop. No rest to cause.
I am grateful, lordship.
19.
Yes, 19.
I'm for the petitioners, your
Right.
lordship.
You have state, Mr. Gal. Yes. What is the matter?
The petitioners participated in the recruitment process in accordance with the
Sorry, in the what process?
the recruitment process.
Well,
It's a promotional examination.
Right.
And accordance with the eligibility criteria outlined in the notification dated 14/9/2022. And despite the meeting and all the prescribed criteria, their examination results were unexpectedly low, and which has raised concern about the fairness and transparency of the evaluation process, Your Lordship. In this regard, we are making two representation. One is RTA before the concerned authority, and other two formal representation before the concerned authority. Kindly peruse page number. Our representation is page number 19 and 28, and RTA application in page number 29, Your Lordship.
What happened to the RTI application?
They do nothing, and they only supply me this this memo on the day after tomorrow. Yesterday, day before yesterday, they supply me this report that they forward this letter to the concerned department. But till date, 1 month.
Color is very sophisticated.
Yes.
Milord, I find Milord this
If
SDO
there
has
is loading, there will be no difficulty if there's a power cut or something.
color very prominent. Lordship, this I find this SDO has sent one this instruction full of this memoranda, this and that. But the relevant question is, Milord, my learned friend is Milord praying for non-consideration of representation at page 25, I believe, Lordship.
Yes, sir.
At page 25, that is on Milord 24th July, Milord.
25.
And kindly see the last pages, I think, relevant that they have sent it before the DPO, and this is a letter given to my learned friend. So, Milord, kindly direct this authority, Milord, to consider this. DPO is, I think, district project officer.
So more than one month I've already passed, but it is.
So, Milord,
Direct them to do it within a fortnight. They'll give.
Lordship, I think, based on this, Milord, kindly.
What is that? I mean,
This is what Milord, the authority, SDO, is communicating to my learned friend that your representation is being processed and we have sent it, we have forwarded to DPO for
I'll record it. Learned counsel for the petitioner contends that the petitioner sought certain information to ensure transparency in the procedure whereby the petitioners were
sat for promotional post, Lordship. From
the petitioners.
In the meantime, Your Lordship, another examination which already declared before the online application has already been started. Your
Turned
Lordship.
out unsuccessful in an examination held by the respondents. First of next para, learned counsel for the respondent submits that the respondents are already in the process of dealing with the representation of the petitioner on such score annexed to the petition. The same has been forwarded to the district project officer.
Officer, Milord, ICDS.
To the district project officer, comma, ICDS, comma, Hooghly. Who's up next para? In such view of the matter, comma, WPA 21740 of 2023 is disposed of by directing which respondent should respondent to. DPO is not a party.
Your Lordship, the subdivisional officer and the block development officer.
SDO has forwarded the matter to
DPO.
He is the concerned authority.
Subdivisional officer.
Directing the respondent number 3 to ensure that the representation of the petitioners annexed to the petition are considered within an outer limit of a fortnight from date, and the outcome thereof be communicated to the petitioner immediately thereafter, no otherwise to cause certain settlement.
SDO has forwarded.
But the liability has been fixed on you. You have to ensure that.
Concerned authority.
DPO is not a party here. Why relegate her to something, some another person? You ensure you talk with the DPO. It binds you. Just forwarding it won't, you won't be absolved of your liabilities, sir. Next.
20.
What is the matter? Need not have recorded your submission. Keep that with you for the next round of litigation. Yes, what is the matter?
Malad Durga Puja permission matter, Malad?
Refuse permission. Why Durga Puja? So late in the day.
On private land, Malad. What happens?
Go and do it. Who
Yes,
prevents you?
but then authorities every time created trouble. Therefore, for abundant caution, this time we wanted to take formal permission, but the portal says we have to have earlier years permission. So therefore, only innocuous prayer before my lord, we have made a representation to the SDO that may be considered in accordance with.
20 and 21, doesn't matter,
Hello.
pertaining to the same issues. And in 20, Suman Chandra is for the state. He is not here. And as far as 21 is.
One Suman will do, that is sufficient. Sir.
Sorry, Suman De is here.
Oh, all Sumans are being Shengupta De Ghosh, 3 Sumans in the panel. Mr. Shane has to take some steps on this court.
What has happened that.
So why do you require permission at all? You don't require permission. Yes.
Well, we have got permission from electricity, but pollution, fire and police.
There is a website, ADA Bangla, where we have to approach, we take permission from the state authorities to organize the plan, subject to criteria to be fulfilled by the concerned city authority. That includes fire, electricity, police, and municipality or corporation as applicable. Whenever they are trying to get access to that portal, they are being refused because this is a new puja. And as far as the new puja is concerned, the government has taken a decision that no new pujas will be allowed anymore. Now, they have approached the SDO, and the SDO has informed them.
Government had taken a policy, no new puja will be allowed.
No new pujas.
That's a written policy decision.
That's a position. But in view of that view has been taken by the government, due to which they are not being able to get access to the.
So I'll direct you to take it manually, then they'll apply manually.
SDO has consented that if a direction is passed upon him or her, he or she will consider the matter and take appropriate decision.
How will they consider without an application being made? That is what I'm saying.
They will have to make
Manually, I'll direct that to.
before the concerned SDO.
Very good.
Who is SDO number 4 in this application?
Senate counsel for the petitioner submits that the petitioner wants to hold a private puja, but for abundant caution seeks permission for holding the same, since there may be certain objections from certain quarters, being the relevant authorities. First of next para, learned counsel for the state contends that although there is a policy decision of the state that no new pujas would be permitted to apply online, the concerned subdivisional officer may be furnished with the application and the said authority will consider the same. Footstep next para, in such view of the matter, WPA 22026 of 2023 is disposed of by directing the petitioner to apply to make manual applications before the respondent number 4 physically, for obtaining permission as required to hold the petitioner's puja. Footstep, if such applications are physically made, those will be considered irrespective of the fact that those are not made on the online portal by the respondent number 4, and a decision will be taken thereon within a week from the approach being made by the petitioner. No address to cost are the certified copies.
Item number 21.
Identical
Next
matter.
item. They are identical matters.
2021 same order.
Right. 23 my lord also pertains to my lord permission of Durga Puja. I am for the.
You are wanting the Durga Puja? Refused. 20 or 21 is same order. 20, acha take it, duto take it. Eta hoye geche 2021.
22.
What is the matter?
Petitioner in this matter, Malad. Malad, this is with regard to the NEET examination with regard to PG, Malad, post-graduation 2023. And
So what is
the
it? This
last
should
date.
take some time. Let us come back tomorrow with the
Malad,
application.
today is the last date of the
Oh,
counselling,
then I
Malad.
have to
That's
say,
why it
yes.
was urgently
Yes, what is
mentioned,
that?
Malad.
What is
Malad, in this matter, Malad, there are 3 stages, Malad, 3 rounds of counselling. Once, Malad, the petitioner was successful into this examination. First round, he was allotted a particular college, that is Murmu College in Odisha. Thereafter, in the second round, Malad, he was facing some technical glitch, which
Right.
was informed to the authorities. Malad, due to this technical glitch, Malad, he was compelled to study, Malad, the non-clinical subject, though he opted for the clinical one, that is the ENT. Later on, in the second round, Malad, he was given the non-ENT to biochemistry. So that's a completely non-clinical subject. Now, my lord, even after my lord informing this to the authorities, my lord, they did not take any action. They have, my lord, published the final result with regard to the round 2, where he was again allotted the same college, my lord, since the provisional allotment was with regard to the biochemistry. Now, my lord, round 3 has also started. Now, today is the last day of the counseling. My lord, my humble prayer before your lordship is to give another chance to the petitioner, my lord, to participate in the second round, so that, my lord, his choice filling the colleges which he wants to prefer, my lord, that could be given, and the subject, my lord, selection could be open to you.
Where is the infraction of your right here? Why should you be given that opportunity?
My lord,
And
yes, I was, my lord,
appreciate the fate of the student, but
my lord,
why should it
since
be
my lord, he could not prefer, his choice of selection was some other college, but he was given some other college, and that too, my lord, the choice he had given for ENT. He was even allotted, the first allotment was with regard to the ENT, that is the clinical subject, but later on which converted to non-clinical just because
did
of the
not object
technical
at that
glitch.
point of time?
I have, my lord. I have already written an email with regard to this, my lord. There is another matter which was filed in Andhra Pradesh High Court, and, my lord, the petitioner successfully got second chance for sitting in the second counseling, my lord. My lord, may I
Got a
read?
copy of the judgment?
Yes, my lord, I have.
Please give a copy to your
Yes,
friend
ma'am.
also.
Yes, ma'am. My lord, in this, my lord, I would like to reflect certain facts, my lord.
Mhm.
In this, if your lordship kindly comes to the second page, my lord, so it shows, my lord.
Even if you get an order here,
My
how will you help? How will it help you? I mean, this is the last. Today is the last date of the council.
My lord, if he could be given at least this chance, my lord, to refill, and if an order can be passed by your lordship, my lord, because
What sort of order? Tell me. I'll have
My
to
lord, is-
reopen the entire counseling process.
my lord, that is not possible. I understand, my lord, since the matter
Possible.
was,
The
my
other
lord,
students
pending
will
before.
suffer.
My lord, only with regard to this petition, because in
The counseling will start today or already ended probably.
no, by 12 at night, my lord, it will end.
Yes.
The counseling process.
So even if I pass an order, how does it help you? You attend the last date of the
My lord, I
counseling.
filed the matter, my lord. It was running
see,
before your lordship, my lord.
Appreciate, but nothing. When did you file it?
My lord, it was
At
filed.
that point of time, the second round had been over.
Second round was over by that time.
You are wanting me to reopen it from the second round.
My lord, second round. Otherwise, my lord, I do not have any option because I am compelled
File
to
the
study
petition
that.
after that. It was infractious ab initio basically.
My lord, in the round 3 also, my lord, only those colleges were given, my lord, which I have not even opted for. So, my lord, technically I am compelled to study in that college which I have never, my lord, preferred, and that too performing well in this examination.
What do you mean I have no
My lord,
interim order?
in this order also the same.
To understand what interim order I'll give you. There is no scope of an interim order here.
My lord, a fresh, at least counseling in the round 3 so that
For
those
one
options
person.
can. My lord, in this order also, in the similar circumstances, that
May have
order
been
was
given,
given, my lord. What if your lordship can kindly
That was
pass an
probably
order into this?
at the final hearing stage. Yes, this petition was disposed of.
Yes, my lord, that is
Without directing affidavits, how can
at
I
that
do that?
that to my lord, they have taken an action, my lord. I have written the email that there were technical glitches. They have not, my lord, given any consideration to my email. At that point of time only I gave, my lord.
What was the relief given there? Let us see.
My lord, the relief which was given that she can participate and the recounseling is possible with regard to certain, my lord, with the petitioner, there were certain other candidates who were allowed because they have, my lord, submitted and they have accepted this in the order itself. It is reflecting that there was some technical glitch with regard to certain.
Give me the dates. When did you first make your first attempt?
My lord, my examination was on 5th of March 2023, NEET post-graduation examination 2023. Thereafter, my lord, I have attended the first round of counseling and provisional allotment was given, my lord, on 6th of August 2023. Thereafter, my lord, I joined that college because that was the mandate. I had to join that. And 11th of August, I joined that college, Murmu College, Odisha. Then, my lord, thereafter, they have opened the line for, this is all online, my lord. May I humbly submit. Then thereafter, my lord, this technical glitch had started and the dates I am providing, my lord. They have initially, my lord, they have told 19th August to 23rd of August 2023 is the choice filling date with regard to round 2.
19th to, I'm sorry, the last
19th of August 2023 to 23rd of August, my lord.
Right.
It got modified. Suddenly they have modified. No reasons for modification have been given. 22nd of March, August, my lord, 2023 to 24th of August 2023. Then it was extended till 9 a.m. 25th of August 2023. Then, my lord, the provisional result came in on 28th of August 2023.
I wrote an email on 29th of August.
Provisional results came out on 28th.
28th, my lord. Actually, this was the date for the publication of the final result, but due to this, my lord, the other pending matter, my lord, they had extended the date. And then the final result was published on 31st of August 2023.
I'm sorry, it is too late in the day.
My lord, if
can be
some
done.
relief could be given, my lord.
What relief? Tell me. Today is the last date of the third counseling. There is no other option. I mean, nothing doing now. I can keep the writ petition alive. Whatever reliefs today, I cannot give you any further relief which I cannot give at the final hearing of the writ petition. Interim order, there is no scope of interim order. I can direct short affidavits, I can take up the matter if something can be done for you.
But they have submitted in that writ petition, they have already submitted that there was a technical glitch. Which,
Technical glitch
believe,
is
my
not
lord-
in doubt. Suppose
Yes,
we
my
do
lord.
not doubt the technical glitch.
My lord.
But the other students are there. The entire counseling is over by
But with regard to one petitioner, at least, my lord, if that relief could be given, I'm humbly
what interim order?
submitting.
Tell me, you will be permitted to participate in today's counseling.
Today's counseling, their round 3 is going on. My lord, today it is going to shut anyway.
Then
My lord, if reopening
interim
of
order
the
has the scope
counseling,
of
my lord,
interim order. Then I'll have to grant the relief you're asking for in the writ petition itself. That
my lord,
cannot be
that is
possible.
what I can ask for, my lord. That's the utmost.
Sorry, I'll just direct affidavits, but refuse interim order. I'll say why, because there's no scope.
Hmm.
The petitioner seeks an interim order on the ground of urgency, full stop, due to certain technical glitches, comma, the petitioner could not opt for her chosen option in the NEET postgraduate examinations 2023, even after participating in the first round.
My lord, that
of
will be
counsel-
his, my lord.
First round of litigation. Full stop, next para. However, comma, it transpires that today is the last date of the third round of counseling. Full stop, as such, comma, since there is no scope of grant of any interim order at this belated juncture to the petitioner, comma, the matter is being fixed for final hearing after the oncoming puja vacation, full stop. The respondent shall file their affidavits in opposition within November 24, 2023. Reply, if any, shall be filed by November 30, 2023. The matter shall be listed for hearing under the upgraded matters on December 1, 2023, 1st December. I'm sorry, please come back on that.
I'm deeply obliged, my lord.
I have to take care of it. Yes.
23.
Last appellate side matter today. Yes.
It's an application, my lord, which we have filed, my lord. We have applied before a school, my lord, in Chondipur block.
Other side, you're for the other side? Yes. Oh, you're there.
We have for state school authority because they want.
School authority has been served?
Yes, school of. Yes,
School
my lord, my
authority,
prayer is very innocuous, my lord. This particular.
Your prayers are always very innocuous.
Yes, my lord. I am also very innocuous.
In rem impact.
I am also very innocuous. my lord. Prayer is, my lord, I applied, my lord, for my lord, this particular locality, my lord, in Chondipur, there is no Durga Puja. Some local residents applied before the school authority that we want to have a Durga Puja if the
school premises,
if the playground adjoining the school premises, if that can be given.
Achha.
And in reply thereto, there was no response. Thereafter, a lawyer's notice was served. Now the lawyer was made over with a memo of the school education department, which is there at page 30.
You don't have a right to hold.
No, I am not seeking a right, my lord. I am seeking a consideration.
What consideration?
And my lord, our specific case is, my lord, we have annexed photographs, my lord, that this particular, my lord, this playground also, my lord, this is being used, my lord, for page 32, my lord, for hosting, my lord, political functions, as well as, my lord,
challenge that
a club, my lord.
When a political function is held, challenge.
My lord, a club, my lord, also organizes Monosha Pujo there, my lord. My lord, we undertake, my lord. We will, my lord,
you don't have a right.
No, my lord, we undertake. This is my duty to indicate, my lord. We want a consideration. We undertake, my lord, that is the least, my lord, a citizen can expect, my lord. We undertake, my lord, that the, my lord, studies of the children will not be disturbed in any manner whatsoever, my lord. The schools are closing after the 16th, my lord. My lord, if, my lord, they consider our prayer, my lord, whatever arrangements are to be
Where is
made.
your representation?
My lord, the representation, my lord, will find is the first annexure, page 21. And thereafter, my lord, the lawyer's letter is at page 23, my lord. This is the limited extent to which, my lord, my lord, seeking for. And we have also given an undertaking that after completion of the Durga Pujas, my lord, we'll return it, we'll restore it to its original form, and we'll, my lord, hand over, my lord, the playground, my lord, in its original form, my lord. This is our specific
The school is a government school.
Yes, yes, it's a aided school. It's an aided sponsored school. It's a sponsored school. We have also cited, my lord, instances at page 35 where similar schools, my lord, under the same circle, my lord, they are also, my lord, giving away, my lord, giving out their playgrounds for, my lord, organizing Durga Puja.
Still, it does not create a right.
No, I'm not seeking.
Let us hear the school. Yes, what you say.
I just pray for a consideration.
Consider the representation.
This permission which my learned friend is citing the 2021 part.
Yes, I knew this will come. I have come up with 2023 permissions also. Yes.
No, regarding the other schools.
Yes.
Maybe.
No, in 2023 also.
One thing, our hands are tied because kindly come page 30.
Mr. Bhattacharya, actually, you don't have a legal right to say.
I'm not seeking a legal right, my lord, but I have a legal right, my lord. As a but I am a legal right. I am fortified by my lord's observation made in respect of, my lord, the Durga Puja, my lord, at Newtown. No, a right for being considered, my lord.
That's a public place designated for holding fairs.
It's a sponsored school.
This is a school playground.
Sponsored school, and my lord kindly appreciates, my lord. My lord, the shelter.
But I mean, Article 14 here.
No, my lord, kindly
Playground of a
appreciate, my lord, the ground that is being cited, my lord. They are heavily relying on this particular memo at page 30.
This petition is not maintainable, Mr.
My
Bhattacharya.
lord, for seeking consideration, my lord, in my understanding,
even then,
subject to my lord's kind sanction, my lord, they say, my lord,
there cannot be any consideration of your representation regarding a thing which you don't have a right.
No, my lord, they say, my lord, that it cannot be considered in view of the memo issued by the Directorate of School Education, which is there at page 30. This is what is the only ground, my lord, which has been cited.
Not only that.
Where is that? Where is the refusal?
Page 30, my lord. No, in reply to, my lord, the lawyer's letter, the learned advocate, my lord, by email, my lord, was served upon with this particular notice, my lord, with this particular memo at page 30. Page 30. 30.
This is the Commission for School Education issued this way.
And this is how the email was for.
Rightly so. The other schools, they have also deprecated regarding that.
No, the other schools, my lord, have just handed over the instance, my lord, even of the present year, my lord.
So this is the government order dated 10th April 1970.
Yes, where is the government?
The government order, they accept this education program. Nothing.
No, but other schools are allowing it. What about that? Why?
This is another instance, my lord, of this year only, my lord.
No, Mr. Bhattacharya, sorry, I have to reject you. Where is your this?
This is the government order 1970.
So why are other schools permitting? Why are other schools? You are not answerable for that, of course.
No, but the state is there, my lord.
Yes, Mr. Sen, why are other schools permitting?
My lord, I do not have any idea with regard to that, my lord, other schools, my lord, that Article 14, whether it or not. But my lord, one thing is very clear. First of all, this is not, my lord, the land or, my lord, playground, whatever it may be. The setters, my lord, it belongs to the school authority.
Definitely.
It is not the, my lord, the government land or government school. Now, my lord, this GO of, my lord, it carries dated 18th of December 2018. My lord, it is very clear. If the school authority, my lord, decides, my lord, to agree to any such proposal.
Which one? What is the number?
My lord, that is
1970 government order. Left side.
Left side, there are three.
At top.
Yes, sorry, please continue. Yes, Mr.
So far, that page 30, my lord, my learned relies upon and which my lord forwarded by the school authority in reply to their, my lord, the request to their made. Now, my lord, here it appears that in case the school authority, they agrees to their proposal, then only prior permission. Permission, it, my lord, that, my lord, the preceded by that, they agree to that. Otherwise, now here the school, they have not taken any decision. They have to take a call first. That yes, we do agree. Then, my lord, the question of permission comes. Here only it is stated that if still you do agree to that, then prior permission.
No, Mr. Bhattacharya,
My lord,
rejected.
kindly appreciates, my lord, just in reply, my lord, to Mr. Sen's contention.
Yes.
Page 30, my lord, the memo, my lord, which is the
I'm
sole,
there,
yes. But this has been made applicable even in respect of government sponsored school, my lord. My lord, we'll see, my lord, it has been addressed to, my lord, the district inspector school, all principals of government sponsored and government aided school. So, my lord, this comes under, my lord, in my humble submission, my lord, all the government sponsored schools, my lord, these are not private institutions, my lord, they are all amenable, my lord, to, my lord, Article 226, my lord, because they come within the realm of, my lord, Article 12 of the Constitution of India, my lord, meaning thereby, there, my lord, there is a pervasive control, my lord, of the state authorities, my lord, insofar as, my lord, the running of the school is concerned. In fact, my lord, it is demonstrated from this memo itself that the state is having a pervasive control. The third paragraph, my lord, hence it is hereby ordered to all concerned to refrain from doing the same without due permission from the competent authority in the school education department. So, my lord, this brings my case, my lord, within the ambit of, my lord, Article 226 of the Constitution of India, my lord. When, my lord, non-arbitrariness, my lord, is an integral facet, my lord, when it comes to, my lord, Article 14 of the Constitution of India, my lord. Right to equality, my lord. Right to equality implies, my lord, a right of being considered, my lord, in accordance with law, my lord. There is the no, sir. Not a negative equality. I am not saying that the other schools should not be permitted. I am saying that other schools are doing it. I have made an application. I have a right, a legitimate expectation. Once I have addressed an application, at least that application be considered and disposed of in accordance with law. That is only the limited extent. I opened my case by saying that it's a very innocuous prayer, my lord.
Take a checked order. The petitioner contends that the petitioner sought to hold a Durga Puja festival on the playground of the respondent number 6 school, Mr. Bhattacharya.
Respondent number 7 and 8. 7.
Respondent number 7 school. Push up next para. However, comma, the school did not consider the representation of the petitioner on such score, but the commissioner, comma, school education, comma, West Bengal, a communication dated December 18, 2018, comma, indicated that such matters should be referred.
Not the commissioner, but the school, my lord.
Page 830.
31, my lord.
School forwarded
The school forwarded the my lord, this memorandum.
কোনখানটা ছাড়লাম? Such matter shall be should be referred to their superior authorities, who in turn shall refer such cases to the school education department for further action, comma, which memorandum was forwarded to which authority, Mr. Bhattacharya?
It was forwarded to the learned advocate on record for the petitioner, my lord. Page 31.
Was forwarded to the learned advocate on record for the petitioner. Within bracket, page 31 of the writ petition. Full-stop, it is argued that by virtue of the issuance of the said memo itself, comma, it is evident that the school, comma, which is a government-aided educational institution, comma, falls within the purview of state under Article 12 of the Constitution of India, and as such is amenable to the writ jurisdiction of this court. Full-stop, next para. The petitioner invokes Article 14 of the Constitution of India inasmuch as, comma, allegedly, comma, other schools in the same area which stand on an equal footing as the respondent number 7 school have been permitting such pujas and other political activities on their grounds. Full-stop, next para. It is argued that without any rhyme or reason and without any rejection as such, comma, the petitioner's representation to hold puja on the school playground is not being acceded to. Full-stop, next para. It is contended by the school that by virtue of the government order number ED-88 within bracket 10 dated April 10, 1970, comma, the use of buildings and grounds of government or aided institutions for political meeting or demonstration of any kind is forbidden. Full stop. Next para. It is, thus, submitted that the petitioner does not have a legal right which has been infringed to invoke the jurisdiction of this court. Full stop. Next para. Learned counsel for the state contends that the school playground belongs to the school concerned and there cannot be a blanket right of any person to hold or organize a puja or other festival on such ground. However, the school authorities have the discretion to allow or refuse such request by any person. Next para. It transpires that by virtue of the government order dated April 10, 1970, the use of buildings and grounds of government aided institutions for political meeting or demonstration of any kind is forbidden. Next para. However, the attempt to organize a puja, which is a ceremonial festival, does not fall within the purview of political meetings or demonstration of any kind. Hence, the reliance placed by the respondent school on the concerned government order is misplaced. Insofar as the memorandum number 358 within bracket 49 bracket closed hyphen capital S small c stroke HS dated December 18, 2018 is concerned, the Commissioner, School Education, West Bengal has communicated to the Director, SCERT, West Bengal that it has come to the notice of the said authority that school premises are being allowed to be used for purposes other than education, thereby compromising the principal goals and objectives of furthering the cause of education, wherefore those buildings and infrastructure infrastructures are meant. Next para. However, in the penultimate paragraph of the said communication, it has been indicated that all institutional and school authorities shall refer such cases of use of school infrastructure and premises for non-educational purposes to their superior authorities, who in turn shall refer such cases to the school education department for further action. Next para. It is well settled that a citizen does not have a right to perform religious worship on a particular plot of land by virtue of Article 35 of the Constitution of India. However, the Durga Puja festival in West Bengal is wider in periphery than a mere religious worship performed with regard to the deity, but also has social connotations. Next para. Be that as it may, even if other schools in the area, which are government aided or otherwise, have been permitting puja to be organized in their premises, the same does not create any legal or constitutional right in favor of the petitioner. Next para. The situation might have been otherwise if the ground in question was specifically designated to hold fairs or public festivals, etc. However, a school playground, by no stretch of imagination, can be said to be a public ground designated for the purpose of holding festivals. Next para. Even if a school playground belongs to a government-aided school, the same ipso facto does not convert the playground of the school, which is an educational institution, to a public, free for all, hyphenated, free for all area where any and everybody can seek to organize any festival whatsoever. Thus, I do not find that any legal or constitutional right of the petitioner has been infringed by non-consideration of the petitioner's representation by the school authorities for holding a puja in the school playground. Hence, there is no cause of action for the instant application to interfere under Article 226 of the Constitution of India, full stop. Accordingly, WPA 22952 of 2023 is dismissed, full stop. However, comma, it is made clear that nothing in this order shall prevent the petitioner or any other citizen of the country from pointing out any other infringement or illegality with regard to the violation of any state circular regarding puja being organized on school playgrounds. Full stop. If such a challenge is preferred before the appropriate forum, comma, nothing in this order shall prevent the appropriate authorities to court to take steps in that regard. No rest to go.
Grateful to will it be my lord's pleasure, my lord, to instead of dismissing it, my lord, to dispose it of, my lord, and my lord, this will not preclude the school authorities if they want to, my lord, to consider, my lord, the representation.
You don't have a right.
Very good. My lord, one more thing, my lord, it's my duty as an officer of the court, my lord, since my lord is hearing, my lord, a lot of puja related matters, my lord.
Yes.
Now the state, my lord, is heavily relying upon a judgment of the Honorable Division Bench of the High Court passed in WP number 21481 of 2005. That was passed in a public interest litigation, and a plea is being regularly taken by the state government now that in terms of this particular order, there cannot be no permission given for holding any new puja. So, my lord, this particular judgment, my lord, there were subsequent orders.
New puja, I have my doubts because whether
no, my lord, I have faced, my lord, similar situation, my lord. So, my lord, that particular order, my lord, which was being relied upon by the state, that has been diluted by subsequent orders, my lord, and also recorded by our honorable court, my lord, that particular ban regarding organizing new pujas was in respect of only the year 2005. So, if my lord feels
no,
it proper,
I'll misplace that, Mr. Bhattacharya, if it is
this I understand, my lord, will be handy, my lord, for
very handy, but
effectively disposing
I'll
of.
remember, at least remember this dilution, and I can insist on the state whenever those matters are taken up. For
I have made a search, a thorough search, my lord.
Thank you very much.
The order which was being referred to by the state, my lord, that is not available in the server also. So it is only available with the state, and the subsequent orders are also not available, but in a subsequent writ application, my lord, those orders were indicated.
Sen is cursing you behind. এই ওটা কপিটা রেখে দিও, পুজো ম্যাটার হলে এটা ধরিয়ে দেবে। থ্যাংক ইউ। ওটা কেটে দিও।
Please keep this on Monday or Tuesday. Monday মধ্যে পারবে? Monday, please keep it on Monday, my lord. I'll file I'll challenge this.
Difficulty. I don't have specific instructions on that, my lord. But with
I'll hand over a copy.
With respect to this writ, my lord, I went back.
This is your order.
I understand. I should have it. I don't have the instruction.
Lord, it was passed on 12th of September, supposedly.
Review committee?
Supposedly. And served on now. Lord, posted on 30th according to them. Not unfortunate, but not just to avoid technical complications. Keep it on
Your client should have been more cautious if that was done. Take instruction on this also.
I will. Definitely.
When it was done in September, should have been communicated earlier or at least through you.
Definitely.
Obviously, we were not aware. Obviously, we were not aware. That would be the first ground we'd be taking others.
Definitely, it should have. But I was.
Yes, what were you going to say?
I was only impressing upon your lordship that I understand they will challenge this now, but with respect to the identification committee, which is the subject matter of the writ application, which your lordship is hearing, that was your lordship recalls that point of resolution being passed, my lord, the approval of the resolution plan, that identification committee order was passed prior to the resolution plan. So therefore, on the basis of that, my lord, I was allowed to proceed against the. I've made a small list of dates. I will take your lordship through that.
Let us come back on Monday. Monday, can you do it? Oh, Monday, yes.
Yes.
Today
Yes,
on
sir.
Tuesday.
Next Monday.
Very good.
I'll do it.
On the prayer of learned senior counsel appearing for the petitioner, comma, in order to enable the petitioner to challenge review committee order, which has apparently been drawn up, comma, the matter is adjourned till October 16, 2023.
But one humble prayer.
If you file that, just please give the number.
I will not.
Yes,
One humble
Mr.
prayer, not let them not give effect to this not a review committee decision. Pending not this writ, the matter being heard, not
by
they
Monday,
took
nothing
a
will-
adjournment, not they took a adjournment. Not your lordship has seen,
I have
not
not
pending the
taken an
matter,
adjournment.
pending the matter, not it's communicated. Your lordship
Mr.
knows.
Bachata, you have not yet challenged it. I mean,
I understand. But if your lordship,
They aren't
if
enjoying
your
any
lordship
stay.
says,
They-
not I
they
can
should have
put in a
obtained that
supplementary
stay.
of affidavit here and now. I can put it in here and now. I have affirmed it and brought it.
Oppose that, my lord. On a technical ground, but I'll oppose that.
I understand that he,
Possibly
your
this- if
lordship,
they have not taken effect so long, I mean,
they've served on it not after 4th. But and in the meantime, my learned friends had also asked for an adjournment of the matter.
after line at it is expected that in the meantime, comma, no action will be taken by the respondent authorities on the basis of the willful defaulter declaration which has been impugned in the present writ petition and or any further action, including any review committee order, comma, which might have been taken pursuant thereto.
Obliged to you.
Come back on Monday, we'll complete the arguments. If you can just in a nutshell, half page, 2 page
I'll do
written notes of arguments, both of you.
I'll do that. I'll do that. But I understand it's the
Very,
last
very
week of
short,
court.
just deal with all. And please take instruction on this review committee.
Item number 3,
I've handed up a copy.
Bishambhar Saran versus Punjab National Bank.
Yes, sure. So you say, Mr. Chaudhary, that the basis of all these FIRs and all these were the willful defaulter proceeding and the fraud proceeding.
Yes,
So if that goes, these also go.
Yes, my lord, what has happened really, my lord, the writ petition is proceeding on the premise. In fact, the last demand of justice which we made is that you have withdrawn the willful defaulter proceeding. The complaint is still there. Why have you not withdrawn it? Because consequential action should go. Now, my lord, the bank can possibly take 3 stands. Number 1, it is pursuant to the willful defaulter circular. My lord, my endeavor will be to show that it was pursuant to, because the chronological sequence will establish that. Number 2, it is pursuant to the circular of declaration of fraud, because that also there is a provision. You can lodge a complaint to CBI. And number 3, it is irrespective of any circular. I have done it independently.
That is the best case yes.
So there are 3 possible stands
Right.
which the bank can take. Now, my endeavor will be to show that irrespective of whichever stand they take, my lord, this complaint should have been withdrawn. Because, my lord, the necessary ingredients which have been mentioned in that complaint are all non-existent as of today. That is my endeavor. That is why I say that this is arbitrary. Because, my lord, what has happened, the CBI has misconstrued the fraud order, and, my lord, it has registered in 2023 the 21 complaint, which was, my lord, lying dormant for this time, thinking as if there is a bar from the Delhi High Court. But, my lord, if that is so, the Delhi High Court, my lord, interim order was passed in 2021 prior to the bank writing this complaint. I'll show that. My lord, kindly take a list of date, my lord. I have hurriedly, my lord, I forgot to put in the pages. I'll give my lord. After copy though. Well, this, my lord, most of the dates lordship will find.
Yes.
Page ta this withdrawal. Lord, if lordship takes the circular by which the notice was withdrawn, Lord, kindly with the list of dates, my lord, kindly open, my lord, page 191.
Yes.
191, lordship will see, my lord, this is the communication of 9th November 2022, which is really communicating a decision of a meeting held by the review committee on 29th September 2022. Sorry, identification committee. In terms of RBI master circular dated July 1st, 2015, a meeting of the committee for identification of willful defaulters bank was held on 27 September 2019. Well, that is the first date in the list of dates. So this is starting in 2019 when the committee for willful defaulters identification committee have the meeting. Identification committee concluded that events of willful default in the borrower's account had occurred and gave its approval for issuance of show cause notice for identifying the following persons as willful defaulter: Visa Power Limited, the borrower, and Bishambhar Saran as the promoter director, and there was the other promoter. Accordingly, show cause notice, show cause of 15 days was issued on 2nd July. That is the second date in the list of dates. To the above borrower, Visa Power, and its above named directors on the following ground. Diversion of funds, Lordship will find the transaction audit report of Deloitte Tomatsu so and so, Visa Power had paid so and so, siphoning of funds. Then unauthorized disposal, removal of charge assets. And all these are based on the transaction audit report, which is mentioned over here. Then kindly sees, thereafter, the identification committee in its meeting dated 29th May 2021, 29th May 2021 is item number 3 in the list of dates. Issued order identifying the borrower and its directors as willful defaulter on the above grounds. Thereafter, representation dated 27th July 2021 in the form of WPO so and so was received against the identification order in compliance of the direction of the review committee in its meeting. This WPO, my lord, why this was done? There was a writ petition, my lord, and an order was passed. Lord, I must show your lordship that order. That is 26 July 2021, which is annexed to the writ petition. Page ta diye dibi. Lordship just gives me a moment. Yes, my lord, page 217. That is, my lord, item number 6 in the writ petition.
Yes.
Order of Justice Bosha, 3rd August. An order of identification committee dated 29th May is under challenge. Learned advocate appearing for the petitioner submits. Identification committee did not consider reply to show cause. He submits. Although the remedy of approaching review committee is available, but since the identification committee did not consider the reply to show cause, it would be appropriate that court directs the identification committee to consider the reply to show cause and thereafter arrive at the decision. According to him, the petitioner
So you are relegated to the review committee by
Yes.
this.
Then, my lord, the
But
review committee
peculiarly-
considers this
Yes.
and withdraws it. Now, kindly see, in the
No, not
meantime-
review committee, the willful identification committee, first
No,
committee
my lord,
again
kindly
withdraws.
see, I show you, lordship, my lord. The review committee asks them to reconsider it again.
In between that was.
Yes, I'll show that. In between, my lord, what happens is, in between comes the complaint, which lordship will find. This should have been, yes, the complaint of 18 June 2021, which lordship will find at page 59. That is, my lord, item number 4. So, willful defaulter, item number 4.
Yes.
So, after, my lord, willful defaulter, the committee declared me as a willful defaulter in terms of the RBI circular, my lord, which is starting at page 38 of the writ petition. I have shown your lordship, my lord, there was a provision of, yes, criminal proceedings.
Yes.
And my lord, that is at page 48, criminal action by banks. And it was there. But it says that you are to put in a transparent mechanism, whatever you are doing, you must inform so and so. So, my lord, the writ petition proceeds on the premise that this was then done because willful defaulter action was initiated. And whatever, because, my lord, lordship will find from the narration which has been made in the complaint, whatever were existent as on that date, those narrations have been mentioned. But after that, each of the cause of action which were mentioned as existent on that date, my lord, the cause of action has got altered.
Willful default, fraud, as well as that LOC.
Everything
all
was
three
there.
were
Yes, everything was there. So, my lord, so in 21, they did. Now, fraud, my lord, I have my submission because in the meantime, I am proceeding now, it's on the willful default. Now, my lord, kindly let me finish that. 192, kindly see the deliberation. The committee noted that willful default proceedings in account was initiated on, I'm sorry, my lord, the previous paragraph. Thereafter, representation dated 27 July in the form of WPO was received against the identification order. Now, in compliance of the direction of the review committee in its meeting of 29th April, the representation was placed before the identification committee for its consideration. So the review committee directed the identification committee to consider.
Right.
Now the identification committee says, the committee noted that willful default proceeding in the account was initiated on the ground of diversion of funds, siphoning of fund, and unauthorized disposal of charged asset, the basis of which is transaction audit report of Messrs. Deloitte Touch Thomas II India LLP. Committee further observed that NCLT Kolkata, with a order dated 25th July 2019, has held that audit report of 24th August 2018 of Deloitte by itself, without any independent material on record, does not prove any preferential, undervalued, and fraudulent transaction. This is, my lord, not only the observation of NCLT, the bank committee has also agreed to this. It does not prove independently any of these transactions. The committee also took note of the fact that appeal filed by the RP against NCLT was not entertained by NCLAT, and hence the order of NCLT has attained finality. The committee observed that the present proceedings of willful default have been initiated solely on the basis of the transaction audit report dated 24th August, and no other report or document has been relied upon. In view of the order of NCLT Kolkata of 24th August, which has attained finality, bank cannot solely rely upon the audit report of Deloitte for identification and declaration of borrowers as willful defaulter. The identification committee, headed by the executive director and consisting of other members, that is Chief General Manager, Deputy General Manager of bank, on the basis of deliberation and records available, decided to drop the present willful default proceedings against the borrower and its directors, so and so, to re-examine with liberty to the zonal, this is, my lord, the zonal branch office, to re-examine the willful default aspect in account on the basis of independent documentary evidence, if any, which proves willful default as per RBI Master Circular. This supersedes the order of the committee. Now, my lord, this is the decision of the committee of the bank, which had initially done it, and it is immediately thereafter, my lord, the complaint was lodged. Now, my lord, now if lordship peruses the complaint is a verbatim reproduction of that audit report, and the allegations are, lordship has already noted it, I had placed it. The complaint starts at page 59, and will kindly straight away come to page 65. For after the tabulation, forensic auditor was appointed during CIRP process. Findings of the forensic auditor disclosed following fraudulent transaction. And this auditor is the same, that same what is referred to. And lordship can take it from me that all the particulars right up to page 66. It's a verbatim reproduction of the forensic audit report. There is nothing else. Then, in view of the fact, it is clear accused persons have jointly hatched. I am reading the last paragraph of 66. Against public banks to cheat so and so, accused persons of so and so. Role of statutory editors, so and so. And this is the only part. This is if there any staff is involved, my lord, the complaint doesn't say anything about the staff. And then kindly see, from the above facts, it is clear Visa Power in connivance has diverted and siphoned funds. Accused along with. My lord, only basis of this complaint is the forensic audit report, because, my lord, in between May 2021 and June 2021, there was no other document which was there in the custody of PNB from which these, and my lord, lordship can compare. These are, in fact, my lord, the bank can also say it's a verbatim reproduction of what was there, my lord, in the NCLT proceeding. These are the self-same allegations. Now,
what happened to that fraud identity?
I'll come to that, my lord. So this is the first aspect.
Yes.
So, my lord, if the willful defaulter goes,
FIR goes by virtue of NCLT and willful defaulter second.
Willful defaulter, my lord, FIR, my lord, has been lodged now. I am in the writ petition.
We are on the complaint.
We are on the complaint.
The complaint
because, my lord, PNB was duty bound. Once they withdraw the proceeding, they should have also informed, because when the statute, when the RBI guidelines casts an obligation, it also, my lord, that should be read into that once you withdraw the willful default proceedings and those cause of action or the ingredients of cause of action are no longer there, you should also inform the CBI.
But similar provisions are there in the fraud.
I come to that.
You place those.
Now, so far as this is concerned, my lord, it is proceeding. If it is willful default, then my lord,
Willful default, you have got it.
they should
FAR
withdraw it.
goes, willful default.
Consequential should go.
Very good.
Now, my lord, the other aspect is there was a similar RBI circular, classification of accounts as fraud. Now, this was the subject matter of challenge in the Delhi High Court.
Right.
In the Delhi High Court, where Lordship has been pleased to see the order of Justice Jalan,
Yes.
which is annexed there. My lord, I want to first show your Lordship, my lord, an interim order was passed.
The Justice Jalan's order is annexed to the.
It is annexed, my lord. I'll come to that.
Placed it on the last page. Either you or Mr. Dutt.
Yes, Mr. Dotto had placed it, my lord. Mr. Jalan, Justice Jalan's order, my lord. I am showing now what I handed up is the interim order when the writ petition was first moved. The reason why I am saying this is to advance my point that this complaint of June 2021 was not pursuant to the fraud circular because there was an interim order directing them to maintain status quo on this aspect.
On the fraud circle.
But my lord, this is this has other proceedings, you can do it. Lordship will find that if Lordship takes the order of Justice Jalan, 9th April 2021, kindly comes to the second page. Also now. My lord, kindly come to the second page, my lord, paragraph 6.
Mr. Chaudhary, I've read it. I've got it. You're right. Yes.
So, my lord, this is, and my lord, the last paragraph clarifies it. Is free to issue show cause and pass reasoned order, so and so. It is also. Now, my lord, pursuant to paragraph 8, my lord, nothing has been done. Then, my lord, comes the final order of Justice Jalan, Delhi High Court, which Lordship has already seen. 177. It is only on the ground of violation of natural justice. There is no. And my lord, they are at liberty that after compliance with that, that was given in the interim order also, paragraph 8. They could have initiated. The final order also says that nothing will prevent them. So, my lord, two situations are, my lord, obviated. And even after the final order, if they think that the account is fraud, my lord, they will just issue a show cause, give a hearing to us, and then again classify it as fraud, and then again trigger the entire, my lord, process of lodging an FIR and whatever it is. So, my lord, it can't be either due to the willful default and notice. It can't be even for the fraud, pursuant to the fraud circular, because as on that date, on 9th April 2021, there was an order of status quo vis-a-vis that because it was pending challenge in Delhi High Court. So, the only other possibility now remains is that irrespective of these two circulars, independently can the bank do it? The answer is in the affirmative. Bank independently, anybody can go to the police and do it. Now, kindly see the complaint once again at page 59. If what you have stated independently on that date, assuming it is independent, if they take the stand, it is independent of that. And, my lord, your bank has subsequently, my lord, withdrawn that because of what I read, that no, on that document you cannot proceed. If you have independent, you can go ahead. My lord, is it not the duty of the bank to inform the CBI that, look, our bank has taken a decision that because of this, only on this you cannot confer any liability on them. If you have, we don't have any independent proceeding, this is for your information, we have withdrawn. Because, my lord, from page 65 to, my lord, page 67, my lord, 4 paragraphs, it is exactly that. There are 2 further ingredients in the complaint. The second is a lookout circular has been issued by Bank of India against the accused person, not this. My lord, all lookout circulars have been quashed against Mr. Saran. So these are also no longer there. Then, my lord, the third allegation was a fraud. Fraud was stated. My lord, kindly see.
Circular is not actually a component of the complaint.
No, that is why I am
just
saying,
to embellish the complaint.
My lord, whatever had happened, as on June 2021, the bank had narrated these facts. Now, my lord, rightly they had narrated.
Yes.
My reading is that it is pursuant to the willful default circular because they had really complied all the steps. Now, my lord, I am looking at all situations. I am looking at it can be either by willful default circular, it can be either or by the fraud circular of RBI or independently. So first two I have shown that it cannot be. Now, independently, if it is assumed this can be, if your entire factual background that you have narrated, you have yourself withdrawn it. And my lord, they were supposed to inform the authorities that I have withdrawn it. On the same transaction audit report, my bank has taken a decision that you cannot, if you don't have independent documents, you can't proceed, and all this only independently you should proceed. This should be informed to CBI. And my lord, this fraud account is also now, it has been set aside by the Delhi High Court order. The page 68, complainant bank has declared the account as fraud and reported the same to RBI on 11th June 2019 for so and so. So this 11th June action has also gone. So, my lord, now that the CBI is taking, my lord, action on this, they should at least, all we are seeking is they should inform that we have dropped the proceedings on this and this is our observation.
Mr. Chaudhary, what was the trigger of registering the FIR so late, according to you?
No, so far as now, Lordship will see the FIR.
Happened after that, yes.
FIR, Lordship will see at page 196. The CBI has given only one paragraph of explanation. CBI construed the Delhi High Court order as not taking any coercive step. And after the Delhi High Court order, the CBI has done. But, my lord, I am not, my lord, we have not challenged anything on FIR, my lord, because I understand, my lord, the limitations in 226, apropos, my lord, 482 of CRPC. But, my lord, kindly see, my lord.
There is no limitation.
No, I am only saying this. My lord, I am only saying this because, my lord, kindly visualize, if I directly go for 482, my lord, that immediately response will be, bank has not withdrawn it. So we have to proceed with it. The allegations are there. The complaint is there as on date before the investigation agency.
With the facts before you, Mr. Chaudhary, if you had at all challenged the FIR, the writ court would be the only remedy before you prove.
No, that is why, my lord, over here, my lord, my prayer would be twofold. If Lordship is pleased to, my lord, quash that complaint, then consequential action.
What have you sought here?
My lord, I have asked for quashing of the complaint and consequential directions for that, which should cover the FIR. I am being very candid, my lord. We have couched the relief widely. Let us put it.
Yes, very well. Yes.
So, my lord, now if Lordship sees the FIR 196,
yes,
lord, the reason given by the bank is at paragraph 8 at page 197. Which, my lord, the reason given by CBI has nothing to do with the complaint over here. Kindly see. Due to delay in pendency of matter before the Honorable Delhi High Court, filed by accused Vishamba Saran in the matter of declaring the account of Visa Power as fraud by Punjab National Bank, the accused challenged the bank, challenged that the bank is required to give the opportunity of being heard to the borrower before declaration of as fraud in the master circular issued by RBI. The Honorable High Court has directed to maintain status quo with a order of 9th April 2021 and continued the same with the subsequent orders. So, my lord, if this is the fact, 9th April 2021 status quo was there. How can they now take cognizance? It is status quo. The complaint wouldn't have been taken. The complaint is of June 2021. Kindly see the complaint is also, my lord, there at page 204, 18 June 2021. I showed your lordship from page 59, but since, my lord, it is annexed to the FIR, it is also there, page 204.
Right.
It is 18 June 2021. So if there is an order of status quo and they take cognizance of the complaint, it is in direct violation and continued the same with a subsequent order. Subsequent to the order of Honorable Supreme Court of India in SBI versus Rajesh Agarwal, Delhi High Court with a order of 12th May set aside action taken by the bank declaring the account of borrower as fraud on the ground no opportunity of hearing was given, but clarified any FIR which has been lodged, the proceedings remain effective. This is, my lord, lodged prior thereto. Prior to the Delhi High Court, writ remains unaffected. Not an FIR lodged or not a complaint, no FIR was there. But prior to this date, after this FIR is coming after Delhi High Court order. So this Delhi High Court order, this last line is also not, this is, of course, my lord, CBI has given that. But my lord, I am showing that the bank complaint, which is of 8 June 2021, first, it is in violation of the order of Delhi High Court if the bank contends that I have made it pursuant to the fraud circular, RBI fraud circular, in violation of status quo. The only possibility or explanation the bank can have is I have an independent right to lodge a criminal complaint and I have done it. Now, nobody is disputing that, my lord, it can. But my lord, independent right, you had lodged it in 2021 and you forgot about it. You did not take any steps. Now that you have yourself withdrawn the willful defaulter notice and have made those observations.
There is a difference between a complaint and a first information report.
Correct.
The language of the Delhi High Court was, it is made clear that any first information report which has been lodged and proceedings pursuant thereto, which will be charge sheet and criminal trial, remain unaffected. At that point of time, first information report.
Nothing was there.
First information report is lodged in certain cases only. We have to see whether there is cognizable offence.
Correct.
So even this does not probably.
This is apropos an explanation given by CBI, but we have not made CBI a party. That is why I am only on the action of the bank.
If you did not make the CBI a party, how can you challenge the subsequent registration of FIR?
No. I am
at the behest of the
I am saying, my lord, if the complaint goes.
If the complaint goes, still the FIR remains unless challenged.
No, that is true. Let the complaint go, my lord. We will inform the CBI. The
We'll
complaint.
take care of the FIR.
Yes. And consequential orders we have asked for. But if lordship feels that not making CBI a party, that will not, my lord, the complaint should go. Because, my lord, the violation of Article 14 is, my lord, here, my lord, the bank had a statutory duty when they were following RBI guidelines that you declare willful defaulter, you file a complaint in terms of the RBI guideline. But after you withdraw it, you don't inform CBI that I have withdrawn it. And I have observed that this very self-same report on its own, you cannot have any proceeding until and unless you have independent documents. Those are my consequential direction, my lord, I just cite, my lord, one judgment of your lordship in Amit Kumar Kejriwal, 18th July. Consequential.
Then CBI had to be a necessary part.
CBI had to party chilo and others.
CBI must have been party there.
Here, my lord, I am.
What was this? This was regarding what?
My lord, lordship will kindly come to page 2. Well, in fact, page 1, para 2, lordship says, it is contended that such classification without giving a right of hearing to the petitioner was palpably Dehode's law. Learned counsel places reliance on that State Bank.
The relevance is, Mr. Chaudhary, that it was my judgment.
No, I am on page 8.
It's not relevant.
Page 8. All consequential action taken by respondent pursuant to classify are also
the usual thing. But that makes your writ petition bad for non-joiner of CBI research. If you seek for that.
Subject to correction, I believe in this matter also only bank was a party.
CBI was not there. FIR was lodged, I don't think so.
Yes, FIR
it has been considered. Then it's there. Show me that.
Page 2.
Yes.
Last paragraph. That apart, by placing reliance on the relevant documents, including the first information report. But, my lord, I must be candid, my lord. If the complaint goes, my lord, if the complaint is quashed, my lord, all I have to do is I will communicate it to CBI. They will not, because, my lord, they have woken up late 2021 charges which are now no longer in existence.
They are not taking any risks now.
My lord, it is a stigma, my lord. I am fighting, my lord. This
CBI is not taking any risks now. That is what I say.
That is.
Yes. Mr. Shen.
Lord, the allegations against Lord, the writ petitioner are known to your lordship, having heard the petitioner in different avatars over different matters. Essentially, diversion of funds, siphoning of funds, unauthorized disposal, removal of charged assets. Now, lordship remembers
the judgment of the Honorable Supreme Court, which dealt with the matter where, my lord, the wife of a doctor passed away due to medical negligence. He had multiple forums available to him on that set of facts. He initiated proceedings before the Consumer Forum. He initiated proceedings before the Medical Council. He initiated proceedings before the criminal courts. All three went ahead. Ultimately, he got relief insofar as the proceedings before the Consumer Forum are concerned, and there was direction for compensation at all. Not the pith and substance of what I would like to submit for your lordship's consideration is that the same set of facts can give rise to causes of action under different statutes and enable initiation of proceedings under different statutes, all of which can have their own conclusions depending upon interpretation of that particular relevant statute, independent of each other. The same set of facts can give rise to different proceedings under different statutes. And there's no bar in that. Now, Lord, so far as, Lord, the proceedings with which we are concerned here, the first set of proceedings, perhaps in order of time, is the proceedings before the NCLT. I'm taking the order of time as to when the proceedings ended rather than when they started, because that's a little amorphous. We know when they ended. So far, as the proceedings before the NCLT is concerned, if your lordship is kind enough to take page 113 of your lordship's brief. Volume 1.
Yes.
Now, the orders of the NCLT starts at page 110. And if your lordship is kind enough to take paragraph 5 at page 113,
Yes.
110 is the order. This is the final order. And now please take page 113, paragraph 5.
Yes.
Pointing out the details as to how the above transactions are either fraudulent or preferential or undervalued. The liquidator requested this authority to direct the respond numbers 1 to 3 to contribute various sums ranging from such and such to such and such, and also to direct the IBBI to file complaint against the respondent in special court under section 236 of the Insolvency and Bankruptcy Code 216. Now, if your lordship is kind enough to have a look at the Insolvency and Bankruptcy Code, section 236 relates to proceedings in relation to offences. If your lordship kindly takes section 236.
Yes, please. Yes.
Notwithstanding anything contained in the Code of Criminal Procedures, this is apart from the proceedings under the criminal procedure. Offences under this code, that's the IBC, shall be tried by the special court established under chapter 28 of the Companies Act 2013. So, Lord, we are dealing here with offences under the IBC, and they are to be tried by a court which is established under chapter 28 of the Companies Act. Lord, if your lordship is kind enough to take the Companies Act and, Lord, the establishment of the special courts.
I have a complaint.
The lordship kindly takes chapter 28.
Can you please give me the section?
Section 435.
Yes, 430.
The central government may, for the purpose of providing speedy trial of offences under this act, except under section 452, by notification establish or designate as many special courts as may be necessary, then the constitution of the special court and offences triable by special courts. So, Lord, the proceedings before the NCLT, which ultimately, Lord, culminated in the order of 25th of July 2019, 25th of July 2019, related
to proceedings under the Insolvency and Bankruptcy Code, which entitled Lord initiation of trial for the offences under the IBC before the special courts constituted under the Companies Act 2013 in relation to offences enumerated under the Companies Act 2013 in section 236.
Right.
So Lord, these are special sections, special offences, and Lord, a special trial, special proceedings.
Yes.
Now Lord, please see how they ended. The end is that this proceeding, as also the other proceedings, as my learned friend rightly pointed out, and your lordship was also kind enough to observe, were dependent upon the transaction audit report, the FAR, or the transaction audit report, however we may describe it.
Right.
This does not affect the substratum, but it only says that this by itself and without any other independent material does not prove the preferential undervaluation or the fraudulent transfer. Well, your lordship will find that finding.
Yes, independent documents can be produced to prove the same offences. That is their galore in all the offences.
That is at page 121, paragraph 22. Page 121, paragraph 22. The NCLT's finding is that I hold that there is not enough material to draw inference that the respondents did some transactions which are preferential, undervalued, and fraudulent. No, this is really like, Lord, if I may say so, section 34 of the Evidence Act. Not in section, as your lordship is aware, section 34 of the Evidence Act relates to Lord, relevance of books of accounts. Section 34 says entries in books of accounts are relevant, but by themselves are not enough to charge any person with liability. Likewise, before the NCLT, the question was whether they're enough to prove liability. And the transaction audit report was held that by itself, as a standalone document without anything else to corroborate it, is by itself not sufficient to charge the person with liability. Similar, the proceedings under the IBC read with the Companies Act, insofar as proceedings under the special court are concerned, ended only on the basis that the transaction audit report was not sufficient by itself to prove liability. Then the second proceeding in order of time is the proceedings under the RBI Master Circular. That is with regard to the willful defaulter. Now, the same document is there at page 191.
Culminated with the same observation that
Same
FAR is not
observation.
sufficient. Yes.
That it is not sufficient. Now, Lord, this also says that solely is not sufficient.
Yes.
And this also does not affect the substratum of the audit. It only says we need further corroboration to charge him as a willful defaulter. That proof as a willful defaulter by this is not enough. Now, look, this relates to interpretation of the RBI Master Circular. The RBI Master Circular, 1st of July 2015. This is a proceeding specifically under the RBI Master Circular and to decide whether he is a defaulter within the four corners of the RBI Master Circular.
Yes.
Now, Lord, then we have the third set of proceedings, which is before the Delhi High Court. Now, so far as the Delhi High Court is concerned, that is again same set of facts, but relating to proceedings another under a different set of rules and regulations. This is with regard to the Master Direction on Frauds. Now, it is with regard to the Master Direction of Frauds of 1st of July 2016 that the Delhi High Court was pleased to take up the matter. Now, if your lordship takes page 177, which is the order passed by the Honorable Delhi High Court.
Yes.
If I may say so, Lord, by one of our Calcutta High Court's best exports to Delhi, my Lord Justice Pratik Jalan. His lordship used to practice here, Lord.
Oh, sorry.
For quite a considerable period of time.
Achha. Sorry.
He is junior to Mr. Bhaskar Gupta, late Mr. Bhaskar
Oh,
Gupta.
by face I probably know. Yes. All right.
Lord, please come to Lord, the page 8 of 14. This is page 184.
8 of 14, yes.
These writ petitions were being heard together as they all involve a challenge to the master directions on frauds dated 1st July 2016, issued by the Reserve Bank of India and actions taken by various banks against the petitioners thereunder.
Hmm.
Your Lordship will find the operative portion at page 186, paragraph 6, which has been read out several times to your Lordship, saying that because of natural justice not having been afforded, principles of natural justice, Audi alternate partem, Rajesh Agarwal, therefore, on that ground and that ground alone, the proceedings are held to be bad and set aside. Delhi High Court really does not decide anything at all, so far as the substance of the transaction audit report or the effect of that is concerned. But if I may say so with great respect to my learned friend, the second last sentence of this paragraph does not operate in the reverse. It is made clear that any first information report which has been lodged and proceedings pursuant thereto remain unaffected by this order. It does not necessarily mean that it is made clear that any first information report which has not yet been lodged.
No, definitely not. Definitely not. No.
So, this observation really does.
Chaudhary did not argue that.
Yes,
Chaudhary did not
better sense prevailed today, Mulad. I was told by my junior that there was some emphasis laid on this portion of the
No, Mr.
paragraph.
Chaudhary did not.
Yes, Mulad. Now, Mulad, so far as so, therefore, Mulad, the three proceedings,
yes,
I am not on the lookout circular.
Yes, that is irrelevant.
No, the lookout circular actually has been quite interestingly coined, because it really relates to a line of control, which the
Yes,
banks
line
should
of
or should not cross.
Yes, exactly. That has crossed my mind many a time. I'm being very candid. Because that's so, I mean, it's antithetical to line of control. Yes, you are absolutely right on that.
The person attempting to cross the line of control.
LOC, the moment you say LOC, I mean, that strikes you. I mean, line of control, and that's being.
It's the bank's endeavor to stop the person from crossing the line of control.
That's an extended recovery proceeding now.
Yes.
Yes.
It's really to put pressure. So, the three proceedings,
yes,
which have been argued by before your Lordship, one being the proceedings before the NCLT, the second relating to the proceedings under the RBI Master Circular, declaration of willful defaulter, and the third being the proceedings before the Delhi High Court. None of them have any relation to offences, if any, which the same set of facts may have under the Criminal Procedure Code. And it is possible on the same set of facts to have proceedings under the Criminal Procedure Code, even though under different other statutes, they may be held to have been insufficient or inadequate. That's my first point.
Have you seen the sections cited in the FIR?
Yes, my lord. Sections are very important because the sections are non-compoundable. I'll come to that also, Lord. Because, Lord, this is important, Lord. I'll come to that immediately. So far as the proceedings before the Criminal Procedure Code is concerned, if I may ask myself the question, what have I done? Under Lord Section 154 of the Code of Criminal Procedure, I'm entitled in law to pass on information to the police. I've passed on information to the police. Here in this case, the CBI. The CBI has considered it, and the CBI has found that the ingredients of cognizable offences under the code are made out. And therefore, on the basis of this complaint or an information, they have registered a first information report. And thereafter, they have even appointed an investigating officer. The matter has already started. The clock has started to tick. The procedure under the Criminal Procedure Code has already started. Now, Lord, how does it end, if I may ask myself the question? The IO, the investigating officer, may, upon his inquiry, may come to a finding that no, it was wrongly held that there were cognizable offences made out. No cognizable offences made out. Therefore, I am filing a report that no cognizable offence is made out. or he may file a report in final form under section 173 of the code saying that cognizable offenses are made out, a prima facie case is made out, and a request before the jurisdictional magistrate to frame charges. There's a third step. Even before the magistrate, prior to the magistrate framing charges, it is possible under section 173 subsection 8 for the accused to file what is known as a Narazi petition and to convince the magistrate that no cognizable offenses have been made out. Even otherwise, it is possible for the magistrate to come to a finding without an application on section 173(8) to hold that no, the investigation shows inadequacy in your investigation. No charges have been, the charges which the investigating officer has held to be prima facie proof are not made out. Therefore, I'm directing a reinvestigation. So at this stage, all that the bank has done is that the bank has passed on information. Registration of a first information report is a duty, a statutory duty of the investigating agency in terms of Lalita Kumari's judgment. Lalita Kumari's judgment is very important in this connection because of two reasons. One is that once the information is lodged by the complainant with the police or the investigating agency, the next set of steps are to be taken by the investigating agency alone. And there, my lord, Lalita Kumari says that it is possible, and it is very often found, that the complaint may not disclose everything, but may disclose something which makes it cognizable. And the first information report is also not an encyclopedia of the entire set of offenses. It is possible to carry out further investigation and come to a finding that a cognizable offense is made out. And secondly, Lord, Lalita Kumari also goes into the pros and cons as to would the fact that registration of a FIR is mandatory because a cognizable offense is made out lead to malpractices by way of arrest or unwanted arrest.
But
This
Mr.
aspect is
Shen,
also
probably at the risk of disturbing you, Mr. Chaudhary is highlighting his challenge to the complaint.
Yes,
now
Lord.
he is not going to the extent of the FIR.
Yes, Lord.
Now there's a catch to that in the sense that the moment we speak of the complaint, now we are focusing on the complaint only. Let us not be on the investigation or the FIR. That is a consequence.
Yes, Lord.
As regards the complaint, his only argument is the entire complaint pertains to allegations and refers to allegations, refers to the FIR and the willful default and entire all those proceedings which are no longer there. So if those proceedings are no longer there, the FIR is no longer there, which was the sole premise of the complaint, how can the complaint subsist now?
Two answers to that. One is I don't term it as a complaint, I term it as an information, because this is an information in terms of section 154. The written document, which is the document of 18th of June 2021, which is the in-tune document.
Let us look into 154.1.
Yes, my lord. Every information relating to the commission of a cognizable offense, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant. And every information, whether given in writing or reduced to writing as aforesaid. So this is an information and nothing more than information. I have given an information. I have given an information saying that in my understanding, in view of these set of facts, cognizable offenses under the Code of Criminal Procedure have been found or are to be found.
Right.
That's all that I have done. And as I've submitted for your lordship's consideration, the same set of facts can lead to different consequences and different conclusions under different statutes. So merely because the willful defaulters committee has held that it is insufficient or by itself as a standalone document is not enough for him to be classified as a willful defaulter under the RBI master circular, and the NCLT has held likewise that the proceedings under the special code, under the IBC code is not made out on this alone, it does not mean that ultimately after investigation by the police, cognizable offenses under these provisions of the code will not be made out.
You may say that the petitioner has never been exonerated
Never.
on the main offenses, the substratum as you are arguing.
Yes, sir.
Those allegations, they have not been exonerated finally. Only the documents have been disbelieved or have been held to be insufficient.
Inadequate.
Inadequate, whatever.
Inadequate to charge him with liability under those statutes.
So therefore, the substratum, as you say, put it quite rightly, I mean, the complaint remains.
Lord, the complaint remains and Lord, as Lalita Kumari says, the complaint may be the tip of the iceberg.
Yes, yes.
During investigation on these set of facts, the investigating agencies may find out further evidence to ensure come to a finding that case is made out under those sections.
Yes.
So today it would be premature to say that these set of facts, which of course are the facts which are also pleaded there, are not enough to charge him with liability, are not enough to ultimately charge him with liability.
So his offenses have not been proved, but not disproved.
Not disproved.
Not
And
proved
today,
and disproved.
today I'm only indicating to him, to the investigating officer, some facts or some events which according to us make out cognizable offenses within the code of criminal procedure. Investigating agencies and the officers will investigate further and find out further pieces of evidence.
Alright.
And ultimately come to a finding which will result in a final report under section 173. Number, if your lordship please comes to the first information report, the lordship will find the sections which are mentioned, which your lordship was indicating to me.
Yes.
At the top, your lordship will find the box. The first is section 120B, which is criminal conspiracy. Then 409, which is criminal breach of trust.
Yes.
Then 420, which is cheating and dishonestly inducing delivery of property. Then is 477 capital A, which is falsification of accounts. Now, the last one is under the Prevention of Corruption Act, but this relates to public servants. Why this is important is because here action has been taken against banks employees also.
All right.
Now, Lord, please see thereafter the place of occurrence. Now, this is very important. This is a part of my argument. Not that I'm letting it go, but I'm making the submission for your lordship's consideration. The first information report was lodged by the Punjab National Bank, Bhubaneswar, Orissa, sir. Then, Lord, please turns the page. Paragraph 8 was what was read by Mr. Chaudhary. I'm not repeating it. The reasons for the delay, it is really not material for our consideration today, except that the CBI chose to give this explanation. Whether it is correct or not correct, I as the de facto complainant have nothing to do with this. Now, Lord, please turn the pages over and Lord, please come to page 202. Paragraph 13. At the bottom of the page, Lord.
Yes.
Action taken since the above information reveals commission of offences under sections as mentioned in item number 2. Registered the case and took up the investigation. Yes, the wheels have been set in motion. Name of the investigating officer is also mentioned there. His rank is also mentioned there. So, unless it is a compoundable offense, which it is not in terms of section 320 of the Code of Criminal Procedure, I as the de facto complainant cannot withdraw this information.
The complaint has lost relevance in a sense. I mean, after it crystallized into an FIR.
The complainant and the complaint, we have now receded into the background. Now, the FIR is the plaint. And the FIR will be investigated by the investigating officers. So, to say today that kindly set aside the information given by us on 18th of June 2021, perhaps, is a prayer which cannot be made today. Because that has merged, if I may use this expression, with the first information report and has lost its independent identity.
Yes.
Now, my lord, it is, when your lordship is now sitting in 226, to my lord, decide whether your lordship in 226 will interfere at this stage, I will like to show Lalita Kumari, but also what is important in my respectful submission for your lordship to consider are, my lord, the tests laid down in Bhajan Lal. Because Bhajan Lal is not only concerned with 482, but also with 226. And there your lordship will only read the FIR. And from a bare reading of the FIR, lordship will only want to satisfy your lordship whether the slightest iota of any cognizable offense is made out, taking the FIR as correct, just like Order 7 Rule 11.
Yes.
And if on the reading of the FIR, it appears that yes, cognizable offenses are made out, that is the end of the matter. Both 482 and 226. Not? Of course, now 226 has been expanded thanks to Mr. Goswami, Mr. Arnab Goswami, with regard to bails, etc. We have an over-expanding horizon of 226. But principally, Bhajan Lal is the traditional test that we would like to assist your lordship.
This was the comment of the day.